Hello everyone, in this video we will discuss MCQs of Indian Evidence Act. These MCQs will be more than 1000. So let's get started from the question number 1. As per section 1 of Indian Evidence Act came into force on, here correct answer is option B, that is September 1, 1872. Indian Evidence Act came into force on September 1, 1872. Question number 2. As per the preamble of the Indian Evidence Act 1872, the purpose of this act is to consolidate, define and amend the law of evidence. Therefore, option D is the right answer. Question number 3. The Indian Evidence Act 1872 has been divided into dash parts and dash chapters. Here correct answer is option B, that is 3 parts and 11 chapters. Question number 4. How many sections and chapters are there in Indian Evidence Act? Correct answer is option A, 167 sections and 11 chapters, divided into 3 parts and 11 chapters. Question number 5. The Indian Evidence Act applies to option A, the whole of India excluding the state of Jammu and Kashmir, option B, all judicial proceedings in or before any court, and option C, all proceedings before an arbitrator, option D, affidavits presented in any court or officer. Here correct answer is option B, all judicial proceedings in or before any court. Question number 6. The Indian Evidence Act is applicable to Jammu and Kashmir and Nagaland, Jammu and Kashmir, Nagaland and scheduled tribal areas, all of the above. Correct answer is option D. Question number 7. Under section 1 of the Indian Evidence Act, the proceedings which are specifically excluded from the operation of the Indian Evidence Act. Option A, proceedings before industrial tribunals, proceedings before arbitrators, proceedings before administrative tribunals. D, none of the above. Here correct answer is option B, proceedings before arbitrators. Question number 8. The Indian Evidence Act does not apply to the proceedings before the arbitrator, affidavit submitted by the dependent on his own, option C, statement made by a child, and option 4, statement of a person whose past is criminal. Here correct answer is option C. Option 1 and option 2 are correct. Indian Evidence Act does not apply to proceedings before the arbitrator and affidavit submitted by the deponent of his own. Question number 9. Which of the following statement is correct? The Indian Evidence Act applies to affidavits. The Indian Evidence Act applies to a proceedings whose object is to determine a jural relation between one person to another. Indian Evidence Act applies to arbitration proceedings. The Indian Evidence Act applies to departmental proceedings. Here it has been asked which of the following statement is correct. Option B is correct because Indian Evidence Act applies to proceedings whose object is to determine a jural relation between one person and another. Question number 10. Select the incorrect statement using the codes given below. Statement first, the Indian Evidence Act does not apply to arbitration proceedings. Option second, the Indian Evidence Act does not apply to the proceedings before a commissioner appointed by the Court of Recording Evidence. Option 3, the Indian Evidence Act applies to affidavits presented to courts. And option 4, statement 4, the Indian Evidence Act applies to judicial proceedings held before all kinds of military courts. Here, correct answer is only option 1, that is Indian Evidence Act does not apply to arbitration proceedings. Second, third and fourth statement are not correct. Therefore, correct answer will be option B. 2, 3 and 4 are incorrect. Question number 11. The Indian Evidence Act was drafted by option A, Lord Macaulay, option B, Sir James Stephen, and option C, Huxley, and option D, Sir Henry Summer Mine. Here the correct answer is option B, that is Sir James F. Stephen. Indian Evidence Act was drafted by Sir James F. Stephen. Question number 12. Any such fact which possesses probative fact is called evidence. This definition is belonged to Salmon. Question number 13. The maxim false in omnibus means. Correct answer is option B. If a thing is false in respect of one, it must be taken to be false in respect of all. Question number 14. The maxim falus in uno, falus in omnibus is option A, a sound rule of evidence, option B, a sound rule of law, option C, both A and B, and option D, none of the above. Here correct answer is option B, that is a sound rule of law. Question number 15. Principle of falus in uno, facilus in omnibus is option A, rule of law, option B, rule of caution, option C, not applicable in India, option D, both rule of caution and non-applicable to India. Here correct answer is option D, both rule of caution and not applicable in India. Question number 16. Point out the correct answer. Law of evidence is lex talens, lex fori, lex loci, lex citus. Here correct answer is option B, lex fori. Lex fori means law of forum. Question number 17. The Indian Evidence Act 1872 is not exhaustive. Many rules relating to law of evidence are contained in option A, CPC, option B, TPA, option C, Indian Succession Act, and option D, all of the above. Correct answer is option D, all of the above. Question number 18. To which of the following does the Indian Evidence Act apply? Option A, affidavits. Option B, non-judicial proceedings. Option C, arbitration proceedings. And option D, judicial proceedings. Correct answer is option D, Indian Evidence Act applies to judicial proceedings. Question number 19. The Indian Evidence Act 1872 applies to administrative tribunals proceedings, arbitrators proceedings, contempt proceedings, none of the above. Here correct answer is option D, that is none. Question number 20. Section 2 of the Indian Evidence Act was repealed by. Section 2 was repealed by Repealing Act of 1938. Question number 21. Which word has not been defined under Section 3 of Evidence Act? Option A, confession. Option B, court. C, fact. D, document. Correct answer is option A. Confession is not defined in Indian Evidence Act. Question number 22. The affidavit given to the court is not an evidence, merely a written statement, a proof. Correct option is option B. Affidavit given in the court is an evidence. Question number 23. Indian Evidence Act applies to civil proceedings only, criminal proceedings only, both the civil and criminal proceedings, none of the above. Correct answer is option C, both civil and criminal proceedings. Question number 24. The law of evidence under the Indian Evidence Act 1872 is substantive law, procedural law, substantive and procedural law, none of the above. Correct answer is option B, that is procedural law. Question number 25. The law of evidence consists of which one of the following? Option A, ordinary rules of reasoning. Option B, legal rules of evidence. Option C, rules of logic. And option D, all of the above. Here correct answer is option B, that is legal rules of evidence. Question number 26. Which one of the following term has not been defined by the Indian Evidence Act in section 3? Option A, court. Option B, document. Option C, evidence. And option D, confession. Correct answer is confession. Question number 27. Which one of the following is not defined in section 3 of Indian Evidence Act? Court, document, evidence, confession. Here correct answer is option D. Confession is not defined in section 3 of Indian Evidence Act. Question number 28. Which one of the following is not included in expression court under the Indian Evidence Act? Option A, all judges. Option B, all persons legally authorized to take evidence. Option C, all magistrate. And option D, arbitrators. Arbitrators are not included in expression court under the Indian Evidence Act. Court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. Therefore, here it is been asked which of the following is not included. Arbitrators are not included will be the right answer. Question number 29. In the Indian Evidence Act, the expression court means all judges, all magistrates, all persons except arbitrators legally authorized to take evidence, all of the above. Here correct answer is option C. All persons except arbitrators legally authorized to take evidence. Question number 30. The term court as defined in the Indian Evidence Act does not include. Option A, presiding officer of a labor court, tehsildar, arbitrator, commissioner appointed by a civil court. Correct answer is option C. Arbitrator is not included in the definition of court. Presiding officer at labor court will be considered, tehsildar will be considered, and also commissioner will be considered. Question number 31. Which one of the following is not included within the definition of the term court under the Indian Evidence Act? All judges, all magistrate, all consumer forums, all persons legally authorized to take evidence. Here correct answer is option C. All consumer forums are not included within the definition of the term of court under the Indian Evidence Act. Question number 32. In relation to the expression defined in section 3 of Indian Evidence Act, which of the following statement is not correct? Option A, facts includes any mental condition of which any person is conscious. Option B, courts includes arbitrator. Option C, an inscription on a mental plate in a document. And option D, a fact is said to be not proved when it is neither proved nor disproved. Here correct answer is option B. Courts includes arbitrators. Question number 33. In relation to the expression defined in section 3 of Indian Evidence Act, which of the following statement is not correct? Option A, facts includes not only physical fact but also psychological facts. Courts includes arbitrator. This statement is not correct, therefore B will be the right answer. Question number 34. Facts can be physical facts, psychological facts, physical as well as psychological facts. And option D, only physical facts and not psychological fact. Here correct answer is option C. Facts can be physical as well as psychological facts. Question number 35. In the law of evidence, fact means and includes option A, anything perceived by the senses. Option B, state of things capable of being perceived by the senses. And option C, mental condition of which a person is conscious. And option D, all of the above. Here correct answer is option D, all of the above. In law of evidence, facts means and includes anything perceived by the senses, state of things capable of being perceived by the senses, and mental conditions of a person of which a person is conscious. Question number 36. A fact under section 3 of Indian Evidence Act means and includes anything capable of being perceived by the senses, state of things capable of being perceived by the senses, relation of things capable of being perceived by the senses. Option D is the correct answer. Question number 37. Under Indian Evidence Act, fact means option A, factum probandum, option B, factum probans, Option C, both A and B, and option D, none of the above. Here correct answer is option C, that is both A and B, factum probandum and factum probans. Question number 38. Which one of the following is a fact? Hari said, Mohan saw, Ram told a lie. All of these. Correct answer is option D, all of these. Question number 39. Which of the following is a fact? That there are certain objects arranged in a certain place. Option B, that a man heard or saw something. Option C, that the man said certain words. And option D, all of these. Here correct answer is option D, all of the above. Question number 40. There are certain objects arranged in a certain order in a certain place is a fact. Question number 41. Which of the following pairs is not correctly matched? That a man heard or said something is a fact. A map or plan document. Copies made from or compared with original evidence. Fact connected to a fact in issue in such a manner as to constitute part of the same transaction. Rule Nisi. This is not correct. This is res gestae. So 41 not correctly matched is option D. Question number 42. Facts under the Evidence Act means anything capable of being perceived by the senses only, anything not being capable of perceiving by the senses only. Option C, any mental condition of which any person is conscious, and option D, anything capable of being perceived by the senses and any mental condition of which any person is conscious. Under Evidence Act, facts means anything capable of being perceived by the senses and any mental condition of which any person is conscious. Option D is the correct answer. Question number 43. Whether a weapon is a deadly weapon is a question of option A, law, option B, fact, option C, opinion of the expert witness, option D, opinion of the judge. Correct answer is option B, that is fact. Question number 44. Which of the following is not a fact? Option A, mental condition, option B, relation of things, option C, state of things, and option D, none of the above. Correct answer is option D, none of these. Question number 45. The fact sought to be proved is called factum probandum. Option B is the correct answer. Question number 46. Which of the following qualities to be treated as fact within the meaning assigned to it under the Indian Evidence Act? That a man heard or saw something, that a man holds a certain opinion, that a man acts in good faith, all of these. Here correct answer is option D, all of these. Question number 47. Which one of the following is a fact? Sohan saw a cow, Mohan said Sohan to go, Sheetal has a high reputation, all of these. Here correct answer is option D, all of these. Question number 48. A reputation of a person is a fact, a subject, an opinion, and evidence. A reputation of person is a fact. Option A is the right answer. Question number 49. A witness described in detail the articles decorated in the room while giving statement before the court. This is a option A, fact, option B, opinion, option C, document, and option D, cause. Here correct answer is option A, fact. Question number 50. Anything, state of things or relation of things capable of being perceived by the senses is option B, fact. Correct answer is option B. Question number 51. Which of the following is required to be proved essentially? Option A, judicial notice, option B, admitted fact, option C, confession, and option D, relevant fact. Here correct answer is option D, relevant fact. Question number 52. The material facts on which a party relies are called factum probantia, facta probanda, falsa demonstration on nocet, facias terroria. Here correct answer is option B, facta probanda. The material facts on which a party relies are called facta probanda. Question number 53. Fact in issue means facts existence or non-existence of which is admitted by the parties, facts existence or non-existence of which is disputed by the parties, and option C, facts existence or non-existence of which is not disputed by the parties. In question number 53, correct answer is option B, facts existence or non-existence of which is disputed by the parties is fact in issue. Question number 54, fact in issue means the fact, the existence or non-existence of which is admitted by the parties, disputed by the parties, non-disputed by the parties, none of the above. Here correct answer is option B, disputed by the parties. Question number 55. Which of the following statement is not a fact in issue under Evidence Act? The existence of any right which is asserted or denied by the parties, the existence of any disability asserted or denied by the parties, the existence of a right admitted by the parties. Select the correct answer by using the codes given below. 1, 2, 3, none of these. In question number 55, correct answer is option C, that is third. Here it is been asked, not a fact and issue under Evidence Act. Third statement is not a fact and issue. Option 1 and 2, the existence of any right which is asserted or denied by the parties, the existence of any disability asserted or denied by the parties are related to fact and issue. Question number 56. A is tried for the murder of B by beating with a club with the intention of causing death. At A's trial, which one of the following is not fact and issue? A is beating B with the club, A's conversation with C, A is causing death with the club, A's intention to cause B's death. Here correct answer is option B. A's conversation with C is not fact and issue, other options are fact and issue. Question number 57. A is tried for the murder of B for intentionally beating him with a club causing the death. Which of the following are fact and issue? Option A is beating with club. Option B, A is causing B's death by such beating. Option C, A's intention to cause B's death. And option D, all of the above. Here correct answer is option D, that is all of the above. Question number 58. Fact alleged by one party and denied by the other in a case are termed as fact and issue. Question number 59. Making the fact and issue is, it is the duty of the parties, it is the duty of the advocate of parties, it is the duty of the court, it is the duty of the government counsel. Here the correct answer is option C, that is it is the duty of court. Making a fact and issue is the duty of the court. Question number 60. Document produced for the inspection of the court includes a written document, a caricature, an electronic record, and inscription on a stone. Select the correct answer by using the quotes given below. Here correct answer is option C, 1, 2, 3 and 4. Question number 61. The documents are caricature, words printed, lithographed or photographed, a map and an inscription on a stone, all of the above. Here correct answer is option D, all of the above. Question number 62. An inscription on a metal plate or stone is a fact, is a document, is an opinion, is a motive. Here correct answer is option B, is a document. Question number 63. Electronic records were included in section 3 of the Indian Evidence Act with effect from. Option A 17 October 2000, option D 10 October 2000, option C 2 October 2000 and option D 14 November 2000. Here correct answer is option A, that is 17 October 2000. Electronic records were included in the section 3 of Evidence Act. Question number 64. Electronic records produced before the court are oral evidence, documentary evidence, ordinary evidence, technical evidence. Correct answer is option B, that is documentary evidence. Electronic records produced before the court are documentary evidence. Question number 65. Which one of the following has not been mentioned in the definition of documents as the means by which a matter is expressed or described upon any substance? Option A letters, option B figures, and option C symbols, and option D mark. Here symbols is the correct answer. Symbol are not included in the definition of documents. Question number 66. Which one of the following does not come within the meaning of document under the Indian Evidence Act? Option A writing, B a map, C a telephonic talk, and option D a word photograph. Here correct answer is option C, a telephonic talk will not come under the meaning of document. Question number 67. Evidence means and includes ocular evidence only, documentary evidence only, ocular and documentary evidence both, ocular evidence based on documents only. Correct answer is option C, both oral and documentary evidence. Question number 68. Which one of the following statements are correct? Evidence under the Evidence Act means and includes oral evidence, all documents except electronic records, all documents including electronic records. Select the correct answer by using the quotes given below. 1, 2 and 3, 1 and only, 2 and 3, 1 and 3 only. Here correct answer is option D, that is 1 and 3 only. Oral evidence and all documents including electronic records. Question number 69. Circumstantial evidence is direct evidence, indirect evidence, neither A or B, material evidence. Correct answer is option B. Circumstantial evidence are indirect evidence. Question number 70. A is an accused of child's murder. The following facts are constructed in the case. An hour before the murder, A went to the place of a murder with the child. A alone returned home. Collar of A's shirt found to be blood-stained. The evidence of which takes into account the above mentioned facts is called direct evidence, circumstantial evidence, real evidence, secondary evidence. Here correct answer is option B, that is circumstantial evidence. Question number 71. In reference to the circumstantial evidence, the circumstances from which the conclusion is drawn should be fully established. Statement second, the circumstances should be conclusive in nature. Statement third, all facts so established should be consistent only with the hypothesis of guilt and inconsistent with innocence. Now, statement 4, the circumstances should, to a moral certainty, exclude the possibility of guilt of any person other than the accused. Select the correct answer by using the quotes given below. In question number 71, correct answer is option C, 1, 2 and 3. First, second and third will refer to the circumstantial evidence. Question number 72. An Evidence Act does not expressly mention about oral evidence, documentary evidence, secondary evidence, circumstantial evidence. Here correct answer is option D, that is circumstantial evidence. Question number 73. With respect to proof of circumstantial evidence under the Indian Evidence Act, which of the following proposition or expression is incorrect? Option A, that the circumstances from which guilt is established must be fully proved. Option B, that all facts must be consistent with the hypothesis of guilt or innocence of the accused. Option C, that the circumstances must be of conclusive in nature. And option D, that the circumstances should to a moral certainty exclude every hypothesis except the one proposal to be proved. Here correct answer is option B. This is not correct. Therefore, this will be the right answer, because in the question it has been asked which of the following proposition or expression is incorrect. Question number 74. Circumstantial evidence must satisfy the following test. The circumstances from which an inference of guilt is to be drawn must be cogently and firmly established. Those circumstances should be of definite tendency, unerringly pointing towards the guilt of the accused. Statement second, the circumstances taken collectively should form a chain of so complete that there is no escape from the conclusion that within all human probability the crime was committed by the accused. And D, all of the above. Here correct answer is option D, all of the above. Question number 75. In which decision the 5 golden principle punch shield about the circumstantial evidence has been laid down? Option A is the correct answer. Sharad Birdhichand Sharda versus State of Maharashtra, AIR 1984, is the decision related to the 5 golden principle about the circumstantial evidence. Question number 76. An evidence sought through unfair means is not admissible, admissible if relevant, admissible only at the discretion of the court, not valid. Correct answer is option B, admissible if relevant. Question number 77. Which of the following is relevant and may received in evidence? Option A, tape recordings. Option B, dog tracking. Option C, narco-analysis test. And option D, all of the above. Correct answer is option D, all of the above. Question number 78. What is oral evidence? Statement made before court is oral evidence. Question number 79. Which one of the following is not considered as evidence? Affidavit, statement of witness, electronic record produced before court, document produced before court. Here correct answer is affidavit. Affidavit is not considered as evidence. Question number 80. The evidence unearthed by sniffer dogs falls under the category of scientific evidence. Option D is the correct answer. Question number 81. Under the Indian Evidence Act, the evidence given by dog squad is admissible. Question number 82. Under the Indian Evidence Act 1872, what is not evidence in the following? Option A, personal knowledge or observation of a judge about the case during hearing. This is not evidence. Option A will be the right answer here, whereas statement of dumb witness is oral evidence. State documents produced by the inspection of the court is also evidence, and electronic CD is also evidence, but option A will not fall under the category of evidence. Therefore, option A here will be the right answer. Question number 83. In which year the electronic evidence was incorporated in the Indian Evidence Act as a part of documentary evidence? Here correct answers are option C, that is 2000. Question number 84. Tape recorded statements are documentary evidence. Correct answer is option A, documentary evidence. Question number 85. Proof is the result of inquiry, evidence, investigation, statement. Correct answer is option B. Proof is the result of evidence. Question number 86. A fact is said to be proved if its existence is so probable that a prudent man would accept it as existing. Option D is the correct answer. Question number 87. A fact is said to be not proved when it is neither proved nor disproved. Here also option D is the correct answer. Question number 88. Section 4 of the Indian Evidence Act deals with the expression may presume, shall presume, conclusive proof, all of the above. Correct answer is option D, all of the above. May presume, shall presume, and conclusive proof. Question number 89. When one fact is declared by the Indian Evidence Act to be conclusive proof of another, the court on proof of one fact shall not allow evidence to be given for the purpose of disproving it. Option A is the correct answer. Question number 90. Under Indian Evidence Act, a court has no discretion regarding proof of a fact in the context of may presume, shall presume, conclusive proof, judicial notice. Here correct answer is option C, that is conclusive proof. Question number 91. Whenever it is directed by the Indian Evidence Act that the court shall presume a fact, it shall regard that such fact as proved unless it is disproved. Option A is the right answer. Question number 92. Whenever it is provided in the Indian Evidence Act that the court may presume a fact, may call for proof of the fact, the court is bound to regard that a fact as proved. The parties can presume the fact as proved. The fact is conclusive proof. Here correct answer is option A, may call for proof of the fact. Question number 93. A fact is a fact if conclusive proof of another fact. If that fact is proved, then Option A, then the court can call upon the party to prove another fact. Option B, the court can allow opposite party to adduce the evidence to disprove another fact. Option C, both A and B. And option D, the court shall regard the another fact as proved. Here correct answer is option D, the court shall regard another fact as proved. Question number 94. Which of the following section of Indian Evidence Act deals with conclusive proof? Options are section 41, 112 and 113. Option B, section 112. Option C, section 113. And option D, section 112 and 113. Correct answer is option A, section 41, 112 and 113. Question number 95. What is shall presume in regard to a fact? Option A, final proof. Option B, court may presume that a fact is proved. Option C, court shall presume that a fact is proved unless it is disproved. And option D, none of the above. Correct answer is option C, the court shall presume that a fact is proved unless it is disproved. Question number 96. The Indian Evidence Act deals with presumptio juris only, presumptio humanis only, both A and B, none of the above. Correct answer is option C, both A and B. Presumptio juris and presumptio humanis. Indian Evidence Act deals with the both. Question number 97. Presumption of fact under the Indian Evidence Act 1872 is based on logic, human experience and natural events and law of nature. Option B is based on the provisions of law. Option C cannot be ignored by the court. And option D is of certain and uniform position. Here correct answer is option A. Presumption of fact under the Indian Evidence Act is based on logic, human experience and natural events of law and nature. Question number 98. Non-explanation of injuries on the person of the accused by the prosecution witness is always fatal to the prosecution case, is never fatal to the prosecution, may affect the prosecution case provided serious injuries are suffered in same occurrence, none of the above. Correct answer is option C, may affect the prosecution case provided serious injuries are suffered in the same occurrences. Question number 99. Only such facts are made relevant by the Evidence Act as are encompassed by section 5 to section 55 of Evidence Act, section 5 to section 32 of Evidence Act, all the sections of the Evidence Act, only such facts which can be proved as per section 59 and section 60 of the Evidence Act. Here correct answer is option A, that is section 5 to section 55 of the Evidence Act. Question number 100. Which one of the following section of Indian Evidence Acts provides that evidence may be given of facts and issue and relevant facts? Here correct answer is option C, that is section 5. Question number 101. Under the law of evidence, the relevant fact must be logically relevant, must be legally relevant, must be legally and logically relevant, must be legally and logically relevant and admissible. Here correct answer is option B. Under the law of evidence, the relevant fact must be legally relevant. Question number 102. Under Indian Evidence Act, evidence may be given in respect of fact and issue, relevant fact only, fact and issue and relevant fact, none of these. Here correct answer is option C, that is fact and issue and relevant fact. Question number 103. Relevancy is option A, question of law and can be raised at any time. This is the correct answer. Relevancy is question of law and can be raised at any time. Question number 104. Which one of the following statements is not true? According to section 5 of Evidence Act, evidence may be given in any suit or proceeding of the existence of every fact and issue, non-existence of every fact and issue, those facts declared relevant under the various provisions of the Evidence Act, those facts which the parties think are relevant. In question number 104, option D is not correct, therefore will be the right answer. Question number 105. Which of the following is required to be proved essentially? Judicial notice, admitted fact, confession, relevant fact. Here correct answer is option D, relevant fact. Question number 106. Facts which though not an issue are so connected with the fact and issue as to form part of the same transaction are relevant under which section of the Indian Evidence Act? Relevant under section 6 of Indian Evidence Act. Correct answer is section 6. Question number 107. Under which one of the following section of the Indian Evidence Act the doctrine of res gestae has been dealt with? Doctrine of res gestae has been dealt in section 6 of Indian Evidence Act. Question number 108. The principle of dash is embodied in section 6 of the Evidence Act. Correct answer is option B, that is res gestae. Question number 109. Section 6 of the Evidence Act deals with option A, relevancy of fact forming the part of the same transaction, admission, opinion of expert, conclusive proof. Correct answer is option A. Section 6 of the Indian Evidence Act dealt with relevancy of fact forming the part of the same transaction. Question number 110. Res gestae literally means. Correct answer is option C, that is same transaction. Question number 111. Fact forming the part of the same transaction are option A, plea of alibi, option B, dying declaration, option C, admission, and option D, res gestae. Here correct answer is option D, res gestae. Question number 112. The criteria of res gestae is A, proximity of time and place, B, community of purpose, C, continuity of action, and D, all of the above. Here correct answer is option D, that is all of the above. Question number 113. The term res gestae is equivalent to the facts mentioned in section 6 of Evidence Act. It implies things done in the course of transaction, facts in issue and surrounding circumstances, act talking for themselves, all of the above. Correct answer is option D, all of the above. Question number 114. The case of Sawal Das versus State of Bihar is related to. Correct answer is rule of res gestae. Question number 115. Under which one of the following provisions of Indian Evidence Act the words forming part of the same transaction occurs? Here correct answer is option B, that is section 6. Question number 116. The facts which form the part of the same transaction are relevant under section 6 of the Evidence Act. Question number 117. In order to make the evidence admissible as a part of res gestae, option A, the statement must have been made immediately after the act. Option B, the statement must have been made contemporaneously with the act, and option C, the statement must have been made with any time after the act. Option D, either A or B. Here correct answer is option D, that is either A or B. The statement must have been made immediately after the act. The statement must have been made contemporaneously with the act. Question number 118. In a case of murder by A or B, which facts are relevant? That A left immediately the place of crime before police reached. B, that A told his friends about taking revenge for his father's death. C, that A was seen flying with a knife immediately after murder of B, and option D, all of the above. Here correct answer is option D, that is all of the above. Question number 119. Facts which, though not an issue, are so connected with a fact and issue as to form part of the same transaction, whether they occurred at the same time or place or at different times and place, are relevant, are irrelevant, are partly relevant, none of these. Here correct answer is option B, that is are relevant. Question number 120. A is accused of waging war against the government of India by taking part in an armed insurrections in which property is destroyed, troops are attacked, and goals are broken open. A is not present at all of them, yet the occurrence of these facts is relevant because they constitute a motive for the relevant fact, they show the preparation for relevant fact, they are effect of relevant facts, they form the part of the single transaction. Correct answer is option D, that is they form the part of the single transaction. Question number 121. Which one of the following statement is correct? A struck B on the neck with a knife, and this was seen by C, who exclaimed, A is killing B. C exclamation is relevant because it was spontaneous, relevant because it forms a part of the transaction, relevant because it is relatable to the transaction, relevant because it is a fact and issue. Here correct answer is option B, relevant because it forms a part of the transaction. Question number 122. A fact is relevant if it is mentioned in the pleadings, if it is mentioned in the document relied by any of the parties, if it is connected with the fact and issue so as to form the part of the transaction. Option D, all of the above. Here correct answer is option C. A fact is relevant if it is connected to the fact and issue so as to form the part of the same transaction. Question number 123. R.M. Malkani versus State of Maharashtra is related to which of the following? This case is related to relevancy of fact forming the part of the same transaction. Option A is the correct answer. Question number 124. Under Indian Evidence Act 1872, the rule of res gestae is applicable in civil cases only, criminal cases only, civil as well as criminal cases. Option D, not applicable in any case. Here correct answer is option C, civil as well as criminal cases. Question number 125. The English doctrine of res gestae has no place in India, has place in India, and has been incorporated under section 6 of the Indian Evidence Act 1872, has been incorporated under section 7 of the Evidence Act 1872. Here correct answer is option C. The English doctrine res gestae has place in India and has been incorporated in section 6 of the Indian Evidence Act 1872. Question number 126. Res gestae is an exception of the option A, hearsay rule, B, relevancy rule, C, circumstantial evidence, D, none of these. Here correct answer is option A, that is hearsay rule. Res gestae is an exception to the hearsay rule. Question number 127. A is accused of the murder of B by beating him. What is not admissible as evidence? Option A, whatever was said by A or B or by standards at the time of beating. A has intention for murder of B. A marks on the ground of struggle between A and B. A is a man of bad character. Here correct answer is option D. A is a man of bad character is not be admissible as evidence. Question number 128. In which of the following cases hearsay evidence is not admissible? Option A, statement of experts expressed in treaties if the author is dead or cannot be found. Where eyewitnesses told the facts to another person, statement of that person. If the statement of a deceased person when it relates to cause of his death. If the statement is part of the transaction in issue. Here correct answer is option B. Where eyewitnesses told the facts to another person, statement of that person. Question number 129. Choose the true statements about the propositions. Section 6 prescribes rule of relevancy of an evidence which is a part of same transaction. Proximity of time, place and continuity of action are suggestive of part of the same transaction. Psychological acts may also form the part of the same transaction. Assertions. First and second are correct, third is incorrect. Second and third are incorrect, first is correct. First and third are correct and second is incorrect. All are correct. Here correct answer is option D, that is all the statements are correct. Question number 130. Section 7 of the Evidence Act does not include which one of the following? Occasion, cause, purpose, effect. Correct answer is option C, that is purpose. Question number 131. Which one of the following statement is correct? In a trial of A for the murder of B, marks on the ground produced by a struggle at or near the place of a murder is a fact. Option A, forming part of the same transaction. Option B, necessary to explain or introduce relevant fact. Option C, showing existence of a state of mind or of body. Option D, as to the occasion, cause or effect of fact and issue. Here correct answer is option D, as to the occasion, cause or effect of fact and issue. Question number 132. Footprints of accused is admissible under dash of Indian Evidence Act. Section is section 7. Footprints of accused is admissible under section 7 of Indian Evidence Act. Question number 133. The question is whether A murdered B during the course of a struggle. Marks on the ground produced by the struggle at the place of occurrence is a relevant fact under which of the following sections of Indian Evidence Act? Here correct answer is option B, that is section 7. Question number 134. Motive, preparation and previous or subsequent conduct is covered under section dash of Indian Evidence Act. Correct answer is section 8. Question number 135. Which one of the following is not inclusive in section 8 of the Indian Evidence Act for relevancy? Options are option A, intention, B, motive, C, preparation, D, conduct. Here correct answer is option A, intention. Intention is not conclusive in section 8 of the Indian Evidence Act. Question number 136. Any fact constituting a motive or preparation for any fact in issue is option A, is a relevant fact, B, not a relevant fact, C, is a relevant fact if it forms a part of the same transaction, D, none of the above. Here correct answer is option A, that is a relevant fact. Question number 137. A is tried for murder of B by administering potassium cyanide. The fact that A has purchased potassium cyanide just before the murder of B is relevant under section 8 of Indian Evidence Act. Question number 138. Under which section of Indian Evidence Act the conduct of the accused is relevant? Here correct answer is option B, that is section 8. Question number 139. The conduct to be relevant under section 8 of the Indian Evidence Act, it option A, must be previous. Option B, must be subsequent. C, may be either previous or subsequent. D, none of the above. Here correct answer is option C, may be either previous or subsequent. The conduct to be relevant under section 8 of the Indian Evidence Act, it may be either previous or subsequent. Question number 140. Queen versus Abdullah case is related to. Correct answer is option A, that is conduct. Question number 141. The question is whether A was ravished and thereafter murdered. The fact that without making a complaint, she said that she had been ravished. Option A is irrelevant as a conduct, is relevant as substantive evidence, is relevant as a secondary evidence, may be relevant under section 32 clause 1 or section 157 of the Evidence Act. Option D is the correct answer. Question number 142. Which of the following would not be relevant in the evidence under section 8 of Indian Evidence Act? Option A, evidence of the existence of a motive for the crime charge, evidence of the statement which accompanies some conduct. Option C, evidence of the statement which influences and affects the conduct of a person whose conduct otherwise relevant. Option D, evidence of a statement of the act of robbery without making any complaint. Here correct answer is option D. It will not be relevant. Evidence of a statement of act of robbery without making any complaint is not relevant. Question number 143. X is prosecuted for the murder of Y. During trial, the evidence is adduced that X and Y had verbal altercation in which accused X had threatened to kill Y. The fact that soon after the threatening statement X had purchased the same knife which was used to stab Y is admissible under dash of Evidence Act. Here correct answer is option C, that is section 8 of the Evidence Act. Question number 144. A is accused of B's murder. Which of the following will be a relevant fact? Option A is going to the field with a club. Option B, A is saying shortly before the incident that he will take revenge of his father's death. Option C, A is fleeing before the police arrived at a village. And option D, all of the above. Here correct answer is option D, all of the above. Question number 145. To what facts of the following rules or relevancy has been discussed under section 8 of the Indian Evidence Act? Motive, preparation, previous or subsequent condition, conduct, all of the above. Correct answer is option D, that is all of the above. Question number 146. Under Indian Evidence Act, motive becomes more relevant in a case based on option A, direct evidence, B, circumstantial evidence, C, documentary evidence, D, without any evidence. Correct answer is option B, that is circumstantial evidence. Under the Indian Evidence Act 1872, motive becomes more relevant in a case based on circumstantial evidence. Question number 147. Which of the following statement is true? A is tried for the murder of B. There is evidence of the fact that B prosecuted A for libel and that A was convicted and sentenced. This judgment is conclusive proof of the murder of B by A as it is a judgment in rem. Option B, relevant but not conclusive proof as it relates to the matters of public nature relevant to the inquiry. Option C, relevant as the existence of such judgment is a fact and issue. Option D, relevant under section 8 as showing the motive for the murder of B. Here, correct answer is option D. Relevant under section 8 as showing the motive of the murder of for the murder of B. Question number 148. The question before the court is whether document X is the will of A. Which of the following is relevant? Option A had consulted advocates in reference to the marking the will. A had caused drafts of the wills to be prepared by which he did not approve. Option C, A had made inquiries as to the value of his estate which he has bequeathed. Option D, all of the above. Here correct answer is option D, that is all of the above. Question number 149. The question is whether A owes B rupees 10,000. The fact that A asked C to lend him money and D said, C in A's presence and hearing, I advise you not to trust A for he owes B rupees 10,000 and that A went away without making any answer is a option A, relevant fact, B, irrelevant fact, C, fact and issue, D, none of the above. Here correct answer is option A, that is relevant fact. Question number 150. Identification of the accused person is related to which of the following section of Indian Evidence Act? Correct answer is option B, that is section 9. Identification of the accused person is related to section 9 of the Indian Evidence Act. Question number 151. Test identification parade is admissible under. Correct answer is option C, that is section 9. TIP is admissible under section 9 of Indian Evidence Act. Question number 152. Identification of a suspect by photo is option A, admissible in evidence, option B, not admissible in evidence, option C, section 9 of the Indian Evidence Act excludes identification by photo, option D, section 8 of the Indian Evidence Act excludes identification by photo. Here correct answer is option A, that is admissible in evidence. Identification of a suspect by photo is admissible in evidence. Now let us proceed to question number 153. A sues B for libel imputing the disgraceful conduct to A. B affirms that the matter alleged to be libelous in nature is true. The position and relations of the parties at the time when the libel was published may be relevant. Option A, as constituting a motive for fact and issue. Option B, as conduct influenced by fact and issue. Option C, as introductory to fact and issue. And option D, as preparation for fact and issue. Correct answer is option C, that is as introductory to fact and issue. Question number 154. TIP yani test identification parade is corroborative evidence. Option B is the correct answer. Question number 155. Important case related to identification parade is Ramanathan versus State of Tamil Nadu, Ram Lochan versus State of West Bengal, Queen Empress versus Abdullah, and option D, all of these. Here correct answer is option A, that is Ramanathan versus State of Tamil Nadu is relating to test of identification parade. Question number 156. Which one of the following statement is incorrect regarding to a test identification parade? Option A, it constitutes a substantive evidence. Accused should not previously be known to the witness. It helps the investigating agency to know that the investigation is proceeding on the right lines. And option D, it should be conducted as soon as after the arrest of the accused. Here in this question it has been asked which of the following statement is incorrect. Option A is incorrect. It constitutes substantive evidence is incorrect. Therefore, option A will be the right answer. Question number 157. To ensure fairness and accuracy in a test identification parade, the requirement is option A, parading person of same social status. Option B, parading person of same or similar physical appearance along with the suspect. Option C, parading to be done in presence of all the witnesses simultaneously. And option D, none of the above. Here correct answer is option B, parading person of same or similar physical appearance along with the suspect. Question number 158. Which one of the following statement is correct? The latest approach towards the evidentiary value of identification parade as laid down by the Supreme Court in Anik Kumar versus State of Uttar Pradesh is that it is option A, mandatory evidence, option B, evidence which may be dispensed with, option C, corroborative evidence in criminal proceedings, and option D, evidence to support or to rebut any fact before the court in criminal proceeding. In question number 158, correct answer is option D, that is evidence to support or to rebut any fact before the court in criminal proceeding. Question number 159. Match list first and list second. Here, facts which shows the preparation of fact and issue. Here, correct answer is section 8. Facts which are the result of fact and issue. Correct answer is section 7. Facts which are part of the same transaction. Res gestae. Correct answer is section 6. Facts which are necessary to explain or introduce relevant facts. Correct answer is section 9. By going through these matches, the correct code will be option B. Question number 160. Which section makes anything said, done or written by an accused to a conspiracy relevant as against co-conspirators in reference to their common intention? Option A, section 10 of the Indian Evidence Act 1872. Here this option is the correct answer. Section 10 of the Indian Evidence Act 1872. Question number 161. A is tried for a riot and is proved to have marched as the head of a mob. The cries of the mob are relevant as option A, they are related to things said or done by the conspirators in reference to the common design. Option B, explanation of the nature of the transaction. Option C, explanatory of motive of preparation. And option D, explanatory of occasion, cause or effect of facts. Correct answer here is option B, that is explanation of the nature of the transaction. Question number 162. Which section of the Indian Evidence Act provides provisions relating to conspiracy? Correct answer is section 10. Question number 163. Things said or done by a conspirator in reference to common design is relevant fact under which section of Indian Evidence Act? Correct answer is option C, that is section 10. Question number 164. A and B were prosecuted for conspiracy for bribing a police officer. A came to the police station and offered an inspector packet of currency notes. He told the inspector that B had sent the money as a consideration for hushing up the case against him. The offer of money and the accompanying statement made by A were relevant against. Correct answer is option C, that is both A and B. Question number 165. X, Y and Z entered into conspiracy on December 26, 2007 to explode a bridge. In accordance with the conspiracy, the bridge was to be exploded on January 26, 2018. However, Mr. Y was arrested on January 24, 2018. He made statement to police about the conspiracy. However, remaining two conspirators successfully executed the conspiracy. Later on, the remaining two conspirators were also arrested and all were charged under the provisions of IPC. During trial, prosecution reasonably established the fact of conspiracy between X, Y and Z exploded the said bridge. In reference, which of the following fact is relevant under section 10 of the Evidence Act? Option A, a letter written to X to Y on December 20, 2017 inquiring the possibility of a meeting. Option B, confession made of Y to the police on January 24, 2018. Option C, confession made of Z to the police officer on January 13, 2018. And option D, an email sent by Y dated January 16, 2018 to supplier of explosive. Here correct answer is option D, that is an email sent by Y dated January 16, 2018 to the supplier of explosives. Question number 166. Under the Evidence Act, anything said or written by a conspirator when the conspiracy is afoot is relevant against the co-conspirator on the basis of the doctrine of agency. Option C is the correct answer. Question number 167. The Indian Evidence Act declares that anything said, done or written by one of the conspirators is relevant to prove conspiracy if it was in reference to their common intention. Option B is the correct answer. Question number 168. With respect to section 10 of Indian Evidence Act 1872, which of the following proposition expression is incorrect? Option A, there must be reasonable ground to believe in the existence of a conspiracy established by prima facie. Option B, it must be proved that the accused were parties to the conspiracy. Option C, the act, declaration, etc. of each conspirator must be only in furtherance of their common intention. And option D, the act, declaration, etc. must be confined to the period of conspiracy. Here in this question it has been asked which of the following expression is incorrect. So by going through these options, option C is incorrect will be the right answer. Question number 169. Which of the following fact is relevant under section 10 of the Evidence Act? Option A, those facts which are introductory in nature. Option B, those facts which help to certain identification or an article of a person. Option C, those facts which depict relation between parties. And option D, those facts from which inference of conspiracy can be traced. Here correct answer is option D, that is those facts from which inference of conspiracy can be traced. Question number 170. Which of the following is not correct for relevancy of evidence to prove conspiracy? Here in this question, it has been asked which of the following is not correct. Option A, there must be reasonable ground to believe that two or more persons have entered into a conspiracy. Option B, the act in question must have been done after the time when the intention to conspire was first entertained by any of them. And option C, the act must have been done in reference to their common intention. Option D, it can be used in favor of other party or for the purpose of showing that such person was not a party to the conspiracy. Here it has been asked which of the following is not correct. Option D is not correct. Other options are correct. Question number 171. The evidence relating to conspiracy is option A, common motive of the conspirators and any act done in pursuance of it. Option B, common intention of the conspiracy and anything written in pursuance of it. Option C, common intention of the conspirator and anything said, done, written by any of them in furtherance of that intention. Here option C is the correct answer. Question number 172. Fact not otherwise relevant becomes relevant if they are inconsistent or makes highly probable or improbable any fact in issue or a relevant fact. Option A, cannot be relevant. Option B, relevant under section 11 of Evidence Act. Option C, relevant under section 9 of Evidence Act. And option D, relevant under section 7 of Evidence Act. Here correct answer is option B. This is not correct. Therefore, option B will be the right answer. Question number 173. Facts not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant fact. Which of the following sections of Indian Evidence Act contains the aforesaid principle of law? Correct answer is section 11. Question number 174. Which one of the following sections of Indian Evidence Act provides the provision regarding plea of alibi? Correct answer is section 11. Question number 175. Which section of Evidence Act called a residuary section dealing with the relevancy of facts? Correct answer is option A, that is section 11. Question number 176. Facts which are inconsistent with any fact in issue are relevant on the basis of option A, plea of alibi. Option B, principles of res gestae. Option C, nihil ad rem. And option D, res integra. Correct answer here is plea of alibi, section 11. Question number 177. The question is whether on 11 January 2019 A committed a crime of murder at Jaipur, whereas factually it has been proved that at the time and day of occurrences A was at Shimla. It is a relevant fact because option A, plea of alibi of the accused. Option B, by the nature of the transaction explaining of the relevant fact is revealed. Option C, it reveals subsequent conduct of the accused. And option D, the act of the accused was intentional and not an accidental act. Here correct answer is option A, that is plea of alibi of the accused. Question number 178. A is accused of murder of B by pistol alleged to be purchased on 15 September at Dehradun. A makes a statement that on 15 September he was at Lucknow, not at Dehradun. A's statement is a relevant fact under section 11. Question number 179. The question is whether A committed a crime at Calcutta on a certain day. The fact that on that day A was at Lahore is relevant. Option A, as a motive for the fact in issue. Option B, as introductory to fact in issue. Option C, as preparation of relevant fact. And option D, as it makes the existence of fact in issue highly improbable. Correct answer is option D. Question number 180. The plea of alibi is established by option A, prosecution. Option B, accused. Option C, either by prosecution or by accused. And option D, none of the above. Correct answer is option B. Plea of alibi is established by accused. Question number 181. The case of Dudhnath Pandey versus State of Uttar Pradesh is related to option A, res gestae. Option B, plea of alibi. Option C, admission. Option D, accomplice. Correct answer here is option B, that is plea of alibi. Question number 182. The plea can succeed only if it is shown that the accused was so far away at the relevant time that he could not be present at the place where the crime was committed. The Supreme Court of India in this observation was referring to the plea of option A, innocence. Option B, abetment. Option C, alibi. And option D, self-defense. Here correct answer is option C, that is alibi. Question number 183. The question is whether the murder of X was committed by Y. The fact that Y produces an admission slip of hospital indicating dislocation of his hip bone during the period of alleged murder. Which one of the following is the correct provision of the Indian Evidence Act under the which it is relevant? Here correct answer is option D, that is section 11. Question number 184. Which of the following statements as per the provision of Indian Evidence Act is not correct? Option A, facts which are inconsistent with any fact in issue shall not be relevant. Option B, facts not otherwise relevant are relevant if by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. Any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. Admissions are not conclusive proof of the matters admitted, but they may operate as estoppels under the provisions of the Indian Evidence Act 1872. Here, option B, C, D and are correct. In this question, it has been asked which of the following statement as per the provision of Indian Evidence Act are not correct. Option A is not correct, therefore will be the right answer in this question. Question number 185. Section 11 of Indian Evidence Act enables a person charged with a crime to take what is commonly called the plea of option C, alibi. Question number 186. The question is whether A committed a crime at Kolkata on a certain day. In the answer to this question, which of the following fact is relevant? Option A, that A was out that day at Mumbai. Option B, that A habitually goes to Kolkata. And option C, that A habitually commits crime. And option D, none of the above. Here correct answer is option A, that A was out that day at Mumbai will be the right answer. Question number 187. Under Indian Evidence Act, facts not otherwise relevant are relevant dash if they are significant. Options statement second, if they are inconsistent with any fact and issue or relevant fact. Statement third, if they make the existence or non-existence of any fact and issue or relevant fact highly probable or improbable. Here correct answer is option D, that is second and third statement are correct. Facts not otherwise relevant are relevant if they are inconsistent with any fact and issue or relevant fact, if they make the existence or non-existence of any fact or fact and issue relevant highly probable or improbable. Question number 188. Which section of the Evidence Act enables the court to determine the amount of damages? Option are Section 9, Section 11, Section 12, Section 10. Here correct answer is option C, that is Section 12. Question number 189. Which section of the Evidence Act lays down rules regarding the relevant facts when the right or custom is in question? Here correct answer is option B, that is Section 13. Question number 190. Evidence of custom cannot be given to be established. Option A, a civil right. Option B, an easementary right. Option C, a customary right. And option D, a criminal right. Correct answer is option D, that is a criminal right. Question number 191. A marriage was solemnized in a general customary form. What is the rule for providing that it is a legal wedlock? Option A, the custom shall be proved by evidence. Option B, the court takes judicial notice of the custom. Option C, the court shall evaluate the effect of custom on the general public. And option D, all of the above. Correct answer is option D, that is all of the above. Question number 192. Fact showing existence of any state of mind or showing the existence of any state of body or bodily feeling are relevant under which section of Indian Evidence Act? Option A, Section 16, option B, Section 12, option C, Section 14, and option D, Section 15. Here correct answer is option C, that is Section 14. Question number 193. The fact showing the existence of any state of mind under Section 14 of Indian Evidence Act relate to intention, knowledge, good faith, all of these. Correct answer is option D, that is all of these. Question number 194. Which of the following does not find a mention as showing the state of mind under Section 14 of Evidence Act? Option 1, will. Option B, motive. Option C, good faith. And option D, negligence. Here correct answer is option B, that is motive. Question number 195. A is accused of defaming B by publishing an imputation intended to harm the reputation of B. The fact of previous publication by A respecting B showing ill will on the part of A towards B is relevant. Option A, because it proves the preparation for harming A's reputation. Option B, as it is necessary to explain the fact in issue. Option C, as proving intention to harm B's reputation. And option D, as it is the effect of relevant fact. Here correct answer is option C, as proving intention to harm B's reputation. Question number 196. Under which one of the following sections of the Evidence Act the previous conviction of a person is relevant? Option A, explanation first to Section 14. Option B, explanation second to Section 14. Explanation third to Section 14. Explanation 4 to Section 14. Correct answer is option B, that is explanation second to Section 14. Question number 197. A is accused of receiving stolen goods knowing them to be stolen. The above is the illustration of Section 8, Section 12, Section 14, Section 13. Correct answer is option C, that is Section 14 of the Evidence Act. Question number 198. Under Section 14 of Indian Evidence Act 1872, which of the following facts becomes relevant? Namely, fact showing the state of mind, fact showing state of body, fact showing state of bodily feelings, all of the above. Here correct answer is option D, that is all of the above. Question number 199. A is tried for the murder of B by intentionally shooting him dead. The fact that A on other occasions shot at B is relevant as it shows intention to shoot B, B motive to shoot B, C preparation to shoot B, D none of the above. Here correct answer is option A, that is intention to shoot B. Question number 200. X is tried for committing murder of Y by intentionally shooting at him. With reference to this intention, prosecution adduced the fact that X had attempted to shoot Y at an earlier occasion. The fact is relevant under dash of the Evidence Act. Correct answer is section 14 of the Indian Evidence Act. Question number 201. A is tried for the murder of B by intentionally shooting him dead. The fact that A was in the habit of shooting at people with the intent to murder them is relevant fact, irrelevant fact, neither relevant nor irrelevant fact and issue. Correct answer here is option B, irrelevant fact. Question number 202. Which of the following is incorrect under the Evidence Act? Option A. In case where A is charged with receiving a particular stolen wristwatch knowing the same to be stolen, the fact at the same time he was in possession of other such stolen article is relevant. Question number B. In case where A is tried for the murder of B by intentionally shooting him to death, the fact that A was in the habit of shooting at people with intent to murder them is relevant. This is wrong statement, and in this question this is been asked which of the following statement is wrong. So B is wrong here. Question number 203. The question before the court is whether the document X is the will of A. Which of the following is relevant? Options are: A had consulted advocates in reference to the making of the will. Option B, A had caused drafts of wills to be prepared which he did not approve. And option C, A had made inquiries as to the value of his estate while he was bequeathed. And option D, all of the above. Here correct answer is option D, all of the above. Question number 204. S sues Y for damage done by a dog of Y, which Y knew to be ferocious. The fact that the dog had previously bitten A, B and C are option A, relevant, irrelevant, inadmissible, unreliable. Here correct answer is option A, that is relevant. Question number 205. Which of the following fact is not relevant under the Indian Evidence Act? Option A, where accused was charged for the murder of X, the fact that accused was in the habit of shooting at people. This is not relevant under the Indian Evidence Act. Therefore, this will be the correct answer because in the question it has been asked which of the following is not correct. So option A is right answer here. Let us proceed to question number 206. Question number 206. The question is whether a particular letter reached A. The fact that it was posted in due course and was not returned through the dead letter office. Here option A are not relevant, option B are relevant, option C are relevant, option D none of these. Here correct answer is option C, that is are relevant. Question number 207. The brides in the bath case is based on which of the following in which section of the Indian Evidence Act? Correct answer is option B, that is section 15 of Indian Evidence Act. Question number 208. Which of the following sections of the Indian Evidence Act deals with the relevancy of admission and confession? Options are section 6 to 16 and option B section 17 to 31, option C section 32 to 33 and option D section 34 to 59. Here correct answer is option B, that is section 17 to 31. Question number 209. Which one of the following section of Indian Evidence Act defines admissions? Option R section 16, section 17, section 15, section 18. Correct answer is option B, section 17 defines admission. Question number 210. Admissions. Option A must be in writing, must be oral, can be either oral, writing, must be oral and writing both. Here correct answer is option C. Admission can be either oral or writing. Question number 211. Which one of the following statement is correct? Admission is the acknowledging any right of liability under civil law made. Option A, orally before a judicial authority, in writing before a notary, by conduct and document as well as orally but not in electronic form. Option D, by conduct orally or in writing or contained in electronic form. Here correct answer is option D, by conduct orally or in writing or contained in electronic form. Question number 212. Which of the following sections was amended by the Information Technology Act 2000? Option A, section 6 of Indian Evidence Act, section 17 of Indian Evidence Act, section 32 of Indian Evidence Act, section 41 of Indian Evidence Act. Here correct answer is option B, that is section 17 of Indian Evidence Act was amended by the Information Technology Act 2000. Question number 213. Admission means option A, statement made before court, statements made in documents, statements suggesting inference as to any fact in issue, none of the above. Here correct answer is option C. Admission means statement suggesting inference as to any fact in issue. Question number 214. Admissions are not conclusive proof of the matters admitted, but they may operate as estoppels. Correct answer is option B. Question number 215. Which of the following statement is true? Admissions are option A, conclusive proof of the matter admitted, not conclusive proof of the matter, but may operate as estoppels under certain provisions of the Evidence Act. Conclusive proof of the matter admitted and always operate as estoppel, and option D, not conclusive proof of the matter. Here correct answer is option B, that is not conclusive proof of the matter but may operate as estoppels under certain provisions of the Evidence Act. Question number 216. Statements made by an agent to any party to the proceedings are admissions in all circumstances. Option B, if the court regards under the circumstances of the case that an agent is expressly authorized by the principal to make them. And option C, if the court regards under the circumstances of the case that the agent is expressly or impliedly authorized to take them. Here correct answer is option C, that is, if the court regards under the circumstances of the case that the agent is expressly or impliedly authorized to make them. Question number 217. Admissions according to the Indian Evidence Act includes the statement made by expressly referred person, agents to a party to proceeding authorized to make the statement, person whose liability must be proved, person from whom the party derived his interest in the subject matter. Select the correct answer by using the codes given below. Here correct answer is option A, that is 1, 2, 3 and 4. All the statements are correct. Question number 218. Who can make admission under the Indian Evidence Act? Option A, person from whom interest is derived, an independent person witness to a proceeding, the court. Here correct answer is option A, that is, person from whom the interest derived will be the right answer. Question number 219. With respect to the admission under Indian Evidence Act, choose a true statement about the proposition. Statement first. Admissions can be made by parties to the proceedings. Admission can be made by agents of the parties who are authorized to expressly only. Option third. Persons filing suits in representative character can also make admission while having that character. Assertions. First and second are correct, third is incorrect. First and third are correct and first is incorrect. First and third are correct and second is incorrect, and all are correct. Here in question number 219, assertion C is correct, that is, first and third are correct and second is incorrect. Question number 220. Under the provisions of the Indian Evidence Act, admissions and confessions have the same meaning. Admissions and confessions have different meanings. Admissions are a matter in a criminal trial. Confessions are a matter in a civil suit. Here correct answer is option B, that is, admission and confession have the different meaning. Question number 221. Give the correct answer. All the admissions are confession, but all confessions are not admission. Here this statement is incorrect. Question number 222. Admissions bind a maker insofar as it relates to facts, question of law, both question of facts and law, neither A or B. Correct answer is option A, that is facts. Question number 223. What is evidentiary value of admission? Option A, unimportant. Option B, conclusive proof. Option C, as estoppel. Option D, binding. Here correct answer is option C, that is as estoppel. Question number 224. Admissions are option A, not conclusive proof of the matters admitted. B, conclusive proof of the matters admitted. C, not to operate as estoppel, and option D, or of no value. Here correct answer is option A. Admissions are not conclusive proof of the matters admitted. Question number 225. Which of the following admission is no evidence? Option A, an admission by one or more several defendants in a suit against another defendant. Option B, an admission by a guardian ad litem against the minor. Option C, an admission by one of the partners of a firm against the firm or other partners. D, only A and B. Here in this question it has been asked which of the following admission is no evidence. Therefore answer D will be, option D will be right. A and B are not evidence, whereas an admission by one of the partners of a firm against the firm or other partners will be considered as evidence. Question number 226. With respect to admission under the Indian Evidence Act, choose a true statement about the propositions. Statement first. Admissions are substantive piece of evidence. Generally, admission provided under the maker of the statement, self-serving statement as to state of mind or of body is admissible as admission. Assertions first and second are correct, third is incorrect. B, second and third are correct, first is incorrect. C, first and third are correct, second is incorrect, and D, all are correct. Question number 226. Answer is option D, that is all are correct. Question number 227. Under Indian Evidence Act, admission can be made by party to the suit, a counsel of party, person interested in the subject matter, all of the above. Here correct answer is option D, all of the above. Question number 228. Mark the correct option. It is necessary for the application of section 18 of the Evidence Act that there must be a formal agency. Option B. Section 18, 19 or 20 of Evidence Act are exceptions of the doctrine of privity. Option C. Section 70 to 20 of Evidence Act talk about judicial admission. Option D. Statements made under section 70 to 20 of Evidence Act should be regarding the fact and issue only. Here it has been asked which of the following is the correct option. Option A is the correct option. Question number 229. With respect to admission under the Indian Evidence Act, choose a true statement about the propositions. Propositions. Confession is a subspecies of admissions in a criminal cases. Statement second. Statements containing self-exculpatory statements cannot be called as confession, and mere conduct is not confession unless it amounts to assertion. Here correct answer is option D, that is all are correct. Question number 230. Which one cannot make admission? Option A, agent of the parties. Option B, person from whom parties have derived interest. Option C, admission by co-defendant. And option D, those persons who have been umpires by the parties to the case. Here correct answer is option C. Admission by co-defendant cannot make admission. Question number 231. Which one of the following is irrelevant? Option A. Admission made by party interested in the subject matter. Admission made by an agent of a party to the proceedings. Admission made by party to have pecuniary interest. Option D. Admissions made by a party who has not been expressly referred to a party to seat. Here statement D is irrelevant. Question number 232. The question is whether a horse sold by A to B is sound. A says to B, go and ask C. C knows all about it. C's statement is an admission, not an admission, a confession, a presumption. Here correct answer is option A, that is an admission. Question number 233. The general rule is that admissions are proved against the maker. Which of the following provisions of the Evidence Act provide for the exception of the rule? Options are section 17, section 18, section 21, section 32. Correct answer is option C, that is section 21. Question number 234. Which section of the Indian Evidence Act lays down the rule that in certain circumstances admission can be proved by or on behalf of the person making it? Options are section 18, section 19, section 20, section 21. Here correct answer is option D, that is section 21. Question number 235. A is accused of receiving stolen goods knowing them to be stolen. He offers to prove that he refused to sell them below their value. Which of the following is correct? A may prove the statements though in the nature of admission because they are explanatory to conduct influenced by fact and issue. Option B. A may not prove the statement because they are self-serving admissions. And option C. A may not prove the statement because as accused he cannot be a witness in his own defense. Here in question number 235, correct answer is option A. A may prove the statement though in the nature of admission because they are explanatory of conduct influenced by the fact and issue. Question number 236. Which section of the Evidence Act has been amended in 2000 for admissions or electronic records? Correct answer is option B, that is section 22A. Question number 237. Oral admission as to contents of electronic records are relevant when? Option A. The party proposing to prove them shows that he is entitled to give secondary evidence of the same. Option B. The genuineness of the electronic record produced is in question. Option C. Both A and B, and option D. None of the above. Here correct answer is option B. Oral admissions as to the contents of the electronic records are relevant when the genuineness of the electronic records produced is in question. Question number 238. Under Indian Evidence Act 1872, the provision of relevancy of oral evidence as to the contents of electronic records is provided in section 22A of the Indian Evidence Act is the correct answer. Question number 239. Which section of Indian Evidence Act 1872 deals only with civil matters? Options are section 23, section 27, section 53, section 133. Here correct answer is option A, that is section 23. Question number 240. Which of the following section of Indian Evidence Act does not deal with the criminal matters? Option A, section 25, section 23, section 53, section 30. Here correct answer is option B, that is section 23 does not deal with criminal matters. Question number 241. Which of the following section of the Indian Evidence Act 1872 does not deal with the criminal matters? Option A, section 27, option B, section 133, option C, section 53, and option D, section 23. Here correct answer is option D, that is section 23. Question number 242. Section 23 of the Indian Evidence Act deals with option A, relevance of admissions in civil cases, option B, relevance of oral admission as to the contents of document, option C, relevance of oral admission as to the contents of electronic documents, option D, none of the above. Here correct answer is option A, relevance of admissions in civil cases. Question number 243. When a person makes an admission upon a condition that evidence of it shall not be given, it cannot be proved against him. This was laid down in section 24, section 21, section 22, section 23. Here correct answer is option D, that is section 23. Question number 244. Communication made without prejudice are protected under section 21 of Evidence Act, under section 24 of Evidence Act, under section 23 of Evidence Act, and under section 22 of Evidence Act. Correct answer here is option C, that is under section 23 of Evidence Act. Question number 245. Propositions under the Evidence Act are: statement is a genus, admission is a species, and confession is a subspecies. Statement second, statement and admission are species and confession is a subspecies. Statement third, statement and admissions are genus and confession is a species. In this context, which of the following is correct? Here correct answer is option A, that is first is correct and second and third are incorrect. That means statement is a genus, admission is a species, and confession is a subspecies. Question number 246. In Evidence Act, confession is defined under. Here in Evidence Act, confession is not defined, so option D will be the right answer, none of these. Question number 247. A says to B that he has furnished his wife forever. Under Indian Evidence Act, these statements amount to option A admission, option B confession, option C statement, and option D all of the above. Here correct answer is option B confession. Question number 248. Palvinder Kaur versus State of Punjab is related to which of the following? Option A leading question, option B secondary evidence, option C confession, and option D admission. Here correct answer is option C, that is confession. Palvinder Kaur versus State of Punjab is related to confession. Question number 249. Confession caused by inducement, threat or promise when irrelevant in criminal proceeding is covered by option A section 24 of Evidence Act, section 26 of Evidence Act, section 21 of Evidence Act, section 28 of Evidence Act. Correct answer is option A, that is section 24 of Evidence Act. Question number 250. The statement in order to constitute a confession under the Indian Evidence Act must either admit in terms of the offence or at any rate substantially all facts which constitute the offence. The above view was expressed by the Privy Council in which one of the following cases? Option A John McCain versus Attorney General, option B Paklan Narayan Swamy versus Emperor, option C HHB Gill versus King Emperor, and option D QE versus Abdullah. Here correct answer is option B, that is Paklan Narayan Swamy versus Emperor. Question number 251. Which one of the following is not mentioned as a ground under section 24 rendering a confession by an accused person irrelevant? Option A inducement, option B promise, option C deceit, and option D threat. Here question number 251, correct answer is option C deceit. It is not mentioned under section 24 regarding a confession by an accused person. Question number 252. A rustic woman is in apprehension of assault and maltreatment makes a confession for murder of her mother-in-law at a village panchayat. Whether this confession is admissible? Option A as extrajudicial confession, option B inadmissible due to involuntariness, option C as a supporting evidence to the fact deposed by the other witness, and option D partly admissible. Here correct answer is option B. Question number 253. In which section of Evidence Act 1872 confession is made to the police is not admissible? Correct answer is option A, that is section 25. Confession made to a police is not admissible. Question number 254. Confession before police will be proved, will not be proved, will be considered confession, will not be considered confession. Here correct answer is option B, that is will not be proved. Question number 255. A commits a crime and goes to the police officer. He makes a confession and gives other information. A is charged with the offence. The confession, option A, cannot be proved against him because of section 25 of the evidence. Option B can be proved against him because of section 27 of the Evidence Act. Option C can be proved against him because of section 25 of the Evidence Act, and option D cannot be proved against him because of the section 27 of the Evidence Act. Here correct answer is option A, cannot be proved against him because of the section 25 of the Evidence Act. Question number 256. A confession to be inadmissible under section 25 of the Evidence Act must relate to the same crime for which he is charged. Option B must relate to another crime. Option C may relate to the same crime or at any other crime, and option D none of these. Here correct answer is option C, that is may relate to the same crime or any other crime. Question number 257. A confessional statement made before police is admissible, is not admissible, is admissible only if it relates to the fact discovered in consequence of it. And option D is admissible if it is made on oath in writing. Here correct answer is option B. A confession statement made before a police is not admissible. Question number 258. With respect to the confession, under Indian Evidence Act, choose the true statements about the propositions. Article 20 Clause 3 of the Constitution protects an accused against testimonial compulsions. Article 20 Clause 3 creates no bar in causing retracted confession against the accused. Third, accused can claim protection under section 24 against the confession recorded through compulsion. Assertions here are in question number 258, correct answer is option D, because all the statements here provided are correct. Question number 259. Which of the following cases is not related to confession? Pulukari versus Kottayya versus King Emperor related to confession. State of UP versus Devon Upadhyay is also related to confession. State of Bombay versus Kathikalu is also related to confession. The last and the remaining T.J. Ponnan versus M.C. Varghese is not related to confession, therefore will be the correct answer. Question number 260. A filed a FIR giving details of a crime that he had committed. There was no exculpatory statements in the FIR and gave all the details regarding the commission of the crime. Which of the following statement is accurate? Option A. The FIR is hit by section 25 of the Indian Evidence Act and hence is inadmissible as evidence. However, the fact that A filed the FIR admissible under section 8 of the Indian Evidence Act. Option B. Since FIR is confessional in nature, the fact that the A is filed the FIR is also not admissible in evidence. Statement C. The FIR including confession is admissible under the Indian Evidence Act as it was voluntary and before arrest. Option D. It is admissible under section 32 clause 3 of the Indian Evidence Act. Here only statement A is correct. The FIR is hit by section 25 of the Indian Evidence Act, hence it is inadmissible as evidence. However, the fact that A filed FIR is admissible under section 8 of the Indian Evidence Act. So option A will be the right answer in question number 260. Now let us proceed to question number 261. Confession can be the result of self-talk. Communication of confession to another person is not necessary was held in the case of option A. Sankaria versus State of Rajasthan, option B. Bhutta Singh versus State of Punjab, option C. Saho versus State of UP, and option D. Nishikant Jha versus State of Bihar. Here correct answer is option C, that is Saho versus State of UP. Question number 262. Extrajudicial confession, if voluntary, can be relied upon with other evidence. Reason: extrajudicial confession is a weak piece of evidence. Here both A and R are true and R is the correct explanation of A. This is the correct answer. Extrajudicial confession is a voluntary, can be relied upon the other evidence, and extrajudicial confession is a weak piece of evidence. Both A and R are true statements and they are the explanation of A. Question number 263. When a confession otherwise relevant will become irrelevant. Option A. In consequence of a deception practiced on the accused made to a police officer made under the promise of secrecy when the accused was drunk. Here correct answer is option B, that when a confession otherwise relevant will become irrelevant if is made to a police officer. Question number 264. Under which section of Indian Evidence Act the confession before the magistrate is relevant? Correct answer is option C, that is section 26 of Indian Evidence Act. Confession made before the magistrate is relevant. Question number 265. Extrajudicial confession means a confession made before judicial magistrate in court, before doctor, before friend, before doctor and before friend. Here correct answer is option D, both before doctor and before friend. Question number 266. A confession made by an accused is relevant and admissible. Option A, when it is extrajudicial, voluntarily and truthful and beyond reproach. Option B, when made to a third person after being detained by a police officer. C, when made on being threatened with severe assault and beatings by police. Option D, none of the above, as confession is inadmissible. Here correct answer is option A. A confession made by an accused is relevant and admissible when it is extrajudicial, voluntarily and truthful and beyond reproach. Question number 267. In which state a confession may be proved? Option A, if the confession is made before a police officer. B, if the confession is made due to pressure of police before a magistrate. C, if the confession is made voluntarily before a magistrate. And option D, none of these. Here correct answer is option C, if a confession is made voluntarily before a magistrate. Question number 268. A confession made in police custody is admissible under section 26 of Evidence Act. Option A, if made in the presence of a doctor. B, if made in the presence of a captain of vessel. C, if made in the presence of a magistrate. D, none of the above. Here correct answer is option C, if made in the presence of a magistrate. Question number 269. A confession made by a person while in police custody is inadmissible under option A, section 29 of Evidence, section 26 of Evidence, section 25 of Evidence Act, section 27 of Evidence Act. Here correct answer is option B, section 26 of Evidence Act. A confession made by a police while in police custody is inadmissible under section 26 of the Evidence Act. Question number 270. A voluntary confession is admissible in evidence. Option A, when made to a police officer. Option B, when made to a magistrate or competent jurisdiction. Option C, when made to a village sarpanch with request to save him from police. And option D, when made to a police officer who kept him in his custody. Here correct answer is option B. A voluntary confession is admissible in evidence when made to a magistrate of competent jurisdiction. Question number 271. Confession recorded by a magistrate on oath is. Correct answer is inadmissible. Question number 272. Choose a true statement about the propositions. First, judicial confession is substantive piece of evidence. Extrajudicial confession is not a substantive piece of evidence. Confession of co-accused is admissible against other as well. Here options are first and second are correct, third is incorrect, first and third are incorrect, and first is incorrect. First and third are correct and second is incorrect. Here correct answer is option C, that is first and third are correct and second is incorrect. Judicial confession is a substantive piece of evidence. It is correct. Extrajudicial confession is not a substantive piece of evidence or weak piece of evidence. This is also correct. Confession of co-accused is admissible. Confession of accused is not admissible against others as well. Question number 273. The term police custody under the section 26 of the Indian Evidence Act means which of the following? Option A, physical presence of the police before an accused person. B, indirect control by the police of an accused person. C, some restrictions by the police over an accused person. D, some kind of surveillance and restrictions over the accused person by the police. Here correct answer is option D, that is some kind of surveillance and restrictions over the accused person by the police. The term police custody used under section 26 of the Indian Evidence Act means some kind of surveillance and restrictions over the accused person by the police. Question number 274. The term judicial confession means option A, it is made before a police officer. B, it is caused by inducement, threat or promise. C, it is made before any court officer. D, it is made before a magistrate. Here correct answer is option D. The term judicial confession means it is made before a magistrate. Question number 275. A confession is inadmissible if it is made by the accused. Option A, to a magistrate while he is in the custody of a police officer, to his friend while he is not in the custody of a police officer, to a doctor while he is in the custody of a police officer, to a spiritual advisor under the inducement for the good for his soul. Here correct answer is option C, that is to a doctor while he is in the custody of a police officer. Question number 276. What is the meaning of retracted confession? Option A, confession which is subsequently confirmed. B, confession which is subsequently assured. C, confession which is subsequently resiled. And option D, none of the above. Here correct answer is option C, confession which is subsequently resiled. Question number 277. A confession made to the accused person is relevant. Option A, if it is proceeded from a person in authority unless made in immediate presence of a magistrate. B, if it is made by a police officer unless made in the immediate presence of a magistrate. C, if it is made to the magistrate provided the police officer is present. And D, if it is made while he is in the custody of a police officer and is made in the immediate presence of the magistrate. Here the confession made with the accused person is relevant in option D, that is if it is made while he is in the custody of a police officer and is made in the immediate presence of a magistrate. Question number 278. For recording a confession, magistrate should option A, get that person arrested, summon the complainant, inform such person about the accusation against him. D, inform such person that he is not bound to make a confession. Here correct answer is option D, that is for recording a confession, magistrate should inform such person that he is not bound to make a confession. Question number 279. In certain cases, corroboration of confession is necessary. Reason, in all cases, an extrajudicial confession must be corroborated. Here, correct answer is option B. Both A and R are true, but R is not the correct explanation of A. Question number 280. A is an accused, makes a confession to the superintendent of police. In this case, confession made by A is option A, admissible in evidence against A, not admissible in evidence against A. C, admissible in evidence, not will depend on the discretion of the court. D, admissible in evidence against A because A is an accused. Here correct answer is option B, not admissible in evidence against A. Question number 281. Section 27 of the Indian Evidence Act is based on theory of agency, theory of ratification, theory of confirmation by subsequent facts, none of these. Here correct answer is option C, that is theory of confirmation by subsequent facts. Question number 282. In which of the following cases constitutionality of section 27 was challenged for violation of article 20 clause 3 of the constitution? Here correct answer is option A, that is State of Bombay versus Kathikalu. Question number 283. Which section of the Indian Evidence Act deals with the doctrine of confirmation by subsequent facts? Option A, section 27, B, section 115, C, section 102, D, section 165. Correct answer is option A, that is section 27. Question number 284. Section 27 of the Evidence Act applies. Option A, when the person giving information is an accused but not in police custody. Option B, when the person giving information is an accused and is in police custody. Option C, when the accused person is in police custody but not as an accused. And option D, when the person is neither in police custody nor accused. Here correct answer is option B, when the person giving information is an accused and is in police custody. Question number 285. Section 27 of the Indian Evidence Act is an exception to the rules enacted. Here correct answer is option D, in section 24, 25 and 26 of the Indian Evidence Act 1872. Question number 286. About 14 days ago, I, K and people of my party lay in wait for S and others at about sunset time at the corner of the Piliput tank. We all beat S and H to death. The remaining persons F, K and N ran away. D, who was in our party, received blows on his hand. He had a spear in his hand. He gave it to me. Then I hid it and my stick in the rick of V in the village. I will show you if you come. We did all this at the instigation of K. From the above passage, which of the following is admissible under section 27 of the Indian Evidence Act? Option A, we all beat S and H to death. Option B, the remaining person F, K and N ran away. D, who was in our party, received blows on his hands. He had a spear in his hand. He gave it to me then. Option C, I hid it and my stick in the rick of V in village and I will show you if you come. Option D, we did all this at the instigation of K. Here correct answer is option C, that is I hid it and my stick with the rick of V in the village and I will show you if you come. Question number 287. Under section 27 of the Indian Evidence Act, the whole statement is admissible. Only the portion of the statement which leads to the discovery of evidence is admissible. Both A and B are admissible and D, none of the above are admissible. Here correct answer is option B. Under section 27 of the Indian Evidence Act, both the portion of the statement which leads to the discovery is admissible. Question number 288. The constitutionality of which section of the Indian Evidence Act was challenged in state of UP versus Devman Upadhyay for the violation of Article 14 of the Constitution? Here correct answer is option C, that is section 27. Question number 289. Confessional statement of the accused in custody when admissible if it relates to the confession of a crime by himself, if it relates to the commission of a crime only by the co-accused, leading to discovery of fact relates to the preparation of crime. Here correct answer is option C, leading to a discovery of a fact. Question number 290. B is found dead having suffered injuries with a sharp weapon. A, while in police custody, confessed to killing B with the motive of stealing his motorcycle after following him from his office and having concealed the weapon in office. A gets the knife recovered from before the police. In this case, under section 27 of the Indian Evidence Act, the following would be admissible. Option A, entire statement of including motive of stealing the motorcycle and a manner in which the murder was committed, that is following the victim B from his office except the confession. Option B, the place from which the knife was produced and the knowledge of A leading to the recovery of knife. Option C, the fact that A had murdered V with the knife. Option D, nothing is admissible as the statement was made to a police officer and A was arrested. Here in this question, option B will be the right answer because it is leading to some discovery of fact. The place from which knife was produced and the knowledge of A leading to recovery of knife. Question number 291. If an accused voluntarily consents for brain mapping and narcoanalysis, then such information is relevant under which section of the Indian Evidence Act? Correct answer is option C, that is section 27 of the Indian Evidence Act. Question number 292. In which of the following judgments Supreme Court ruled that section 27 is an exception to section 25 and 26 of the Evidence Act? Correct answer is option A, Inayatullah versus State of Maharashtra. Question number 293. Essential requirement for an application of section 27 of the Evidence Act are: person giving information must be an accused of any offence, the person must be in police custody, the person may or may not be in police custody, A and B both. Here correct answer is option D, that is A and B both. Person giving information must be an accused of any offence, the person must be in the police custody. Question number 294. During the course of investigation, information received from an accused who is in police custody leads to the discovery about arms, clothes, ornaments, corpus, which are related to which of the offence are relevant under section 27 of the Evidence Act. The principle was laid down in the case of option A, 𝐷𝐿𝐴 versus Emperor, Kaushal Rao versus State of Bombay, Sawal Das versus State of Bihar, and Pakla Narayan Swamy versus Emperor. Here correct answer is option A, that is 𝐷𝐿𝐴 versus Emperor. Question number 295. Section 27 of the Evidence Act in respect of the confession evidence. First, so much that the information as it relates to distinctly to the fact discovered in consequence of information received from the person accused may be proved against him. Statement second, person giving such information must be accused of an offence. Statement third, accused need not to be in the police custody. Statement fourth, any statement of the accused confessing his guilt must be made in the presence of a magistrate in all cases. Whether anything is discovered or not in the consequence of such statements may be proved against him. In question number 295, correct statements are statement first and second. Statement first and second are true. Statement first is, so much of the information as it relates distinctly to the fact discovered in consequence of information received from the person accused may be proved against him. Statement second, person giving such information must be the accused of an offence. Statement first and second are true. Question number 296. In which case it was propounded that section 27 is an exception to section 24, 25 and 26. Correct answer is option D, that is State of UP versus Devman Upadhyay. Question number 297. Section 27 of the Evidence Act applies to discovery of some fact which. Option A, the police had not previously learned from other sources and was first derived from the information given by the accused. B, a police had not previously learned from the other sources. C, the police had previously learned from the other sources and the accused has also given information regarding the same. D, all of the above. Here correct answer is option A. Section 27 of the Evidence Act relies to the discovery of some fact which the police had not previously learned from the other sources and was first derived from the information given by the accused. Question number 298. An accused in police custody informs the state house officer that the key by which he opened the safe and committed the theft is kept by him in the patio of how. To what extent this information can be proved? Here correct answer is option D, for keeping the key in the patio of the house. Question number 299. In which of the following cases the Supreme Court held that any information or material that is subsequently discovered with the help of voluntarily administered test result can be admitted in accordance with the section 27 of the Indian Evidence Act 1972? Here correct answer is option A, that is Selvi versus State of Karnataka. Question number 300. Under section 27 of the Evidence Act, the fact discovered means the object produced only, the place from where the object is produced only, the knowledge of the accused as to the object and the place, and none of these. Here correct answer is option C, that is the knowledge of the accused as to the object and the place. Question number 301. The expression information received from a person accused of offence under section 27 of the Indian Evidence Act 1872 covers information through option A, confession statements only, option B, statements amounting to confession or admission only, option C, all forms of information whether confessional or not, option D, none of the above. Here correct answer is option C, that is all forms of information whether confessional or not is the correct answer. Question number 302. Which of the following statement is correct? Option A, confession by inducement, threat or promise flowing from person in authority giving reasonable impression to the accused that he would thereby avoid punishment is relevant. Option B, confession by accused while in custody of police even if made in the immediate presence of a magistrate shall not be proved. Option C, the confession of the accused made while in custody of the police may be proved if as a consequence of information received thereby a relevant fact is discovered, and option D, none of the above. In question number 302, correct answer is option C, that is the confession of the accused made while in custody police may be proved as if as a consequence of information received thereby a relevant fact is discovered. Question number 303. Which one of the following is not the exception to the rule of hearsay under the law of evidence? Option A, expert's opinion, option B, dying declaration, option C, confession, and option D, res gestae. Correct answer here is option C, that is confession. Question number 304. A person after committing crime confess while intoxicated the commission of crime. Under Indian Evidence Act, confession is relevant and admissible in section 29, section 30, section 31, section 32. Correct answer here is option A, that is section 29. Question number 305. Match list first with list second and select the correct answer by using the quotes given below. Here in list 1, option A is confession caused by inducement, threat, promise. Correct answer here is Pyare Lal Bhargav versus State of Rajasthan. Option B, confession to a customs officer. Correct answer here is State of Punjab versus Barkat Ram. Option C, confession in the FIR given by the accused. Here correct answer is Agnu Nagesha versus State. Option C is the correct match. Option 4, that is D, discovery of a fact pursuant to a statement in police custody. Here the correct match is State of Bombay versus 𝐶𝐤 This is the correct match here. Now by going through these matches, the correct option here is option D. D is the right answer. Question number 306. Confession of an accused is admissible against the other co-accused under section 28 of the Evidence Act, section 29 of the Evidence Act, section 30 of the Evidence Act, section 31 of the Evidence Act. Correct answer here is option C. Under section 30 of the Evidence Act, confession of an accused is admissible against under section 30 of the Evidence Act. Question number 307. The confession of an accused is only relevant against him. Which of the following section of the Indian Evidence Act 1872 is an exception to this rule? Option A, section 23, option B, section 25, option C, section 28, and option D, section 30. Correct answer here is option D, that is section 30 of the Indian Evidence Act. Question number 308. The case of Kashmira Singh versus State of Madhya Pradesh relates to privileged communications, tying declaration, confession to police officer, confession of a co-accused. Correct answer here is option D, that is confession of a co-accused. Question number 309. A and B were jointly tried for the murder of C. During the trial, A said B and I murdered C. What is the nature of this evidence against B? Option A, substantive evidence, option B, corroborative evidence, option C, hearsay evidence, and option D, direct evidence. Here correct answer is option B, that is corroborative evidence. Question number 310. In which one of the following cases Supreme Court held that confession of a co-accused are very weak evidence and no conviction can be based solely on such confession? Here options are Nathu versus State of UP, Ram Prakash versus State of Punjab, Kashmira Singh versus State of MP, and option D, none of the above. In question number 310, correct answer is option C, that is Kashmira Singh versus State of MP. Question number 311. Which is the correct proposition of law of evidence? Option A, a confessional statement made when there is a threat or inducement is irrelevant even after the removal of such threat or inducement. Option B, a confessional statement otherwise relevant is not relevant because it was made under promise of secrecy. Option C, a confessional statement otherwise relevant is not relevant because it was made when he was drunk. Option D, in case of a joint trial of several persons, when the confessional statement made by one of them affecting himself and others is proved, the court has power to consider such confession against such other persons as well as against the maker of such confession. Here correct answer is option D. Option D is the correct answer. Question number 312. The illustration that A and B are jointly tried for the murder of C. It is proved that A said B and I murdered C relates to. Correct answer is option A, that is section 30 of the Indian Evidence Act. Question number 313. Under which condition a court may take into consideration the confession of one accused against himself and another person? Option A, if they are tried jointly for the same offence. Option B, if they are tried jointly for different offences. Option C, if they are tried for the same offence but not jointly. And option D, if they are tried for different offences and not jointly. Correct answer here is option A, that is if they are tried jointly for same offence. Question number 314. A confession by accused can be used against a co-accused under section 30 of Evidence Act as hearsay evidence, only as corroborative evidence, as substantive evidence, none of the above. Correct answer is option B, that is only as corroborative evidence. Question number 315. A is on trial for the murder of C. There is evidence to show that C was murdered by A and B, and that B said A and I murdered C, as against A is against A is. This evidence is not to be taken into consideration as the evidence is hearsay, to be taken into consideration as it is direct. C, not to be taken into consideration as A and B are not being jointly tried, to be taken into consideration as A and B are accomplices. In question number 315, correct answer is option C, that is not to be taken into consideration as A and B are not being jointly tried. Question number 316. What is the evidentiary value of the confession of co-accused implicating himself as well as other non-confessing co-accused? Option A, such confession is relevant against all the co-accused. Option B, it shall not relevant against non-confessing co-accused. Option C, such a confession amounts to proof of guilt of the all co-accused. Option D, if the confession of co-accused is acquitted of the main offence, his confession shall cease to be admissible. Correct answer here is option A, that is such confession is relevant against all co-accused. Question number 317. Confession always goes against the maker of it provided it has been made freely and voluntarily. Reason: a confession is inadmissible against a co-accused. Here in question number 317, correct answer is option C, that is A is true but R is false. That is A confession always goes against the maker of it provided it has been made freely and voluntarily is true. A confession is inadmissible against co-accused is false. Question number 318. A and B are jointly tried to the murder of C. It is proved that A said B and I murdered C. What is the nature of confession against B? Option A, substantive evidence. Option B, only corroborative evidence. Option C, hearsay evidence. And option D, none of these. Here correct answer is option B, that is only corroborative evidence. Question number 319. X and Y are jointly tried for the murder of Z. It is proved that X said Y and I murdered Z. The confession of X is option A, may be taken into consideration against Y. Option B, may not be taken into consideration against Y because confession was made by X. Option C, may be taken into consideration or not, depends upon the facts of case. And option D, none of the above is the correct propositions of law. Here correct answer is option A, that is may be taken into consideration against Y. Question number 320. In which section doctrine of dying declaration is found? Here correct answer is option C, that is section 32. Question number 321. The principle on which a dying declaration is admissible under Indian Evidence Act 1872 is indicated in the legal maxim. Correct answer is option B, that is nemo mortibus prosecutor mentiri. Question number 322. The case of Pakla Narayan Swamy versus King Emperor relates to doctrine of estoppel, accomplice, dying declaration, cross-examination. Correct answer here is option C, that is dying declaration. The case of Pakla Narayan Swamy versus King Emperor relates to dying declaration. Question number 323. The Evidence Act relates for the exception of the hearsay rule under section 17 to 39, section 32 to 33, section 34 to 35 and all of the above sections. Here correct answer is option B, that is section 32 to section 33. Question number 324. A dying declaration, statement first, cannot form the sole basis of the conviction unless corroborated, is a weak kind of evidence, stand on the same footing as any other piece of evidence, has to be subjected a very close scrutiny of the reliability. Select the correct answer by using the quotes given below. Here in question number 324, correct answer is option C, that is 3 and 4. A dying declaration stand on the same footing as any other piece of evidence. Option 4 has to be subjected a very close scrutiny for reliability. Question number 325. Proviso of section 32 subsection 1 of Evidence Act are attracted where what is not true? Option A, the cause of death is required to be ascertained. Option B, the deceased statement is related to the cause of death. Option C, the circumstances connected with the death. And option D, verbal statement is not admissible. Here in this question it has been asked which of the following is not true. The statement D, the verbal statement is not admissible, is not true, therefore it will be the right answer. Question number 326. Kaushal Rao versus State of Bombay AIR 1958 is related with which topic of the law of evidence? Correct answer is option C, that is dying declaration. Question number 327. Dying declaration may be made to a doctor, magistrate, any other person, all of the above. Correct answer here is option D, that is all of the above. Question number 328. A dying declaration can form the sole basis of conviction without any corroboration by independent evidence. Option B, can form the basis of conviction only on the corroboration by independent witness. Option C, cannot form the sole basis of conviction and corroborated by the independent witness. Option D, only B and C are correct. Here correct answer is option A, that is can form the sole basis of conviction without any corroborated by independent evidence. Question number 329. Which one of the following case is directly related to section 32 subsection 1 of the Indian Evidence Act? Correct answer here is option B, that is Pakla Narayan Swamy versus King Emperor. Question number 330. To be admissible, a dying declaration must be made before to a magistrate, must be made before a police officer, must be made before a doctor, and option D, must be made to any person, a doctor, magistrate, friend or near relative is the correct answer. Question number 331. A dying declaration under section 32 of the Indian Evidence Act is admissible in evidence only when it is reduced in writing, only when it is made to a police officer, only when it is made to a judicial magistrate, only when it is made to a executive magistrate. Here correct answer is option B, only when it is made to a police officer. Question number 323. Which one of the following statement is correct? Option A, a dying declaration made under section 32 of the Indian Evidence Act 1872 is subject to the control of. Option A, section 164 of the CRPC. Option B, section 161 and 162 of the CRPC, section 52 and 54 of the Indian Evidence Act and section 158 of the Indian Evidence Act. In question number 332, correct answer is option D, that is section 158 of the Indian Evidence Act. Question number 333, which of the following is not a leading case on dying declaration? Correct answer here is option D, that is Deep Chand versus Rajasthan is not a leading case on dying declaration, whereas Kaushal Rao versus Bombay, Moti Singh versus State of UP and R versus Jenkins related to dying declaration. Question number 334. In which one of the following a dying declaration is admissible? In criminal proceedings only, in civil proceedings only, both in civil and criminal proceedings, in civil proceedings only with the permission of the court? Here correct answer is option C, that is both in civil and criminal proceedings. Question number 335. For the admissibility of a dying declaration, it is not necessary that it relates to the cause of death. The person making the statement must be under the expectation of death. The person making the statement must be competent. The statement must be complete. In question number 335, correct answer is option B. Here in this question it has been asked for the admissibility of dying declaration, it is not necessary. Option B is not necessary, that the person making the statement must be under expectation of death. Question number 336. Which one of the following is not a case of dying declaration? Here correct answer is option C, that is Sitaram versus State of UP is not a case of dying declaration, whereas Ratnam God versus State of Bihar, Paniben versus State of Gujarat and Kaushal Rao versus State of Maharashtra is related to dying declaration. Question number 337. Which of the following could be proved as dying declaration after the death of a person? Here correct answer is option D, that is FIR lodged by the person deceased, statement of the person deceased recorded under section 161 CRPC, statement of the person deceased recorded by the executive magistrate would come into the category of dying declaration after the death of the person. Here option D will be the right answer. Question number 338. Under section 32 of Indian Evidence Act, statement of a person who is dead to be admissible, option A must relate to the cause of his own death, option B may relate to the cause of someone else's death, option C may relate to the cause of his own death or someone else's death, and option D both B and C are correct. Here correct answer is option A, that is must relate to the cause of his own death. Question number 339. The form of dying declaration is immaterial. Question number 340. Which of the following could be proved as dying declaration after the death of a person? FIR lodged by the person deceased, statement of the person deceased to police recorded under section 161 CRPC, statement of the person deceased recorded by the executive magistrate, all of these. Here correct answer is option D, that is all of these. Question number 341. Necessity rule regarding the admissibility of evidence is contained in. Correct answer is option B, that is section 32 of the Indian Evidence Act. Question number 342. A dying declaration is relevant evidence under section 32 of the Evidence Act, notwithstanding it being hearsay evidence because, option B, if a person is dead and anything said by the person as to the cause of death is relevant, since the dead person cannot be brought before the court to testify, necessity makes it inevitable to admit the said statement. Correct answer here is option B. Question number 343. With respect to dying declaration under Indian Evidence Act 1972, choose the true statement about propositions. Propositions: percentage of burn injury alone would not determine the admissibility of the dying declaration. Absence of medical certificate as to fit state of body is a fit ground to throw the dying declaration. Third, opinion of the magistrate as to fit state of mind body would decide the reliability of the dying declaration. Here assertions are provided in the options A, B, C and D. In question number 343, correct answer is option C, that is first and third are correct and second is incorrect. First proposition is percentage of burn injury alone would not determine the admissibility of the dying declaration is correct. Opinion of magistrate as to fit state of mind body would decide the reliability of dying declaration is also correct, whereas absence of medical certificate as to fit state of body is a fit ground to throw the dying declaration is incorrect. Question number 344. In which of the following cases a statement need not to be in writing? Option A, for contradicting a witness under section 145 of the Evidence Act, a dying declaration, a statement used to refresh the memory of a witness, a statement which can be used under section 162 of CRPC. Here in question number 344, correct answer is option B, that is a dying declaration. Question number 345. Section 32 of Evidence Act does not speak of which of the following kinds of persons? Option A, person who is dead. Option B, person who cannot be found. Option C, person who is unwilling to give evidence. Option D, person who has become incapable of giving evidence. Here correct answer is option C, that is person who is unwilling to give evidence does not speak of the correct answer. Question number 346. A woman is raped and makes a statement that A raped her. 2 days later she commits suicide. Her statement regarding rape is admissible as dying declaration, not admissible as dying declaration, admissible as dying declaration only if there is some evidence directly connecting with her death with the incident of rape, and option D, none of the above. Here correct answer is option C, that is admissible as dying declaration only if there is some evidence directly connecting her death with the incident of rape. Question number 347. A dying declaration under section 32 of the Evidence Act is admissible in evidence. Option A, only when it is reduced in writing. Option B, even when it is made to a police officer. Option C, only when it is made to a magistrate. And option D, only when it is made in immediate presence of a doctor. Here correct answer is option B, that is even when it is made to a police officer. Question number 348. In which one among the following cases Supreme Court of India said that it is not an absolute rule of law that dying declaration must be corroborated by other evidence before it can be acted upon? Correct answer is option C, that is Kaushal Rao versus State of Bombay. Question number 349. The essential conditions for dying declaration to be relevant include the statement is made by a person as to the cause of his death, statement is made by a person as to any of the circumstances of the transaction which resulted in his death, and option C, third, person must have been under expectation of death at the time of making the statement. Which of the proposition are correct? Here correct answer is option A, that is first and second. First and second proposition is correct and third is incorrect. First and second propositions are statement is made by a person as to the cause of his death. Second, statement is made by a person as to any of the circumstances of the transaction which resulted in his death. These two propositions are correct. Therefore, option A will be the right answer. Question number 350. A dying declaration is admissible in evidence. Its admissibility is founded upon the principle of necessity. Here option A is the right answer, that is both A and R are true and R is the correct explanation of A. Question number 351. What is not correct for the admissibility of the dying declaration under section 32 clause 1 of the Indian Evidence Act? Option A, the person making statement must have died. Option B, statement must have been made as to cause of his death. Option C, it is not necessary the cause of death must be in question. D, it is not necessary that the statement must have been made in expectation of death. Here correct answer is option C, it is not necessary the cause of death must be in question. This is not correct for the admissibility of dying declaration under section 32 clause 1 of the Indian Evidence Act. Question number 352. Which of the following statement is not correct? Option A, the non-examination of the doctor endorsing the dying declaration does not have affect the evidentiary value of the dying declaration. Option B, non-signing of the dying declaration by a literate declarant unable to sign does not render the veracity of dying declaration doubtful. Option C, when the relatives of the declarant are present during dying declaration, the dying declaration would not be relevant. And option D, the statement recorded in FIR may be treated as dying declaration. Here in this question it has been asked which of the following is not correct. Option C is not correct. Other options are correct. Question number 353. When a person proves his own statement constituting admission, or it may be proved on his behalf, when it is relevant as dying declaration, when it is relevant as admission, when it is relevant as confession, when it is only an oral admission as to the content electronic record. Here correct answer is option A, when it is relevant as dying declaration. Question number 354. Telling his wife that P's wife had called him to receive payments due to him, K leaves his house. After 2 days, his dismembered body is found in a truck. In P's trial for murder of K, the statement made by K to his wife is option A, inadmissible. Option B, partly admissible. Option C, inadmissible as it does not directly relate to K's death. Option D, admissible as it relates to the circumstances of the transaction which resulted in K's death. Here correct answer is option D, that is admissible as it relates to the circumstances of the transaction which resulted in K's death. Question number 355. A, an injured person went to police station himself and lodged the FIR at police station. Thereafter, A died due to injuries recorded in the FIR. Which is dying declaration under these facts and circumstances? Option A, depends upon the court. Option B, FIR report is admissible in evidence only when it is being corroborated by other evidence. C, FIR report is itself a dying declaration. D, FIR report can never be a dying declaration. In question number 355, correct answer is option C, that is FIR report in itself a dying declaration. Question number 356. In which of the following dying declaration is not relevant? Option A, when the declarant in his declaration speaks about the circumstances which has led to his death. Option B, when the declarant in his declaration explains the reason of his death. Option C, when the declarant in his declaration speaks about the circumstances which led to the death of the other person. Option D, when the declarant had died after the declaration. Here correct answer is option C, when the declarant in his declaration speaks about the circumstances which led to the death of other person is not relevant. Question number 357. Which one of the following statement is correct for admissibility of evidence under section 32 clause 1 of the Indian Evidence Act? Option A, dying declaration must be in writing. Dying declaration must be made under the expectation of death. Dying declaration may be verbal. Dying declaration must be made to magistrate. Here in question number 357, correct answer is option C, dying declaration may be verbal. Question number 358. Immediately before dying, signs and gestures by a victim whose throat was cut by the accused in answers to put questions indicated the person who had wounded him are admissible under section 6, 7, 32, 33. Correct answer is option C, that is section 32. Question number 359. A dying declaration recorded by the police officer in the form of FIR before the death of the author without obtaining certificate as to his mental fitness cannot be treated as dying declaration, cannot be read in evidence, cannot be treated as dying declaration, cannot be admitted in evidence. Here correct answer is option C, that is can be treated as dying declaration. Question number 360. About 6 months before he was murdered, the deceased wrote a letter to SP Jabalpur asking for the protection and stating that he apprehended injury from A and was in fear of his life. The letter is admissible under section 5, 6, 8 and 32. In question number 360, correct answer is option D, that is section 32. Question number 361. Which of the following will be inadmissible dying declaration? Oral dying declaration recorded on the basis of nods and gesture, dying declaration by signs and gestures, none of the above. Here correct answer is option D, none of the above, all are admissible. Question number 362. A statement to become relevant under section 32 clause 1 of Indian Evidence Act as dying declaration should have been made under which of the following circumstances? It should have been made in relation to the succession to his property after his death. It should have been made under imminent expectation of death. It should be in relation to the cause of his death or circumstances of the transaction that resulted in his death. It should have been made in the will executed by him. In question number 362, correct answer is option C. It should be in relation to the cause of his death or circumstances of the transaction that resulted in his death. Question number 363. Under Indian Evidence Act 1872, a declaration made in the course of business is admissible under. Correct answer is option B, that is section 32 clause 2. Question number 364. In which of the following categories an opinion contained in the book of a deceased expert which is produced in evidence in a court is put? Oral evidence, documentary evidence, evidence under section 32, evidence as hearsay evidence. Here correct answer is option C, that is evidence under section 32. Question number 365. Which subsection of 32 of Indian Evidence Act makes the fact of relations between the parties who are not alive relevant? Subsection 1, subsection 3, subsection 5, subsection 6. Correct answer is option D, that is subsection 6. Question number 366. Relevant facts to consider a statement under section 32 of Evidence Act are when it relates to cause of death, when it relates to existence of relationship, when it is made in will or in deed relating to family affair, all of the above. Correct answer is option D, that is when it relates to the cause of death, when it relates to the existence of relationship, when it is made in will or in deed relating to family affairs, all of the above are the correct answer. Question number 367. Which of the following provisions of Indian Evidence Act permits evidence recorded in one case to be considered relevant in a subsequent proceeding? Correct answer is option D, that is section 33. Question number 368. Evidence of a witness in a previous proceeding would be admissible under section 33 of the Evidence Act only if the adverse party in the first proceeding had the right and opportunity to cross-examine the witness. The statement is true. Question number 369. In a suit after the cross-examination of a witness, the plaintiff was returned for presentation to the court of competent jurisdiction. Before proceedings started in the court, the witness died. His deposition is admissible under section 32, admissible under section 33, admissible under section 6, inadmissible in evidence. Correct answer is option B, that is admissible under section 33 of Indian Evidence Act. Question number 370. Under which of the following circumstances will the evidence given by the witness in a judicial proceeding by relevant subsequent proceedings under section 33 of Indian Evidence Act 1872, when the witness cannot be found, when the presence of the witness cannot be obtained without undue delay or unreasonable expense, when the witness is dead, and option D, all of the above. Here correct answer is option D, that is all of the above. Question number 371. In which of the following cases the evidence given by the witness will not be relevant under section 33 of the Evidence Act? Correct answer is option A, when the witness is staying abroad. Question number 372. Under section 33 of the Evidence Act, evidence of witness A recorded in an earlier judicial proceeding can be produced in another judicial proceeding where witness A is alive. Option B, witness A is alive and is incapable of giving evidence. Option C, criminal proceedings are pending against the witness A. Option D, there was no right but opportunity of cross-examination of A was granted in the first judicial proceeding. Here correct answer is option B, witness A is alive and is incapable of giving evidence. Question number 373. Relevant entries in the book of account alone, option A, are sufficient to charge any person with liability, cannot be taken into consideration in a criminal trial, are not sufficient to charge any person with liability, can help a judge in deciding a suit. Here correct answer is option C, that is are not sufficient to charge any person with liability. Question number 374. Which of the following is a leading case on entries in the books of accounts when relevant? Correct answer is option D, that is L.K. Advani versus CBI. Question number 375. A sues B for rupees 1000 and shows entries in his account book showing B to be indebted to him to this amount. The entry is not relevant, relevant, does not have evidentiary value, inadmissible. Correct answer here is option B, that is relevant. Question number 376. A sues B for rupees 1000 and shows entries in his accounts book showing B to be indebted to him to this amount. Under Indian Evidence Act, the entries are relevant but are not sufficient without other evidence to prove the debt. The entries are sufficient without other evidence to prove the debt. Option C, the entries are not relevant but are sufficient without other evidence to prove the debt. And option D, the entries are neither relevant nor sufficient to prove the debt. Here in question number 376, correct answer is option A, that is the entries are relevant but are not sufficient without other evidence to prove the debt. Question number 377. X sues Y for rupees 1 lakh and relies on entries in his accounts book showing Y to be indebted to him in this amount. To prove the debt, the mere entries are sufficient, the entries are not admissible and independent evidence has to be adduced. The entries are relevant but are not alone sufficient to establish the liability of Y. The entries cannot be relied upon. Correct answer is option C, that is the entries are relevant but are not alone sufficient to establish the liability of Y. Question number 378. In which section of Indian Evidence Act deal with proof of customary practices? Option A, section 34, 46, 47, section 33, 45, 48, section 35, 47 and 49, and option D, section 35, 48 and 49. Here correct answer is option D only, that is section 35, 48 and 49. Question number 379. Which of the following sections of Indian Evidence Act deals with the relevancy of statement as to any law contained in law books? Correct answer is option B, that is section 38. Question number 380. Which one of the following section of Indian Evidence Act has been substituted for the old section by the Information Technology Act 2000? Correct answer is option A, that is section 39. Question number 381. Section 40 to 44 of Indian Evidence Act deal with the relevance of characters, opinions of third persons, judgment, decree and orders. Statements made under special circumstances. In question number 381, correct answer is option C. Section 40 to 44 of Indian Evidence Act deal with the relevance of judgment, decree and orders. Question number 382. Under which of the following sections of Indian Evidence Act the previous judgments are relevant to bar a second suit or trial? Options are section 39, section 40, section 11, section 42. Correct answer is option B, that is section 40. Question number 383. The principle of res judicata provided in which of the following section of the Indian Evidence Act? Section 140, section 40, section 160, section 164. Correct answer here is option B, that is section 40. Question number 384. Under the Indian Evidence Act 1872, which of the following is an exception to the rule of res inter alias judicata mulam alias prejudicatum facit? Here correct answer is option C, that is section 41 and section 42, that is both A and B. Question number 385. The decision of a probate court is option A, a judgment in rem, B, judgment in personam, C, conclusive proof, D, foreign judgment. Correct answer here is option A, that is a judgment in rem. Question number 386. Which kind of jurisdiction is not mentioned under section 41 of the Indian Evidence Act 1872? Probate, admiralty, insolvency, revenue. Here correct answer is option D, revenue. Revenue jurisdiction is not mentioned under section 41 of the Indian Evidence Act, whereas probate, insolvency and admiralty jurisdiction is mentioned in section 41 of the Indian Evidence Act 1872. Question number 387. Which one of the following is a judgment in personam? Correct answer is option B, that is a final judgment in a suit for restitution of conjugal right is a judgment in personam, whereas a final judgment in a suit for divorce, a final judgment in a suit for insolvency, a final judgment in a suit for admiralty matters is judgment in rem. Question number 388. The presumption under section 41 of the Indian Evidence Act is a presumption of fact, a rebuttable presumption of law, a irrebuttable presumption of law, a presumption of law and fact. Correct answer is option C, that is an irrebuttable presumption of law. Question number 389. Under Indian Evidence Act, the judgments of Admiralty Court are relevant in. Correct answer is option C, that is section 41. Question number 390. A prosecutes B for stealing a cow from him. B is convicted. A afterwards sues C for the cow which B had sold to him before his conviction. The judgment against B is. Correct answer is option B, that is irrelevant between A and C. Question number 391. Which of the following judgment is irrelevant under section 43 of the Evidence Act? Judgment of an insolvency court, judgment of a matrimonial court, judgment of a probate court, judgment of a criminal court. Here in this question it has been asked which of the following judgment is irrelevant under section 43 of the Evidence Act. Correct answer is option D, that is the judgment of a criminal court. Question number 392. Which final judgment, order or decree of a competent court among the following is a judgment in rem? Option A, in a money suit. Option B, in a suit for permanent injunction. Option C, in exercise of matrimonial or insolvency jurisdiction. And option D, none of the above. Here correct answer is option C, that is in exercise of matrimonial or insolvency jurisdiction. Question number 393. Kalu prosecutes Khema for stealing a car from him. Khema is convicted. Kalu afterwards sues Ganesh for the car which Khema had sold to him before his conviction. The judgment of conviction of Khema in the suit between Kalu and Ganesh is relevant, irrelevant, relevant only with the prior permission of the court, and none of the above. Here correct answer is option B, that is irrelevant. Question number 394. A prosecutes B for adultery with C. Wife of A. B contested by denying the allegation. B was found guilty and convicted in the said case. Subsequently, C was prosecuted in charge of bigamy on allegations that she had married B during subsistence of her marriage with A. C contested by denying that she was ever married to A. In the case against C, the judgment in the first case against B is. Here correct answer is option B, that is irrelevant. Question number 395. The findings of the criminal court are inadmissible in a civil suit. Reason: acquittal or conviction in a criminal case has no evidentiary value in a subsequent civil litigation except for the limited purpose of showing that there was a trial resulting in acquittal or conviction, as the case may be. Here option A, both A and R are true and R is the correct explanation of A. Option B, both A and R are true but R is not the correct explanation of A. C, A is true but R is false, and D, A is false but R is true. In question number 395, correct answer is option A only, that is both A and R are true and R is the correct explanation of A. Question number 396. Evidence Act, judgment of a civil court is binding on the criminal court under all circumstances. The statement is false. Question number 397. A prosecutes B for stealing a cow from him. B is convicted. A afterwards sues C for the cow which B had sold to him before his conviction. What will be the importance of the judgment of B's conviction between the suit A and C? Here correct answer is option B, that is irrelevant. Question number 398. Any party to a suit may show that any judgment, decree or order which is relevant for a dispute under section 40, 41 and 42 of Indian Evidence Act and which has been proved by the adverse party is delivered by a court not competent to deliver it. Here correct answer is option A only. Question number 399. Relevancy of expert evidence for the purpose of Evidence Act is contained in. Correct answer is option C, that is section 45 to 48. Question number 400. The general rule is that the opinion or belief of a witness is irrelevant. Certain exceptions to this rule have been laid down in Indian Evidence Act. The sections contained these exceptions are option A, section 52 to 55, section 10 to 15, section 6 to 9 and option D, section 45 to 51. Option D here is the right answer. Question number 401. Under which section of the Indian Evidence Act the expert opinion is relevant? Here correct answer is option B, that is section 45. Question number 402. An expert under Evidence Act is a person, option A, who speaks fluent English, option B, expert in directing lies, option C, having requisite skills on a matter upon which he is giving opinion, and option D, none of the above. Here correct answer is option C. Question number 403. The opinion of expert is not relevant on a point of Indian law, on a point of foreign law, on the matters of science, on handwriting or finger impressions. Here in this question it has been asked is when the opinion of expert is not relevant. Option A, on a point of Indian law. Question number 404. Which one of the following is not a correct statement about the expert opinion? Here correct answer is option C. Expert opinion is binding on the judge always. It is not binding on the judge always, therefore it is not correct, therefore it will be the right answer. Whereas the other options are the opinion of expert is seldom conclusive is right. Facts which are irrelevant becomes relevant when they support the opinion of experts is also right. Evidence of experts is a suggestive piece of evidence is also right. Only option C is incorrect, therefore it will be the right answer. Question number 405. Who among the following is an expert under the Indian Evidence Act? Handwriting expert, finger experts, ballistics experts, all of the above. Correct answer obviously is option D, that is all of the above. Question number 406. Even a student may be treated as an expert under section 45 of Indian Evidence Act 1872. It was laid down by the Supreme Court in option number C, that is Kanpur University, Samir Gupta and others versus 1983 is a case related to which a student may be treated as an expert under section 45 of Indian Evidence Act. Question number 407. The report of medical officer stating the injuries of the victim is conclusive in nature, relevant and admissible in evidence, irrelevant, substantive piece of evidence. Correct answer here is option B, that is relevant and admissible in evidence. Question number 408. Under Indian Evidence Act, value of medical evidence is option A is only corroborative, is conclusive, is of no assistant, is conclusive even if contrary to credible and trustworthy evidence of eyewitnesses. Here correct answer is option A. Under Indian Evidence Act, the value of medical evidence is only corroborative. Question number 409. Opinion of an expert under section 45 of Evidence Act is a conclusive proof, is not a conclusive proof, is supportive and corroborative in nature, is not admissible. Here correct answer is option C, that is supportive and corroborative in nature. Question number 410. Under which sections of the Indian Evidence Act DNA test can be admitted in evidence? Option A section 47, option B section 45, option C section 48 and option D section 49. Here correct answer is option B, that is section 45. Under section 45 of Indian Evidence Act, DNA test can be admitted in evidence. Question number 411. A disputed handwriting can be proved by calling an expert, by examining a person acquainted with the handwriting of the writer of the questioned document, comparison of the two admitted and disputed documents, all of the above. Correct answer is option D. Question number 412. Under the provisions of section 45 of the Evidence Act, the opinion of an expert can be for identity of fingerprint, identity of handwriting, both A and B, neither A nor B. Correct answer is option C, that is both A and B. Question number 413. The opinion of expert may be obtained under section 45 of the Evidence Act in relation to. Correct answer is option D, that is science, art, foreign law, finger impressions, handwriting and signature. Question number 414. Opinion of handwriting expert always need in corroboration, is inadmissible in evidence, is always binding on courts, can be acted upon without corroboration. Here correct answer is option D. Opinion of handwriting expert can be acted upon without corroboration. Question number 415. Opinion of handwriting expert under the law of evidence in India is not relevant, relevant and is sole determinant of genuineness of the document, relevant but not sole determinant of genuineness of document, not clear. Here correct answer is option C, that is relevant but not sole determinant of genuineness of the document. Question number 416. A dispute regarding handwriting can be proved by dash, choose the most appropriate answer. Here options are calling an expert, option B examining a person acquainted with the handwriting of the question document, option C spouse and other relatives, and option D both A and B. Here correct answer is option D, that is both A and B. Calling an expert and examining the person acquainted with the handwriting of the question document. Question number 417. An expert is competent to testify on which of the following? Master of Science, questions of art, foreign law, all of the above. Correct answer obviously here is option D, that is all of the above. Question number 418. Mark the incorrect statement. A court may take the assistance of expert for forming opinion on point of foreign law, art, both A and B, neither A or B. Correct answer is option D, neither A or B. Court can take the assistance expert from the form opinion point of foreign law as well as art. Question number 419. In which of the following cases the opinion of expert is not relevant? Option A, a point of Indian law. Option B, a point of foreign law. Option C, matters of science or questions of art. Option D, handwritings or finger impressions. Here correct answer is option A, that is a point of Indian law. Question number 420. When is the opinion of experts relevant? Option A, when the court has to form an opinion of science or art. Option B, when the identity of handwriting or finger impressions is to be decided. Option C, when the opinion has to be formed upon a point of foreign law. And option D, in all the above matters. Here correct answer is option D, that is in all the above matters. Question number 421. Handwriting of A on document B can be proved by option A, the digital signature of A. Option B, the person who claims to have received document B purported to have been written by A. Option C, a person who in ordinary course of business has habitually received documents purported to have been written by A. And option D, a person who states that he is a friend of A. Here correct answer is option C, that is a person who in ordinary course of business has habitually received documents purported to have been written by A. Question number 422. When the court has to form an opinion as to the electronic signature of any person, the opinion of the certifying authority which has issued the electronic signature certificate is fact in issue, relevant fact, proved fact, none of the above. Here correct answer is option B, that is relevant fact. Question number 423. B, C and D never saw A writing, but they give their opinion about the handwriting of A. The opinion of which one is relevant? Here options are of B, because B is a merchant in Delhi. A has written many letters addressed to B. Of C, because C is a clerk of A. C's duty was to examine and files A's correspondence. Of D, because D is Z's broker to whom Z habitually submitted the letters purporting to be B written by A for the purpose of his advice. And option D, all of the above. Here option D is the correct answer. All the options are correct. Question number 424. The opinion of examiner of electronic evidence is a relevant fact under which provision of the Indian Evidence Act? Correct answer is option A, that is section 45A of Indian Evidence Act. Question number 425. Facts supporting or rebutting the opinion of experts are relevant under. Correct answer is option B, that is section 46 of the Indian Evidence Act. Question number 426. Where the handwriting of a teacher is in question, the opinion of his principal may be relevant under which section of the Indian Evidence Act? Correct answer is option A, that is section 47. Question number 427. Under which of the following sections of the Indian Evidence Act opinion as to digital signature is relevant? Here correct answer is option C, that is section 47A. Question number 428. Under section 47A of Indian Evidence Act, disputed electronic signature of any person can be proved by option A, all of these. Option B, opinion of expert. Option C, opinion of the certifying authority who has issued the electronic signature certificate. And option D, comparison of the electronic signature by the court itself. Here correct answer is option C, that is opinion of the certifying authority who has issued the electronic signature certificate. Option C here is the right answer, that is opinion of certifying authority who has issued electronic signature certificate under section 47A. Question number 429. The right of the villagers of a particular village to use the water of a particular well is a general custom or right within the meaning of one of the following sections of the Indian Evidence Act. Correct answer is option A, that is section 48 of Indian Evidence Act. Question number 430. Which one of the following sections of the Indian Evidence Act makes relevant opinion as to the existence of custom? Correct answer is option B, that is section 48. Question number 431. Under which section of Indian Evidence Act the opinion relating to relationship is relevant? Correct answer is option D, that is section 50. Question number 432. The relationship in section 50 of the Evidence Act means option A, relationship by blood only. Option B, relationship by blood or marriage. Option C, relationship by blood or marriage or adoption. And option D, none of the above. Here correct answer is option C, relationship by blood, marriage or adoption. Question number 433. Which one of the following sections of the IPC is expressly excluded by the proviso to section 50 of the Indian Evidence Act 1872? Options are section 354, section 354A, section 498A, section 497. Here correct answer is option D, that is section 497. Is expressly excluded by the proviso to section 50 of the Indian Evidence Act 1872. Question number 434. Under which one of the following sections of the Indian Evidence Act previous good character is relevant in criminal cases? Correct answer here is option D, that is section 53. Question number 435. According to the Indian Evidence Act, which one of the among is irrelevant? Option A, evidence of previous good character in criminal cases. Option B, evidence of previous bad character in reply to evidence of previous good character in criminal cases. Option C, evidence of character to prove the imputed conduct in civil cases. And option D, evidence of character to prove the imputed conduct in civil cases except when relevant. Here correct answer is option C, that is evidence of character to prove the imputed conduct in civil cases is irrelevant. Here option C is the right answer. Question number 436. Evidence are adduced by the parties to the suit about the character. As per the provisions of the Indian Evidence Act, which of the following are correct? Statement first. Evidence of the character in civil proceeding is irrelevant and inadmissible generally. Statement second. The character of evidence is admissible if it affects the amount of damages which he ought to receive. Third, the character evidence is admissible insofar as such character appears from the facts otherwise relevant. Select the correct answer by using the codes given below. Here correct answer is option D, that is 1, 2 and 3. All the options are correct. I am repeating all the options. Evidence are adduced by the parties to the suits about the character. As per the provisions of the Indian Evidence Act, which of the following is correct? Evidence of the character in civil proceedings is irrelevant and inadmissible generally. Correct. The character evidence is admissible if it affects the amount of damages which he ought to receive. The character evidence is admissible insofar as such characters appears to fact otherwise relevant. Here all the statements are correct. Question number 437. An expert may give an account of experiments performed by him for the purpose of forming his opinion under which section of the Indian Evidence Act? Here correct answer is option C, that is section 51 of the Indian Evidence Act. Question number 438. Which one among the following statement is not correct? Options are: in civil cases character to prove conduct is irrelevant. Option B, in civil cases previous good character is irrelevant. Option C, in civil cases character is affecting damages is relevant. And option D, in criminal cases previous bad character is irrelevant unless evidence has been given for good character. Here in this question it has been asked which of the following statement is not correct. Here option B is not correct, that is in criminal cases previous good character is irrelevant is incorrect. Question number 439. In respect of digital signature, which of the following is a relevant fact? Options are: that he himself recognizes his signature before the court. Option B, any other person recognizes his signature before the court. C, the court may direct that certificate of certifying authority may be produced in the court. And D, such digital signature is not admissible in any proceeding before the court. Here correct answer is option C, the court may direct that certificate of certifying authority may be produced in the court is the right answer. Question number 440. Which of the following statement is not relevant in a case where A is tried for murder? Here options are: that A quarreled with dead person 3 days before the incident. Option B, that A has purchased a knife 1 hour before the incident. Option C, that A is a man of good character. And option D, that A is a man of bad character. Here in this question it has been asked which of the following statement is not relevant in a case where A is tried for murder. Here option D is the correct answer, that A man of bad character is not relevant in case where A is tried for murder. Question number 441. In criminal cases under which section of the Indian Evidence Act previous good character of the accused is relevant? Correct answer is option D, that is section 53. Question number 442. In criminal cases, the fact that the person accused is of good character is a relevant fact. Question number 443. Character of a person for the purpose of law of evidence is not relevant in one of the following situation. Option A, previous good character of the accused in criminal cases, previous bad character in reply to evidence of good character in criminal cases, character as affecting the amount damages in civil cases. And option D, character as to prove conduct imputed in civil cases. Here in this question it has been asked character of a person for the purposes of the law of evidence is not relevant. Here correct answer is option D, character to prove conduct imputed in civil cases is not relevant. Question number 444. Which of the following statement is correct? Statement first: evidence of character in civil cases is irrelevant. Second, previous conviction is relevant as evidence of bad character. Third, evidence of good character is relevant in criminal cases. Fourth, word character includes reputation only. Here in question number 444, correct answer is option B, that is first, second and third are correct. Option fourth is not correct, that is Evidence of character in civil cases is irrelevant is correct. Previous conviction is relevant as evidence of bad character, correct. Evidence of good character is relevant in criminal cases is also correct, whereas the word character includes reputation only is incorrect. Question number 445. In criminal proceedings, under which of the following situations the fact that the accused person has bad character is relevant? Statement first, where the character of the accused is an issue when it affects damages, to rebut prior evidence of good character where the court is satisfied. Here correct answer is option D, that is first and third statement are correct. That is where the character of the accused is an issue, and third, to rebut prior evidence of good character. In both the situation, in criminal proceedings, the fact of that the accused person has bad character is relevant. Question number 446. Evidence of character includes evidence of disposition only, reputation only, general reputation and general disposition, particular acts by which reputation or disposition were shown. Here correct answer is option C, that is general reputation and general disposition is the correct answer. Question number 447. In criminal proceedings, the fact that the accused person has a bad character is irrelevant, relevant. Above A is correct unless evidence has been given that he has a good character. All the above are incorrect. Here correct answer is option C, that is A is correct. Irrelevant is unless evidence has been given that he has a good character. Option C is the correct answer. Question number 448. Which one of the following section of the evidence provides previous bad character of the accused is not relevant in criminal proceedings? Correct answer is option A, that is section 54 of the Indian Evidence Act. Question number 449. Which of the following statement is not true? In criminal proceedings, the fact that the accused is of good character is relevant. In criminal proceedings, the fact that the accused has a bad character is irrelevant. A previous conviction is relevant as evidence of bad character. In civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. Here correct answer is option B. In criminal proceeding, the fact that the accused has a bad character is relevant is not true. Question number 450. By which one of the following amendments section 53A has been inserted in the Indian Evidence Act 1872? Correct answer here is option D, that is Criminal Law Amendment Act 2013. By Criminal Law Amendment Act 2013, section 53A has been inserted in the Indian Evidence Act. Question number 451. Which provision of the Indian Evidence Act stipulates that the fact of a woman being habituated to sexual intercourse will not be relevant on the issue of consent in a prosecution for rape or outraging the modesty of the said woman? Here correct answer is option B, that is section 53A of Indian Evidence Act. Question number 452. Which of the following statement is not correct? Option A, in rape, evidence of previous good character of the accused is relevant. Option B, in rape trial, evidence of character of the victim is not relevant. Option C, in a rape trial, evidence of previous sexual experience of the victim is relevant. And option D, none of these. Here correct answer is option C, that is in rape trial, evidence of previous sexual experience of the victim is relevant is not correct. Therefore, it will be the right answer. Question number 453. Under which of the section of the Indian Evidence Act bad character of an accused is not relevant? Bad character of accused is not relevant under section 54 of Indian Evidence Act. Question number 454. Under section 54 of Indian Evidence Act 1872, previous bad character is irrelevant but becomes relevant if the bad character of the person is itself a fact, the bad character of the person is itself a fact and issue, the bad character is evidence to a previous conviction, both B and C, and option E, none of these. Here correct answer is option D, that is both B and C. Under section 54 of Indian Evidence Act 1872, previous bad character is irrelevant but becomes relevant if bad character of a person is itself a fact and issue, the bad character is evidence to a previous conviction. Question number 455. A person is prosecuted for theft. Evidence is sought to be produced to prove that the accused is of a bad character and suspect of theft on several occasions in the past. Option A, bad character is relevant. B, the evidence was admissible. C, the evidence was not admissible. D, none of the above. Here correct answer is option C, the evidence is not admissible. Question number 456. The term character as explained in section 55 of the Indian Evidence Act means good and bad character, reputation and disposition of general nature, reputation formed on the basis of particular disposition, character in a criminal act. Here correct answer is option B, that is reputation and disposition of general nature. Question number 457. Character as affecting damages has been discussed in which one of the following sections? Correct answer is option A, that is section 55 of the Indian Evidence Act. Question number 458. In criminal cases, the fact that accused is of good character is relevant. B. In criminal cases, the bad character of the accused is always irrelevant. Here correct answer is option C, that is both A and R are true and R is the correct explanation of A. Question number 459. Consider the following statements. Statement first. In criminal proceedings, good character of the accused is always relevant. Second, in criminal proceedings, bad character of the accused is always relevant. Third, in a civil case, evidence of character of any persons concerned is always admissible. Fourth, a previous conviction is relevant as evidence of bad character. Which of the following statement given above are correct? Here correct answer is option C. The statement first and the statement fourth is correct. Statement first is related to in a criminal proceedings, good character of the accused is relevant and a previous conviction is relevant as evidence of bad character. Therefore, statement C is the right answer. Question number 460. Mark the incorrect statement. Options are: evidence is always allowed of facts which are necessary to introduce the main fact or some relevant fact. B. Evidence can be given of facts which support or rebut an inference suggested by fact and issue a relevant fact. Facts which contradict the inference of guilt will also be relevant. Circumstances of the situations are not relevant to prove an identity. Correct answer here is option D. Here option D is incorrect, therefore it will be the correct answer. Question number 461. Which of the following statement given below is are correct? In civil cases, character to prove the conduct of imputed to a party is not relevant. In criminal proceedings, bad character of the accused is not relevant unless evidence of good character has been given. C. In criminal proceedings, previous conviction of the accused is relevant as evidence of bad character. All of these. Here correct answer is option D. Option D says that all the options are the correct. Question number 462. Relevancy and admissibility under the Indian Evidence Act are neither synonymous nor coextensive. Question number 463. Mark the incorrect statement. The term relevancy and admissibility are coextensive and interchangeable. The evidence must be relevant in order to be admissible. The facts which are relevant may not be admissible. That relevancy is the genus of which admissibility is a species. Here in this question, incorrect statement has been asked. The incorrect statement is the first statement, that is the term relevancy and admissibility are coextensive and interchangeable. This statement is incorrect, therefore it will be the correct answer. Question number 464. Indian Evidence Act deals with relevancy of evidence, reliability of evidence, admissibility of evidence. Select the correct answer by using the quotes given below. Here correct answer is option B, that is 1 and 3 only. Relevancy of evidence and admissibility of evidence. Question number 465. Exceptions to the rule against admissibility of hearsay evidence are provided in. Correct answer is option D, that is it provided under section 6 of the Indian Evidence Act, under section 32 and under section 34 of the Evidence Act. Therefore, all of the above statement will be correct. Question number 466. Which statement is not correct? Some facts are relevant but not admissible. Some facts are admissible but not relevant. All relevant facts are admissible and all admissible facts are not relevant. Here correct answer is option C. Option C, that all relevant facts are admissible is not correct. Whereas some facts are relevant but not admissible is correct. Some facts are admissible but not relevant is correct. And all admissible facts are not relevant is also correct. Question number 467. By the Information Technology Act 2000, amendment made in option A, section 17, option B, section 34, option C, section 35 of Indian Evidence Act, and option D, all of the above. Here correct answer is option D. Information Technology Act 2000 amendment made in section 17, section 34 and section 35 of the Indian Evidence Act. Question number 468. Which of the following pieces of evidence is not relevant under the Indian Evidence Act? Option A. A is accused of fraudulently delivering to another person a counterfeit coin which he knew to be counterfeit. Evidence is given that he was also in possession of other counterfeit coins. B. A sues B for damages done by B's dog which he knew to be ferocious. Evidence is given that the dog and the previously bitten X, Y and Z and that they had made complaints to B. C. A is charged with shooting at B with intent to kill him. Evidence is given that A had previously shot at B. D. A is tried for the murder of B by intentionally shooting him dead. Evidence is given that A was in the habit of shooting at people with the intent to murder him. In question number 468, correct answer is option D. A is tried for the murder of B by intentionally shooting him dead. Evidence is given that A was in the habit of shooting at people with intent to murder him. Here, this evidence is not relevant under Indian Evidence Act. Question number 469. The question between A and B is whether a certain deed is or is not forged. A affirms that it is genuine, B that it is forged. Here, correct answer is option A only. That is, A may prove a statement by B that deed is genuine and B may prove a statement that deed is forged. Option A is the right answer. Question number 470. A is accused of murdering B. The following facts are constructed in the case. An hour before the murder, A took B in his car to certain place. Second, A alone returned home. Third, A's clothes were found to be blood-stained. The evidence which takes into account the above mentioned facts is called. Correct answer is option A, that is circumstantial evidence. Question number 471. In the trial of murder of B by A, which fact is not relevant in the following? A was absconding immediately after the murder of B. A and B were seen together before murder. A borrowed ₹10,000 from B. On that day, A was in Bangalore while the murder happened in Indore. Here in this question it has been asked, in the trial of murder of B by A, which fact is not relevant in the following? Here correct answer is C. A borrowed ₹10,000 from B is not relevant. Question number 472. A is tried for the murder of B by poison. The fact that before the death of B, A procured poison similar to that which was administered to B is, here correct answer is option B, that is relevant. Question number 473. Tape recorded conversation is admissible in evidence if conversation is very important, conversation can save the culprit, conversation is relevant to the matters in issue but the voice unidentified, conversation is relevant to the matters in issue and the voice is identified. Here correct answer is option D. Tape recorded conversation is admissible in evidence if the conversation is relevant to the matter in issue and the voice is identified. Question number 474. Choose the true statement about propositions. Propositions are: evidence must be relevant as to the matters in issue, the best evidence must be given, it's all cases, circumstantial evidence cannot be admitted. Here assistants are: first and second are correct, third is incorrect, second and third are incorrect, first is correct, first and third are correct, second is incorrect, all are correct. Here correct answer is option A, that is first and second are correct, third is incorrect. First statement is: evidence must be relevant to the matters in issue, the best evidence must be given in all cases, circumstantial evidence cannot be admitted. Here third statement is incorrect and above the two statements are correct. Question number 475. Which of the following pairs is not correctly matched? Admission by a person having any proprietary interest, section 18 of the Indian Evidence Act. Confession made after removal of impression caused by inducement, section 28 of the Evidence Act. Admission by persons expressly referred to by party to suit, section 21 of the Evidence Act. Confession of an accused in police custody, section 26 of the Evidence Act. Here correct answer is option C. Admissions by person expressly referred by party to suit is not correctly matched pair, therefore C will be the right answer. Whereas admission by persons having proprietary interest, section 18, confession made by after removal impression caused by inducement, section 28, and confession of an accused in police custody, section 26 of the Indian Evidence Act is the correct match. But in this question, incorrect match is asked, so option C will be the right answer. Now let us proceed to question number 476. Match list first and list second. Facts as effective fact in issue. Correct answer here is section 7. Facts forming part of the same transaction. Correct answer obviously is section 6, that is res gestae. Facts which constitute preparation for any fact in issue. Correct answer is section 8. Facts necessary to explain or introduce relevant fact. Here correct answer is section 9. Facts necessary to explain or introduce relevant fact. Therefore, by going through these options, the correct match will be option C. Question number 477. Match the following and tick the correct code. Section 7. Cause of relevant facts is the right match. Section 8. Motive of relevant facts. Section 11, facts inconsistent with relevant fact, and section 14, facts showing the existence of any state of body is the correct match for option D. By going through these options, the correct match will be option B. Question number 478. Which of the following pairs is not correctly matched? Option A, relevancy of statements as to law contained in the law book, section 38 of the Evidence Act, is a correct match. Relevancy of statements in map, charts, etc., section 35 of the Evidence Act is incorrect match. Therefore, B will be the right answer. Let us see other options also. Relevancy of certain evidence for proving in subsequent proceedings the truth of facts therein stated, section 33 of the Evidence Act. Relevancy of statement as to facts of public nature, section 37 of the Evidence Act. These both are also true. Therefore, incorrect one is B only. So, B will be the right answer. Question number 479 is again the match of the following. Section 46, facts bearing upon opinion of experts. Section 47 of the Indian Evidence Act, opinion as to handwriting when relevant. Section 47A of the Indian Evidence Act, opinion to digital signature. And section 48 of the Indian Evidence Act is the last remaining option, that is opinion, existence of right or custom when relevant. By going through these matches, the correct match will be here option D. Question number 480. In Evidence Act, the facts of which judicial notice is to be taken are stated in. Correct answer is option C, that is section 57. Question number 481. Which one of the following sections of the Indian Evidence Act says facts admitted need not to be proved? Section 58. Question number 482. The court shall take judicial notice of foreign judicial records, national flag of a state not recognized by India, Stephen's Digest on Criminal Law, rule of road on land and in sea. Here correct answer is option D. The court shall take judicial notice of rule of road on land and in sea. Question number 483. A judicial admission operates as an admission, confession, a plea of ignorance, a waiver of proof. Correct answer here is option D, that is a waiver of proof. Question number 484. Under section 57 clause 1 of the Indian Evidence Act, the court shall take judicial notice of all laws in force in India, all laws including foreign laws, all Indian and Asian laws, all Indian and British laws up to 1950. Here correct answer is option A, that is all laws in force in India. Question number 485. Court can take judicial notice of that Amitabh Bachchan is a famous star, that M.F. Hussain is a veteran painter, that Bentham was a renowned jurist, none of the above. Here correct answer is option D. Question number 486. Consider the following statements. The proceedings of the Parliament or state legislatures of India are judicially noticeable facts. Rule of the road or land or at sea are not judicially noticeable facts. Criminal law in force in India is a judicially noticeable fact. Which of the above statement are correct? Here correct answer is option D, that is first and third. The proceedings of Parliament or state legislature of India are judicially noticeable fact, and criminal law in force in India is judicially noticeable fact. Question number 487. Which of the following facts are required to be proved? All laws in force in the territory of India, public festivals and holidays notified in the official gazette, the rule of the road, none of the above. Here correct answer is option D, that is none of the above. Question number 488. Which of the following facts need not to be proved? Option A, oral evidence, option B, documentary evidence, option C, facts taken in judicial notice by court, and option D, relevant fact. Here correct answer is option C, that is facts taken judicial notice by court. Question number 489. Facts judicially noticeable may be proved, need not to be proved, need to be proved, none of the above. Here correct answer is option B, that is need not to be proved. Question number 490. Which facts under the Evidence Act need not to be proved? Option A, those which are deemed to have been admitted, those which are judicially noticeable, those which are actually admitted, all of the above. Here correct answer is option D, that is all of the above. Question number 491. The court cannot take the judicial notice of which fact? Option A, any news item published in the newspaper, the existence of the titles recognized by the Government of India, the territories under the dominant of the Government of India, the rule of the road and land or at sea. Here correct answer is option A. The court cannot take judicial notice of any news item published in the newspaper. Question number 492. The facts of which the court must take judicial notes included gazetted holiday observed by the government of India, rule of road, neither A nor B, both A and B. Here correct answer is option D, that is both A and B. Question number 493. The term judicial notice under the Indian Evidence Act means notice given by the court, information given to the court to ask for evidence to recognize without proof something as existing. Here correct answer is option D, that is to recognize without proof something as existing. The term judicial notice under the Indian Evidence Act means to recognize without proof something as existing. Question number 494. Section 58 of the Evidence Act deals with formal admissions, evidentiary admissions, formal as well as evidentiary admissions, proof of facts by oral evidence. Here correct answer is option A, that is formal admissions. Question number 495. Facts which need not to be proved by the parties include facts which have been admitted by the parties or at or before the hearing, statements made on oath, any registered documents, statements made in plaint or in written statement supported by affidavit. Here correct answer is option A, facts which have been admitted by the parties at or before the hearing. Question number 496. Which of the following facts need not to be proved? Option A, the facts which are covered under the doctrine of res gestae, the facts which are written in the police statement, C, the facts which are admitted, and D, none of the above. Here in this question it has been asked which of the following facts need not to be proved. Here option C is the right answer. The facts which are admitted are need not to be proved. Question number 497. Under Evidence Act, which of the following facts need not to be proved? Option A, all laws in force in India, all public acts, proceedings of Parliament and Legislative Assemblies of India, all of them. Here correct answer is option D, all of them. Question number 498. Which of the following admissions are dealt with section 58 of the Indian Evidence Act? Admission in pleadings, admissions which can be implied from pleadings, admissions by the parties or agents at the time of the hearing, all of the above. Here correct answer is option D, all of the above. Question number 499. All facts except the contents of documents may be proved by primary evidence, secondary evidence, oral evidence, circumstantial evidence. Correct answer here is option C, that is oral evidence. Question number 500. Contents of documents under section 59 of the Indian Evidence Act 1872 can be proved by oral evidence, cannot be proved by oral evidence, may or may not be proved by oral evidence, can only be proved by oral evidence under the orders of the code. Here correct answer is option B, cannot be proved by oral evidence. Contents of the documents under section 59 of the Indian Evidence Act cannot be proved by oral evidence. Question number 501. Which of the following statement is not correct? Option A, no fact of which court will take judicial notice need to be proved. Facts admitted need not to be proved. All facts and the contents of the documents may be proved or by oral evidence. Oral evidence must be direct. In this question it has been asked which of the following is not correct. Here option C is not correct. That is all facts and contents of the documents may be proved by oral evidence is not correct. Therefore it will be the right answer. Question number 502. Oral evidence is allowed. Option A, only when it is given in court, even if it is given either in the court or elsewhere, when it is given both in trial and investigation, when it is given before a police officer in investigation. Here correct answer is option A, only when it is given in court, oral evidence is allowed. Question number 503. A witness who is unable to speak gives his evidence by writing in open court. Evidence so given shall be deemed to be a, here also correct answer is option A, that is oral evidence. Question number 504. Which of the following statement is correct? A, who has taken vow of silence, gives his evidence in writing in an open court. His evidence shall be deemed to be a oral evidence. Here option C is the right answer. Question number 505. Oral evidence under section 60 of the Evidence Act 1872 must in all cases be indirect, circumstantial, direct, may be presumed by court. Correct answer is option C, that is direct. Oral evidence must be direct under section 60. Question number 506. H says that Y told him that A killed B. This is option A, primary evidence, B, best evidence, C, hearsay evidence, D, admission. Here correct answer is option C, that is hearsay evidence. Question number 507. What is direct evidence? Choose the most appropriate answer. Evidence given where witness testifies directly his own knowledge as to the main fact or facts and disputes, that which needs to be proved the facts at issue, which without the intervention of proof of any other fact. One requiring support of other evidences when the principal fact or factum probandum is attested directly by witnesses, things or documents. Here courts are only first, second and fourth are correct, and B, all of them are correct. C, only first and second are correct, and D, only first, second and third are correct. Here correct answer is option A, that is only first, second and fourth are correct. That is evidence given where witness testifies directly his own knowledge as to the main fact or fact in dispute is correct. Second, that which tends to prove the fact as issue without intervention of proof of any other fact is correct. And the fourth one, when the principal fact or factum probandum is attested directly by witness, things or documents, is also correct. Whereas third, one requiring support of other evidence is not correct. Question number 508. Which one among the following statements according to the Indian Evidence Act is correct? Correct answer is option C, that is all facts except content of documents or electronic records may be proved by oral evidence. Here option C is the correct answer. Question number 509. Which of the following section of Evidence Act recognizes the principle hearsay evidence is no evidence? Correct answer is option A, that is section 60. Question number 510. What is not the main principle of the which underlines the law of evidence? Option A, the best evidence must be given in all cases. Evidence must be confined to the matters in issue. Hearsay evidence must not be admitted. Hearsay evidence must be admitted. Here in question number 510, correct answer is option D, hearsay evidence must be admitted. This is incorrect. It is not the main principle that underlies the law of evidence. That's why it is incorrect. And in this question, it has been asked which of the following is not correct. Therefore, option D will be the right answer. Question number 511. If X is charged with Y's murder, which of the following will be a hearsay evidence? Option A, Z in his evidence states that I saw X stabbing Y with a knife. Option B, evidence of A that Z told me that he had seen X stabbing Y. Option C, both A and B, and option D, none of the above. Here correct answer is option B, that is evidence of A that Z told me that he had seen X stabbing B is be a hearsay evidence. Option B is the correct answer. Question number 512. Under the law of evidence, the term hearsay is used with reference to what is done, written, spoken, all of these. Correct answer is option D, all of these. Question number 513. Which of the following is not a hearsay evidence? Option A, statement of police that on the basis of inquiry conducted by him, the accused was not at home on the night of incident. Report of the newspaper, report prepared on the basis of the information provided by the officer, statement of witness to prove the relationship between the persons. Hence question number 513, correct answer is option A. Option A is not the hearsay evidence. Question number 514. The details of an incident printed in a newspaper as categorized as documentary evidence, indirect evidence, hearsay evidence, relevant evidence. Correct answer is option C, that is hearsay evidence. Question number 515. A informs B that he had heard from X that Z has committed murder of C few days ago. Evidence of B when examined as a witness in court would be considered as direct evidence, hearsay evidence, circumstantial evidence and expert evidence. Here correct answer is option B, that is hearsay evidence. Question number 516. Hearsay evidence is generally inadmissible. However, in which of the following cases it is admissible? Option A, res gestae. Option B, admissions and confession. Option C, dying declaration. Option D, all of these. In all of these cases, hearsay evidence will be admissible. Question number 517. Which one of the following is not a document under the Indian Evidence Act? Option A, an inscription on a stone of a building, a photograph, a printout of a message sent through mobile or computer, a knife recovered by police from the possession of an accused and produced in the court. Here correct answer is option D. Question number 518. In which one of the following cases hearsay evidence is not admissible? Option A, statement of experts expressed in treatise if the author is dead or cannot be found, where eyewitness told the facts to another person, statement of that person, if the statement of a deceased person when it relates to cause of his death, if the statement is part of the transaction in issue. Here correct answer is option B, where eyewitness told the facts to another person, statement of that person. Question number 519. Chapter 5 of the Indian Evidence Act deals with, correct answer is option B, of documentary evidence. Question number 520. Contents of the documents are proved by option A, primary or secondary evidence, examining by a witness not seen the document, by taking extraneous evidence into consideration without any evidence. Here correct answer is option A. Contents of a documents are proved by primary or secondary evidence. Question number 521. According to section 61 of the Indian Evidence Act, the contents of a documents may be proved by primary evidence, secondary evidence, both A and B, neither A or B. Here correct answer is option C, both A and B, that is primary evidence and secondary evidence. Question number 522. Section 62 of the Indian Evidence Act deals with primary evidence, secondary evidence, proof of documents by primary evidence, cases in which secondary evidence relating to the documents may be given. Here correct answer is option A, that is primary evidence. Section 62 of the Indian Evidence Act deals with primary evidence. Question number 523. which is considered as the best evidence? Hearsay evidence, primary evidence, real evidence, secondary evidence. Here correct answer is option B, that is primary evidence is considered to be the best evidence. Question number 524. Primary evidence means and includes oral accounts of the contents of the documents by a person who has seen the original document, true copy made from and compared with the original documents by a private party, none of the above. Here correct answer is option B, the original document. Question number 525. Which one of the following is a primary evidence? Option A, copies made from original. B, documents produced for the inspection of the court. Certified copies of a document. Photostat copies of a document. Here correct answer is option B, that is documents produced for the inspection of court. Question number 526. Which one among the following statement is not correct according to the provisions of the Indian Evidence Act? Options are: where the document is executed in several parts, each part is primary evidence of the document. B, where a document is executed in counterpart, each counterpart is primary evidence as against the parties executing it. C, where a document is executed in counterpart, each counterpart is primary evidence for the parties executing it. D, where the document itself produced before the court for its inspection, its primary evidence of the document. Here in question number 526, it has been asked which among the following statement is not correct according to the provisions of the Indian Evidence Act. Correct in here option C is the correct answer. C is not correct, therefore it will be the correct answer. Question number 527. Where a number of documents are all made by one uniform process, as in the case of printing, lithography or photography, each is primary evidence of the contents of the rest. Question number 528. A document can be proved by producing it before the court, by examining the party who has produced it, by examining the person whose handwriting the document is written or signed, by examining the person in whose favor the document is executed. Here correct answer is option A. A document is proved by producing it before the court. Question number 529. Where a document is executed in several parts, option A, each part is primary evidence of the document is correct answer. Question number 530. Which of the following is a primary evidence? Option A, copies made from the compared with the original, counterpart of documents as against the parties who did not execute them, counterpart of a document against the parties who executed it, certifies copies of document. Here in this question it has been asked which of the following is a primary evidence. Option C, that is counterpart of a document as against the parties who executed, is a primary evidence. Question number 531. Which one of the following is called primary evidence? Photograph of original, certified copies, oral accounts of the document, handwritten letter. Option D is the right answer. Handwritten letter is a primary evidence. Question number 532. Under the Indian Evidence Act, what is not a primary evidence? Document made by printing, document made by lithography, document made by photography, document of copies of common original. Here in this question it has been asked which of the following is not a primary evidence. Option D here is not the primary evidence, that is document copies of common original is not a primary evidence. Question number 533. Which of the following is not a primary evidence? Printing, lithography, photography, certified copies. Correct answer is option D. Certified copies is not a primary evidence, whereas printing, photography, lithography is a primary evidence. Question number 534. Which one among the following is not a primary evidence? A documents executed in several parts, a copy made from or compared with original, documents executed in counterparts, document made by one uniform process. Here in this question it has been asked which of the following is not a primary evidence. Option B here is the right answer. A copy made from or compared with original is not a primary evidence. Question number 535. The primary evidence in respect of a document which is prepared in many original copies will be: first original copy, all original copies, all copies are secondary evidence, none of the above. Here correct answer is option B, that is all original copies. Question number 536. A document prepared in two copies and A alone signed one copy while B alone signs the other. A then hands to B the document signed by himself and B hands to A the document signed by himself. With respect to this and as prescribed under section 62 of the Indian Evidence Act 1872, choose the true propositions. Here options are: both the copies are primary document, both documents executed by A is primary evidence against B, document executed by A is primary evidence against A as well as B, document executed by B is primary evidence only against B. Here in this question correct answer is option D. Question number 537. A carbon copy of the injury report prepared by a doctor by one uniform process by which the original was prepared may be admitted as secondary evidence, primary evidence, direct evidence, circumstantial evidence. Correct answer here is option B, that is primary evidence. Question number 538. Which one among the following is not a primary evidence? A document executed in several parts, a copy made from or compared with the original, document executed in counterparts, documents made by one uniform process. Here correct answer is option B. A copy made from or compared with original is not a primary document. Question number 539. What is primary evidence? Option A. The commissioner prepared a report and signed it, a copy of medical certificate prepared from the original, a photocopy of the will, enlargement of a photo from another photo. Here correct answer is option A. The commissioner prepared a report and signed it is a primary evidence. Question number 540. Which section of the Indian Evidence Act provides that contents of the document must be proved by primary evidence? Correct answer here is option D, that is section 64. Question number 541. Which one among the following sections relates to secondary evidence? Here correct answer is option C, that is section 63. Section 63 is relates to secondary evidence. Question number 542. Photocopies of a document made from the original are primary evidence, secondary evidence, hearsay evidence. None of the above is correct. Here correct answer is option B, that is secondary evidence. Question number 543. When a photograph in original is prepared without being compared, the photograph is primary evidence, secondary evidence, not admissible, admissible but not as reliable. Here correct answer is option B, that is secondary evidence. Question number 544. Which one among the following is not a secondary evidence? Copies made from the original by mechanical process, copies made from or compared with the original, counterparts of documents, lithography. Here correct answer is option D, that is lithography is not a secondary evidence. Question number 545. Copies made from or compared with the original is primary evidence, secondary evidence, inadmissible evidence, none of these. Here correct answer is option B, that is secondary evidence. Question number 546. Secondary evidence includes certified copy of a court's judgment, oral account by any person of a document who has seen it, copies prepared or compared with originals, all of the above. Here correct answer is option D, that is all of the above. Question number 547. Secondary evidence is admissible when the non-production of the primary evidence has not been accounted for. Where the non-production of the primary evidence has been accounted for, irrespective of whether the non-production of a primary evidence has been accounted for or not. And option D, both A and C are correct. Here correct answer is option B, that is where the non-production of the primary evidence has been accounted for. Secondary evidence will be admissible then. Question number 548. Secondary evidence includes certified copies of the original documents, copies made from the original by mechanical process, copies made compared from the original, all of these. Here option D is the correct answer. Question number 549. Secondary evidence of a document means copies of that document, oral accounts of the contents of the document, both A and B and neither A or B. Here correct answer is option C, that is both A and B. Secondary evidence of a document includes copies of that document, oral account of the contents of the document. Both A and B is the correct answer. Question number 550. Under Indian Evidence Act, a copy compared with a copy of a letter made by copying machine is primary evidence, oral evidence, secondary evidence, any of the above. Here correct answer is option C, that is secondary evidence. Question number 551. Which of the following is not a secondary evidence? Certified copies of a public document, copies made from or compared with the original, counterparts of a document as against the parties who did not execute them, oral accounts of the contents of a document given by some person who has himself not seen it. In question number 551, correct answer is option D, that is oral contents of the documents of a given by some person who has himself has not seen is not a secondary evidence. Question number 552. Out of the following, which is not a secondary evidence? Copies made from the original by mechanical process, copies made from or compared with the original, oral accounts of the contents of a document given by a person who has himself seen it, oral account of a photograph. Here in this question, it has been asked which of the following is not a secondary evidence. Correct answer is option D. Oral account of photograph is not a secondary evidence. Question number 553. Oral account to the contents of a document by a person who has seen it. Testimonial evidence, primary evidence, secondary evidence, circumstantial evidence. Correct answer here is option C, that is secondary evidence. Question number 554. An item of evidence which is not a secondary evidence is copies made from the original, copies compared with the original, oral accounts of the contents of a document given by a person who has himself seen it, counterpart of the document against the person who executed it. In question number 554, correct answer is option D. Counterpart of a document is against the person who executed is not a secondary evidence. Question number 555. Which one of the following sections of the Indian Evidence Act provides for the admissibility of secondary evidence? Here correct answer is option D, that is section 65. Question number 556. Secondary evidence of the contents of a document is not admissible when? Correct answer is option D, that is the original has been found to be inadmissible. Question number 557. In which of the following secondary evidence is relating to a document cannot be given? Option A, when the original document shown to be a possession of the person against whom the document is sought to be proved. Option B, when the original document is in the possession of the person who wants to prove it, when the original document is lost without any default or negligence on the part of the person who wants to prove it. And option D, when the original document is of such nature which cannot be easily moved. In question number 557, correct answer is option B. Secondary evidence relating to a document cannot be given when the original document is in possession of the person who wants to prove it. Question number 558. In which of the following cases secondary evidence of the contents of the documents cannot be given? Option A, when the original is in the possession of the person out of reach of the process of the court, when the original has been destroyed, when the document is registered one and may be produced before the court, when the original is of such nature as not to be easily movable. Here correct answer is option C, that is when the document is registered one and may be produced before the court. Question number 559. In which of the following cases secondary evidence may be given of the existence, condition or contents of a document? Option A, when the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved. Option B, when the original is shown or appears to be in the possession or power of the person out of the reach of the court, when the original is shown or appears to be in the possession or power of the person not subject to the process of the court. In all of the above cases. Here in question number 559, correct answer is option D, that is in all of the above cases. Question number 560. A sues B on an agreement and gives B notice to produce it. At the trial, A calls for the document and B refuses to produce it. A gives secondary evidence of its contents. B seeks to produce the document itself to contradict the secondary evidence by A. Option A, he cannot do so. Option B, he can do so with the consent of the other party. He can do so with the order of the court, both B and C. In question number 560, correct answer is option D, that is both B and C. He can do so with the consent of the other party. He can do so with the order of the court. Question number 561. In which of the provisions of Evidence Act special provisions as to evidence relating to electronic record was added? Correct answer here is option A, that is section 65A and 65B. Question number 562. Which provisions of the Evidence Act relate to admissibility of electronic records in evidence? Here correct answer is option C, that is section 65 and 65B. Question number 563. In which section of the Indian Evidence Act special provision is mentioned regarding evidence relating to electronic record? Correct answer is option C, that is under section 65A. Question number 564. Under which of the following section of Indian Evidence Act the contents of electronic record may be proved? Here correct answer is option B, that is section 65B. Question number 565. Special provisions as to evidence relating to electronic record were inserted in the Indian Evidence Act 1872 in the form of section 65B with effect from 1710-2000. Question number 566. This presumption that a computer output shall be taken to have been produced by a computer is contained in? Correct answer is option C, that is section 65B subsection 5 clause C. Question number 567. Under subsection 5 clause C of section 65B in Indian Evidence Act, a computer output shall be taken to have been produced by a computer, whether it was produced by it directly or with human intervention by means of any appropriate equipment. Here option C is the correct answer. Question number 568. In the Indian Evidence Act, the conditions in respect of computer output to be deemed admissible in evidence as document contained in option A, section 65B clause 4, section 65B clause 1, section 65B clause 2, section 65B clause 5. Here correct answer is option C, that is under section 65 clause B subsection 2. Question number 569. A certificate under section 65B of Indian Evidence Act which was inserted by the Information Technology Act 2000 must contain the following. Here options are identification of the electronic record containing the statement sought to be given in evidence, describe the manner in which the electronic record was produced, signature of a person occupying a responsible official position in relation to the operation of the relevant device or management of the relevant activities, all of the above. Here option D is the right answer, which says all of the above. Question number 570. Which one of the following section under Indian Evidence 1872 has been inserted by section 92 and schedule 2nd of the Information Technology Act 2000? Correct answer is option C, that is section 67A. Question number 571. Under Indian Evidence Act, the provision of proof related to electronic signature is contained in. Correct answer is option A, that is section 67A. Question number 572. For proving execution of a registered will, it is necessary to call at least 2 attesting witnesses. It is necessary to call at least 1 attesting witnesses. Not necessary to call any attesting witness. It is necessary to call the registrar. Here correct answer is option B. It is necessary to call at least 1 attesting witnesses. Question number 573. Under Indian Evidence Act, a document required by law to be attested can be proved by calling both the attesting witnesses, at least one of the attesting witnesses, any other person, a legal heir of the attesting witnesses. Here correct answer is option B, that is at least one of the attesting witness. Question number 574. If no attesting witness can be found, it must be proved that attestation of one attesting witness is at least is in handwriting, signature of the person executing the document is in handwriting of that person, both A and B, none of the above. Here correct answer is option C, that is both A and B. If no attesting witness can be found, it must be proved that attesting of one attesting witness at least is in handwriting, signature of the person executing the document is in handwriting of that person. Here option C is the correct answer. Question number 575. If the attested witness denies or does not recollect the execution of the document, its execution may be proved by other evidence under dash of the Indian Evidence Act. Correct answer is option D, that is under section 71 of the Indian Evidence Act. Question number 576. In which of the following documents would need to be compulsorily proved by an attesting witness regardless of whether its execution has been denied? Option A registered general power of attorney, a registered sale deed, a registered will, all of the above. Here correct answer is option C, that is a registered will. Question number 577. Under which provision of law can court direct any person to write any words or figures for comparison of handwriting? Here correct answer is option C, that is section 73 of the Indian Evidence Act. Question number 578. In which of the following cases constitutionality of section 73 of the Evidence Act was challenged for violation of Article 20 Clause 3 of the Constitution? Correct answer is option A, that is State of Bombay versus Kathikalu. Question number 579. Who among the following can compare the disputed handwriting with the admitted writing of the party? Option A, the court. Option B, a handwriting expert. Option B, by anyone familiar in the handwriting of the person concerned, any of the above. Here correct answer is option D, that is any of the above. The court, a handwriting expert, by anyone familiar with the handwriting of the person concerned. Question number 580. Under which section of the Indian Evidence Act the court can itself compare the handwriting of a person? Correct answer is option C, that is section 73 of the Indian Evidence Act. Question number 581. When the court obtains a sample of handwriting or signature of a person under section 73 of the Indian Evidence Act 1872, the court itself may compare the same or may refer to an expert under section 45, cannot refer it to an expert under section 45, must refer the same to an expert under section 45. Here correct answer is option B, itself may compare the same, may refer to an expert under section 45. Question number 582. Which of the following section defines public documents? Correct answer is option C, that is section 74 defines public documents. Question number 583. Whether following documents are public documents: relating to acts or records of acts of the sovereign authority, public record kept in state of private documents, both A and B, none of the above. Here correct answer is option C, that is both A and B. Question number 584. Which of the following document is a public document? Only the documents forming records of acts of the sovereign authority. Option B, only the documents forming the records of the acts of official bodies. C, only the public records kept in any state of private documents, all of these. Here option D is the correct answer. Question number 585. Which of the following is not a public document within the meaning of Evidence Act? Here options are: decree passed in a civil suit, caste certificate issued by a competent authority, judgment of a high court, AGD certificate issued by a medical practitioner. Here in this question it has been asked which of the following is not a public document. Here option D is the correct answer. Injury certificate issued by medical practitioner is not a public document. Other options are the public document. Question number 586. Which one of the following is not a public document? Option A document forming the acts of a sovereign authority, a document forming the acts of official body, a document forming the acts of officer of the government of India, a document forming the acts of an employee of an education institution. Here correct answer is option D, a document forming the acts of an employee of an education institution is not a public document. Question number 587. Which one of the following is not a public document? Option A, an unregistered family settlement, a registered sale deed, judgment of High Court, judgment of civil judge. Here in this question it has been asked which of the following is not a public document. Option A here is not a public document, that is an unregistered family settlement. Question number 588. Public documents includes record of tribunal, record of court, record of public officers, all of the above. Correct answer is option D, that is all of the above. Question number 589. Which one among the following statement is correct? A public document is a document which has been executed by a member of public, has been made public, has been addressed to the public in general, was executed by a public servant in public capacity. Correct answer here is option D, that is has been executed by a public servant in public capacity. Question number 590. Which one of the following is not a public document? Here, insurance policy is not a public document, whereas letters between authorities, electoral list and order sheet in the judicial process is a public document. Question number 591. Which of the following is not a public document? Will, public records kept in any state of any private documents, judgment of the court, arrest warrant. Correct answer is option A. A will is not a public document, it is a private document. Question number 592. Which is not a public document? Documents forming the records of the acts of foreign country, documents forming the records of tribunal, documents forming the records of the Commonwealth, documents forming the records of will written by the governor or state. Here correct answer is option D. Documents forming the records of will written by the governor or state is not a public document, whereas document forming the records of acts of foreign countries is a public document, document forming the records of tribunal is also public documents, and documents forming the records of the Commonwealth is also public document. Question number 593. Which one of the following is not a public document? Option A, a document forming the acts of a sovereign authority, a document forming the acts of an official body, a document forming the acts of public officer of India, a document forming the acts of an employee of an educational institution. Here correct answer is option D. A document forming the acts of an employee of an educational institution is not a public document. Question number 594. Which is not a public document? Orders of a competent authority fixing price of commodities, an order issuing search warrant, a crop cutting report by collector, plaint or written statement in a suit. Here correct answer is option D. Plaint or written statement in a suit is not a public document. Question number 595. Which of the following is not a public document? Affidavit, judgment of the court, arrest warrant, will. A will is not a public document. Option D here is the right answer. Question number 596. Section 74 of the Indian Evidence Act deals with testamentary document, non-testamentary document, personal document, public document. Correct answer here is option D, that is public document. Section 74 of the Indian Evidence Act deals with the public document. Question number 597. Mark what is not a public document within the meaning of the expression used in the Evidence Act. Option A, the records of the motor accident claims tribunal. Option B, the registrar of private documents maintained in the office of sub-registrar under the Registration Act, the record of proceedings of the House of the People maintained in the Lok Sabha Secretariat. Option D, pronote executed by A while taking loan from the money lender. Here correct answer is option D. Pronote executed by A while taking loan from the money lender is not a public document. Question number 598. Which is not a public document? Record of tribunal, record of municipal board, memorandum of association of a company, none of the above. Here correct answer is option D, that is none of the above. Question number 599. Which of the following is not a public document? Records of a nationalized bank, a post-mortem report, a private waqf deed recorded in the office of sub-registrar, entries made by a police officer in site inspection, map and site memo. Here correct answer is option B. A post-mortem report is not a public document. Other given options are related to public documents. Question number 600. A private document kept as a public record of the state comes under the category of public document, private document, both public and private document, none of the above. Correct answer here is option A, that is public document. A private document kept as a public record of the state comes in the category of public document. Question number 601. Section 75 of the Indian Evidence Act 1872 deals with public documents, private documents, certified copies of public documents, proof of other official documents. Here correct answer is option B, that is private documents. Question number 602. What is a private document? Option A, document executed in a family, secret document, document in custody of a private person, document other than a public document. Correct answer is option D, that is document other than a public document is a private document. Question number 603. Public document under the Indian Evidence Act 1872 can be proved by oral evidence, the writer of the certified copy, any of the above. Correct answer is option C, that is certified copy. Question number 604. The procedure for getting certified copy of a public document is set forth in. Correct answer is option B, that is section 76 of the Evidence Act. Question number 605. What type of secondary evidence relating to a public documents may be given? Oral evidence about the contents, certified copy of the document, photostat copy, written admission. Correct answer is option B, that is certified copy of the document. Question number 606. Choose the correct option under the Indian Evidence Act. Judicial notice, section 87. Private document, section 75. Admission, section 48. Accomplice, section 132. Here we have to choose the correct option. Correct answer here is option B. Private document is in section 75. Question number 607. Under which section of the Evidence Act provisions for the presumption as to gazettes in electronic form has been made? Correct answer is option A, that is section 81A of the Indian Evidence Act. Question number 608. Section 81A was added in the Indian Evidence Act by the Information Technology Act 2000 to provide the presumption as to electronic agreements, electronic messages, electronic records, gazettes and electronic forms. Correct answer here is option D, gazettes and electronic forms. Question number 609. Which of the following is correct? There is a presumption that maps of various states and union territories made by the Survey of India are accurate. There is a presumption that map prepared by a registered architect for the purpose of civil disputes is accurate. Both A and B, neither A or B. Correct answer here is option A, that is there is a presumption that maps of various states and union territories made by the Survey of India are accurate. Question number 610. Due execution and authentication of a power of attorney shall be presumed under section 85 of the Evidence Act when executed before and authenticated by a notary, judge, a magistrate. Here option D is the correct answer, all of the above. Question number 611. Which one of the following sections of the Indian Evidence Act 1872 is related to presumption as to electronic agreement? Correct answer here is option D, that is section 85A is related to presumption as to electronic agreement. Question number 612. Presumption as to electronic records and electronic signatures is provided in option A, that is section 85B of Evidence Act. Question number 613. Which kind of agreement can be presumed by the court under section 85A of the Indian Evidence Act? Written agreement, oral agreement, electronic agreement, none of the above. Correct answer here is option C, that is electronic agreement. Question number 614. Under section 85C of the Indian Evidence Act, the presumption as to electronic signature certificates correctness, the court may presume, shall not presume, may not presume. Correct answer is option B, that is shall presume. Question number 615. The provisions relating to presumption as to telegraphic message is embodied in the Indian Evidence Act section. Correct answer is option D, that is section 88. Question number 616. Which of the following is an example of may presume? Presumption as to electronic record, presumption as to digital signature certificate, presumption as to electronic messages, presumption as to electronic agreements. Correct answer here is option C. Presumption as to electronic message is an example of may presume. Question number 617. Which provision of Evidence Act relates to presumption as to documents 30 years old ancient documents? Here correct answer is option B, that is section 90 of Indian Evidence Act. Question number 618. 30 years old document if produced from a proper custody, court shall presume its execution, court may presume its execution, presumed not involved, none of the above. Correct answer here is option B, court may presume its execution. Question number 619. Period of 30 years under section 90 of the Evidence Act is to be reckoned from the date on which the document is relied upon, the date on which the document is filed in the court, the date on which the document is tendered in evidence when its genuineness becomes a subject of proof, all of the above. Here correct answer is option C, that is the date on which the document is tendered in evidence when its genuineness becomes a subject of proof. Question number 620. Execution of a document may be presumed if the document is to be old. Correct answer is option C, that is 30 years. Question number 621. Section 90 of the Indian Evidence Act applies to testamentary documents, non-testamentary documents, testamentary and non-testamentary documents, none of the above. Correct answer here is option C, that is testamentary and non-testamentary documents. Question number 622. A document said to be in the handwriting of A, that document is produced from proper custody. If the document is purporting or proved to be 30, 15, 20 years, 12 years old, court may presume that is in A is handwriting. Here correct answer is option A, 30. Question number 623. 30-year-old document is produced from a proper custody. Here court may presume its execution. Question number 624. The presumption under section 90 of the Evidence Act can be drawn in respect of original documents only, certified copies only, uncertified copies only, all of the above. Correct answer here is option A, that is original documents only. Question number 625. In case where a document proved to be 30 years old is produced from proper custody, which of the following presumptions will the court make? Option A, the court makes irrebuttable presumption that the contents of the documents is true. The court shall presume that the person who had custody of the document is the executor of the document. The court may presume that the signature and the handwriting is the signature and the handwriting of the person to be and was duly executed and attested. The court shall not make any presumption as to its validity or its execution. Here correct answer is option C. The court may presume that the signature and handwriting is the signature and handwriting of the person to be and was duly executed and attested. Option C is the correct answer. Question number 626. Due execution of a document more than 30 years old coming from proper custody is a rebuttable presumption of law, presumption of fact, irrebuttable presumption of none of the above. Correct answer here is option B, that is presumption of fact. Question number 627. How many years old electronic record will be deemed to be proved if it is proved from any custody which the court in particular case considers proper? Correct answer here is option A, that is 5 years. Question number 628. When a document purporting to be a power of attorney duly authenticated as required by law is produced. Here correct answer is option C. The court shall presume its execution and authentication. Question number 629. Under Indian Evidence Act 1872, reports published in the newspaper are no evidence at all. Here option D is the right answer. Question number 630. Which of the following is the best evidence? Documentary evidence, direct evidence, hearsay evidence, circumstantial evidence. Correct answer here is option B, that is direct evidence. Question number 631. Electronic record presented for inspection of the court under Indian Evidence Act 1872 is a documentary evidence. Question number 632. Match list first and list second. List 1. Presumption as to books, maps and charts. Correct answer here is section 87 of the Indian Evidence Act. Presumption as to power of attorney. Correct match here is section 85 of the Evidence Act. Presumption as to telephonic messages. Correct answer here is section 88 of the Evidence Act. And presumption as to plans made by the authority of government. Correct match is section 83 of the Evidence Act. Question number 633. Presumption as to gazettes in electronic form. Here correct answer is section 81A of Indian Evidence Act. Presumption as to maps or plans made by authority of government. Correct match here is section 83 of the Indian Evidence Act. Presumption as to genuineness of certified copies. Correct match here is section 79. And presumption as to documents produced as record of evidence. Here correct match is section 80 of Indian Evidence Act. By going through these options, correct match here will be option A. Question number 634. Which of the following is not correctly matched? Presumption as to contents, presumption as to documents of 30 years old, section 90 of Indian Evidence Act is a correct match. Burden of proving that person alive who has not been heard for 7 years, section 108 of Indian Evidence Act is also correct. Dumb witness, section 119 of Indian Evidence is correct. Presumption as to dowry death, section 113A is not correct. Here incorrect is option D. Question number 635. Written document must be proved by writing only. This maxim has been incorporated under which of the following sections of the Indian Evidence Act? Correct answer here is option B, that is section 91. Question number 636. Section 91 of the Evidence Act applies to only to the transactions which under the law must be in writing, only to the transactions which are reduced in writing, both A and B, none of the above. Here correct answer is option C, that is both A and B. Question number 637. Best evidence rule is exclusively associated the rule laid down in. Correct answer is option D, that is section 91 of the Evidence Act. Question number 638. Bar of exclusion of oral evidence by documentary evidence under section 91 and 92 of the Indian Evidence Act 1872 applies when fact to be proved would invalidate the document, when fact to be proved shows in what manner the language of the document was related to existing facts, when fact to be proved relates to want or failure of consideration when the fact to be proved relates to terms of contract reduced in form of document. Here correct answer is option D. Question number 639. Which of the following sections are based on the principle of superiority of documentary evidence to oral evidence? Correct answer is option D, that is section 91 and 92. Question number 640. Which of the following observations is correct? Section 91 and 92 of the Indian Evidence Act may not be abrogated by special law. Section 91 does not apply. Section 92 also does not apply. The law of estoppel does not override section 91 to 94 of the Indian Evidence Act. Section 91 and 92 apply even if there is no completed and binding contract. Here in this question it has been asked which of the following observation is correct. Observation B is correct. Where section 91 does not apply, section 92 also does not apply. Option B is the right answer. Question number 641. Section 91 of the Evidence Act prohibits admission of oral evidence to prove the contents of a document where writing is a fact and issue. Option B here is the right answer. Question number 642. Where a bill of exchange is drawn in a set of 5, how many of them need to be proved? Correct answer here is option C, that is 1. Question number 643. Assertion A gives B a receipt for money paid by B. Oral evidence is offered for the payment. The evidence is admissible. Reason: the receipt is not a contract or grant in respect of which the oral evidence is barred. Here option A is the correct answer, that is both A and R true and R is the correct explanation of A. Question number 644. A gives B receipt of money paid by B. Oral evidence is offered to prove the statement. The evidence is admissible, the evidence is not admissible. Section 90 of the Indian Evidence Act deals with this aspect, none of the above. Correct answer here is option A, the evidence is admissible. Question number 645. Point out the incorrect statement. If a contract is contained in several letters, all the letters in which it is contained must be proved. If a contract is contained in a bill of exchange, the bill of exchange must be proved. If a bill of exchange is drawn in a set of 3, one only need to be proved. Option D. If A gives B a receipt for money paid by B, oral evidence is offered of the payment, the evidence is not admissible. Here incorrect statement which has been asked is D. Therefore D will be the correct answer. Other statements are correct. Question number 646. A agrees in writing to sell a horse to B for rupees 1000 or rupees 1500 to show which price was to be given under Indian Evidence Act. Evidence can be given, evidence cannot be given. Evidence can be given by the court's permission, can be proved as secondary evidence. Correct answer here is option B, that is evidence cannot be given. Question number 647. Section 92 of the Evidence Act is applicable to disputes between the parties to the instruments only, two strangers where the document is in question, the party to the instrument and stranger, all of the above. Here correct answer is option A. Section 92 of the Evidence Act is applicable to the disputes between the parties to the instrument only. Question number 648. Section 92 of the Evidence Act applies to bilateral documents, unilateral documents, both A and B, either A or B. Correct answer here is option A, that is bilateral documents. Question number 649. Oral evidence of fact invalidating the document is admissible under. Correct answer here is option A, proviso 1 to section 92 of the Evidence Act. Question number 650. Any fact may be proved which would invalidate any document or which would entitle any person to any decree or order relating to thereto, such as fraud, intimidation or illegality, want of due execution or want of capacity in a contracting party, want or failure of consideration, mistake of fact or law, all of the above. Here correct answer is option D, that is all of the above. Question number 651. Section 91 and 92 of the Evidence Act should be read together. These two sections supplement each other. Here correct answer is option A, that is both A and R are true and R is the correct explanation of A. Question number 652. A agrees in writing to sell a horse to B for rupees 1000 or rupees 1500. Here option B is the correct answer. Evidence cannot be given to show which price was to be given. Question number 653. A and B make a contract in writing that B shall sell a house to be paid for delivery. At the same time, they make an oral agreement that 3 months credit shall be given to A. Can evidence of this oral agreement be given in court? Option A, yes, by A against the third party. Yes, A by A against B or vice versa? Yes, by a third party against A or B. Yes, by a third party only if he is affected against A or B. Here correct answer is option D, that is yes, by third party only if he is affected against A or B. Question number 654. A sells a horse and verbally warrants him sound. A gives B a paper in these words, bought of A horse rupees 500. Whether B can prove the verbal warranty? Option A, yes. Option B, barred under section 92 of the Evidence Act. C, no. D, under section 91 of the Evidence Act only written documents can be proved. Here correct answer is option A, that is yes. Question number 655. Which of the following facts can be proved under section 92 of the Evidence Act? Correct answer is option A, that is A enters into a written statement. A enters into a written contract with B to work certain mines, the property of B on certain terms. A says that he was induced to do so by a misrepresentation of B as to their value. Question number 656. An estate called the Rampur Tea Estate is sold by a deed which contains a map of the property sold. The fact that land not included in the map had always been regarded as a part of the estate and was meant to pass the deed. This fact can be proved, cannot be proved, proved by the court's permission, proved by secondary evidence. Correct answer here is option B, that is cannot be proved. Question number 657. Mistake referred to in proviso 1 to section 92 of the Indian Evidence Act refers to unilateral mistake only, mutual mistake only, unilateral and mutual mistake, none of the above. Correct answer here is option C, that is unilateral and mutual mistake. Question number 658. A policy of insurance affected on goods in ships from Calcutta to London. The goods are shipped in a particular ship which has been lost. The fact that particular ships was already accepted from the policy can be proved, cannot be proved, can be partly proved, none of these. Here correct answer is option B, that is cannot be proved. Question number 659. Oral evidence is not admissible to clarify the language used in a document when the language is ambiguous or defective on its face. Here option A is the correct answer. Question number 660. When the language used in a document is on its face ambiguous or defective dash of facts which would show its meaning or supply its defects. Correct answer is option D, that evidence may not be given. Question number 661. A agrees to sell to B his white horse in writing. A has 2 white horses and it becomes uncertain as to which horse was sold. Here in the document therein. Option A, patent ambiguity, latent ambiguity, no ambiguity, none of the above. Here correct answer is option B, that is latent ambiguity. Question number 661. A agrees to sell B his white horse in writing. A has 2 white horses and it becomes uncertain as to which horse was sold. Here the document there is latent ambiguity. Question number 662. A as a sculptor agrees to sell B all my mods. A has both models and tools. Whether evidence can be adduced to show his intention. Here correct answer is option A, that is yes. Question number 663. Latent ambiguity is a document means ambiguity of hidden character and for clarification of which oral evidence may be given. Question number 664. In which chapter of the Indian Evidence Act provisions regarding burden of proof are codified? Correct answer here is option D, that is chapter 7 of the Indian Evidence Act. Question number 665. The provisions relating to burden of proof has been provided under. Correct answer is option C, that is section 101 to 114A of the Indian Evidence Act. Question number 666. Section 100 to 111 of the Evidence Act lays down provisions regarding those who is to lead evidence and prove the case. These rules are called rules relating to burden of proof. Option A is right answer. Question number 667. The burden of proof means the obligation to prove a fact. This is defined under section 101 of the Indian Evidence Act. Question number 668. Which one of the following is correctly matched under the Indian Evidence Act? Burden of proof, section 101. Here option A is the correct answer. Question number 669. Which section of the Evidence Act is not on shifting of burden of proof? Correct answer is option A, that is section 101. Question number 670. In every criminal trial, option A, the accused must prove his innocence. The accused must cross-examine defense witness. The prosecution alone has to prove the charge against the accused. The prosecution can rely on the lapses of the defense case alone to prove the charges. Here correct answer is option C. In every criminal trial, the prosecution alone has to prove the charge against the accused. Question number 671. The burden of proof under section 102 of the Indian Evidence Act always shifts. A is the right answer. Question number 672. The burden of proof in a suit for proceeding lies on that person who would fail if no evidence at all were given on other side. This provision is contained in which section of the Indian Evidence Act? Correct answer is option B, that is section 102 of the Indian Evidence Act. Question number 673. In criminal proceedings, the burden of proof is on the prosecution to prove the guilt of the accused, on the accused to prove his innocence, on both the parties. Court decides on whom the burden of proof lies. Correct answer here is option A. In criminal proceedings, the burden of proof is on the prosecution to prove the guilt of the accused. Question number 674. Burden of proof under section 101 of the Indian Evidence Act never shifts. Question number 675. Consider the following statements. In criminal proceedings, the burden of proof is on the prosecution to prove the guilt of the accused person, on the accused to prove his innocence. Here correct answer is option 1 only, that is on the prosecution to prove the guilt of the accused person. Question number 676. A desires a court to give judgment that he is entitled to certain land in the possession of B or on the basis of certain facts. B denies them to be true under section 101 of the Evidence Act. Correct answer here is option C. A must prove the existence of those facts. Question number 677. A sues B for which B is in possession and which A, as A asserts, was left to A by the will of C, B's father, to whom the burden of proof lie. Correct answer is option B, that is A. Question number 678. A desire of court to give judgment that B shall be punished for a crime which A says B has committed. According to the Indian Evidence Act 1872, the burden of proof is on A under section 101 of the Indian Evidence Act. Question number 679. In election petition, the burden of proof lies on option B is the right answer, the person who challenged election. Question number 680. A is tried for the murder of B. He takes the plea of self-defense, but the evidence adduced by him is not sufficient to put his case under the exception, although it is enough to create doubt whether the charge against him has been positively proved. In this case, option A is guilty of murder because he has not discharged his burden of proof. A is guilty of culpable homicide not amounting to murder because his case falls under the exceptions of section 300. Option C, A has committed no offence because self-defense is a recognized ground on exemption from the criminal liability. And option D, A is entitled to acquittal as the prosecution has failed to prove his guilt beyond reasonable doubt. In question number 680, correct answer is option D, that is A is entitled to acquittal as the accused has failed to prove his guilt beyond reasonable doubt. Question number 681. The principle of proving beyond reasonable doubt applies to criminal proceedings only, civil proceedings only, evidence law, all the civil and criminal proceedings. Correct answer is option A, that is criminal proceedings only. Question number 682. The burden of proof in a suit proceeding lies on that person who would fail if no evidence at all were given on either side. This provision is contained in which section of the Indian Evidence Act? Correct answer is option C, that is section 102 of the Indian Evidence Act. Question number 683. A sues B for land of which B is in possession and which, as A asserts, was left to A by the will of C, B's father. If no evidence were given on either side, B would be entitled to retain his possession applying section 102 of the Evidence Act. Option A, the burden of proof is on A. Question number 684. X sues Y for money due on a bond. The execution of the bond is admitted, but Y says that it was obtained by fraud, which X denies. The burden of proof is on. Correct answer is option A, that is Y. Burden of proof is on Y. Question number 685. A prosecuted B for theft and wishes the court to believe that B admitted the theft to C. Who shall have to prove the admission? Correct answer is option C, that is A. Question number 686. Plea of alibi can be established under dash of the Evidence Act. Correct answer is option C, that is section 103 of the Evidence Act. Question number 687. A wishes to prove dying declaration by B. A must prove B's death. Which section of the Indian Evidence Act provides so? Correct answer is option C, that is section 104 of the Indian Evidence Act. Question number 688. A wishes to prove a dying declaration by B. The burden of proof that B is dead is on by A. Question number 689. Burden of proving the existence of exceptions is put on the accused by the Indian Evidence Act 1872 under section 102, 103, 105, 106. Correct answer is option C, that is section 105 of the Indian Evidence Act. Question number 690. Section 105 of the Evidence Act is intended to apply to which of the following? Criminal trials, civil suit, both A and B, neither A nor B. Correct answer is option A, that is criminal trials. Question number 691. In criminal trial, the onus is on the accused to prove that his case falls in any of the general exception, any of the special exceptions, any of the proviso to any provision, all of the above. Here correct answer is option D. Question number 692. To prove the case of alibi, the burden lies on the prosecution, complainant, witness, accused. Correct answer here is option D, that is accused. Question number 693. A. Accused of murder alleges that by grave and sudden provocation he was deprived of the power of self-control. B. Denies this fact. Here the burden of proof is on A. Question number 694. The burden of proving that the case of the accused comes within any of the general exception is in IPC is upon the accused. Question number 695. Section 105 of the Evidence Act requires that the court presume the absence of such circumstances which brings a case within the purview of the general exceptions of the IPC. Must, shall, may, ought to. Correct answer here is option B, that is shall. Section 105 of Evidence Act requires that the court shall presume the absence of such circumstances which brings a case within the purview of the general exceptions in the IPC. Question number 696. Under Indian Evidence Act, in a trial, the burden of proving the plea of insanity of the accused lies is on. Correct answer is option B, that is accused. Question number 697. Which section of the Indian Evidence Act is related to the doctrine of res ispa liquator? Correct answer here is option C, that is section 106. Question number 698. Any person in section 106 of the Indian Evidence Act refers to a party to the suit, a stranger to the suit, a witness, none of the above. Correct answer is option A, that is a party to the suit. Question number 699. A is charged with travelling on a railway without a ticket. The burden of proving that he had a ticket is on accused. Question number 700. A. Traveller while travelling has been asked for the ticket by the ticket checker. The traveller replies he has purchased the ticket. Ticket checker prosecutes the traveller for travelling without ticket. In this case, under which section on whom the burden of proof lies will be determined. Correct answer is option A, that is section 106. Question number 701. Which of the following section of the Evidence Act deals with burden of proving fact, especially within knowledge? Option A, section 105, option B, section 106, option C, section 107, and option D, section 108. Correct answer here is option B, that is section 106. Question number 702. When any fact is especially within the knowledge of accused, the burden of proving the fact is upon accused, prosecution, either accused or prosecution, none of the above. Correct answer here is option A, that is accused. Question number 703. The principle that possession is prima facie proof of ownership is provided under which of the following section of the Indian Evidence Act? Correct answer is option C, that is section 110 of the Indian Evidence Act. Question number 704. Section 111 of the Evidence Act speak of such situations where one person stands in a position of dash to the other person. Here correct answer is option C, that is active confidence. Question number 705. The good faith of a sale by a client to an attorney is in question in a suit brought by the client. A. The burden of proving the good faith of the transaction is on the attorney. The burden of proving the good faith of the transaction is on the client. Both A and B, none of the above. Correct answer here is option A, that is the burden of proving the good faith of the transaction is on the attorney. Question number 706. According to the Indian Evidence Act, which one among the following circumstances is not correct? Here options are: when it is shown that a plaintiff was alive within 30 years, the burden proving that he is dead is on the person who affirms it. Option B, when it is shown that a person was not heard for 7 years by those who would naturally have heard of him if he had been alive, the burden of proving that he is alive is on the person who affirms it. Option C, when it is shown that a person is in possession of anything, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. And option D, when it is shown that one person stands to the other in a position of active confidence, the burden of proving the good faith of a transaction between them is on the party that respond confidence in the other. Here in this question it has been asked which of the following is not correct. So here option D is not correct. That's why it will be the right Other options are correct. Question number 707. Rules as to burden of proof are rebuttable presumptions of law, irrebuttable presumptions of law, rebuttable presumption of fact, irrebuttable presumption of fact. Correct answer here is option A, that is rebuttable presumptions of law. Question number 708. Burden of proof is lightened by presumption, admissions, estoppel, all of the above. Correct answer here is option D, that is all of the above. Burden of proof is lightened by presumption, admissions, estoppel, all of the above. Question number 709. Match list first with list second. Burden of proof is provided under section 101. On whom the burden of proof lies? Section 102. Burden of proof as to particular fact, section 103. Burden of proving fact especially within the knowledge, section 106. By going through these options, correct option here will be option C. Question number 710. The presumption of continuance of life is contained in, here correct answer is option B, that is section 107 of the Indian Evidence Act. Question number 712. For presumption of death under section 108 of the Indian Evidence Act, the person is shown to be not heard for a period of, correct answer is option B, that is 7 years. Question number 713. The question is whether a man is alive or dead, and it is proved that he has not been heard or for 7 years by those who would naturally have heard of him if he had alive. To whom the burden of proof will lie? Option A, all of them. Option B, the person who affirms it. Here option B will be the right answer, the person who affirms it. Question number 714. Section 108 of the Evidence Act provides that when a man has not been heard or for 7 years by those who would dash have naturally heard of him if he had been alive, the burden of proving that he is alive shifts on the person who affirms it. Here correct answer is option A, that is naturally have heard of him. Question number 715. A man is alive unless nothing has been heard about him for 7 years. Correct answer is option A, that is it is presumption of law. Question number 716. The man who has disappeared and remained unheard or for 7 years by those who would have naturally heard of him if he was alive, the presumption then arises that he is dead. What shall be the presumption as to the time of death of such person? Here correct answer is option C, that is those who allege that the death should have taken to have occurred at a particular time will have to prove the fact. Question number 717. Legitimacy of child born during valid marriage is presumed under which provision of the Indian Evidence Act? Correct answer is option C, that is section 112 of Indian Evidence Act. Section 112 of the Indian Evidence Act provides for, correct answer is option D, that is presumption of legitimacy. Question number 719. In case a child is born within 280 days of dissolution of marriage, the mother remaining unmarried, the presumption of legitimacy of child under section 112 of Evidence Act arises. Here correct answer is option C, that is irrespective of whether the father is alive or dead on the day the child is born. Question number 720. Which of the following provisions of the Evidence Act 1872 provides irrebuttable presumption? Here correct answer is option D, that is section 112. Section 112 of Indian Evidence Act is irrebuttable presumption. Question number 721. Section 112 of the Evidence Act applies when there is a dispute regarding maternity of child, paternity of child, both A and B, either A or B. Correct answer here is option B, that is paternity of child. Question number 722. Unless non-access is proved, the presumption as to legitimacy of any child born during the continuance of a valid marriage between his mother and any man is rebuttable presumption of law, presumption of fact, mixed presumption of law and fact, irrebuttable presumption of law. Correct answer here is option D, that is irrebuttable presumption of law. Question number 723. Presumption under section 112 of the Evidence Act is raised. Option A, when a child is born during the continuance of a valid marriage, when a child is born within 280 days of dissolution of marriage, the mother remaining unmarried in both A and B, neither A or B. Here correct answer is option C, that is both A and B. Section 1, presumption under section 112 of Evidence Act is raised when a child is born during the continuance of a valid marriage and when a child is born within 280 days of dissolution of marriage, the mother remaining unmarried. Question number 724. The rigor of conclusive presumption of legitimacy under section 112 of the Indian Evidence Act can only be rebutted by option A, DNA testing about paternity, non-access of parties, the fact that the wife was observing the menstrual period, The fact that a wife has undergone tubectomy recently. Here correct answer is option B, that is non-access of parties. Question number 725. Even for a child immediately after marriage, presumption of legitimacy under section 112 of the Evidence Act would apply. Reason: the legislature will extended the period of operation of the presumption by 280 days after the dissolution of marriage, did not choose to exclude any minimum initial period for maternity for the application of the presumption. Here correct answer is option A, that is both A and R are true, and R is the correct explanation of A. Question number 726. Legitimacy of a child born during the continuance of a valid marriage or within 280 days after its dissolution, mother remaining unmarried under section 112 of the Evidence Act is conclusive proof. Question number 727. Unless non-access is proved, the presumption as to the legitimacy of any child born during the continuance of a valid marriage between his mother and any man is. Here correct answer is option C, that is conclusive proof. Question number 728. Read the following statements carefully. Option A. The presumption of legitimacy of child is governed by section 112 of the Indian Evidence Act. B. Narendra Nath Pahadi versus Ram Govind Pahadi is the leading case on the legitimacy of child born during the continuance of a valid marriage. Here correct answer is option C, that is both A and R are true. Question number 729. If a child is born within dash days after the dissolution of a valid marriage, it is a conclusive proof of the legitimacy of child. Here correct answer is option C, that is 280 days. If a child is born within 280 days after the dissolution of a valid marriage, it is a conclusive proof of the legitimacy of child. Question number 730. Select the most appropriate statement. A child born during marriage is a conclusive proof of legitimacy. A child born during marriage may be presumed as a legitimate child. A child born during marriage shall be considered as a conclusive proof of legitimacy unless rebutted. No presumption will be drawn about a child born during marriage. Here correct answer is option C. A child born during marriage shall be considered as a conclusive proof of legitimacy unless rebutted. Question number 731. Under which section of the Indian Evidence Act the presumption as to abetment of suicide by a married woman is dealt? Here correct answer is option A, section 113A of the Indian Evidence Act. Question number 732. Under section 113A of the Evidence Act, court dash presume under presume, and under section 113B of the Evidence Act, the court dash presume. Here correct answer is option A. Under section 113A of the Indian Evidence Act, the court may presume, and under section 113B of the Evidence Act, the court shall presume. Question number 733. Court will presume an abetment of a suicide by a married woman when it is shown that she committed suicide within a period of dash of her marriage. Here correct answer is option C, that is 7 years of her marriage. Question number 734. In case of suicide by a married woman, the court under section 113A of the Indian Evidence Act may presume that suicide had been abetted by her husband if suicide was committed by the wife within a period of 7 years from the date of her marriage, wife was subjected to cruelty, the wife was illiterate and from a poor family, the wife was deserted by her husband. Select the correct answer by using the code given below. Here in question number 734, correct answer is option D, first and second. Suicide was committed by the wife within a period of 7 years from the date of her marriage, and the wife was subjected to cruelty. Here in this case, suicide by a married woman, the court under section 113A of the Indian Evidence Act may presume that suicide has been abetted by her husband. Question number 735. Section 113A of the Indian Evidence Act was added in the year 1983. Question number 736. Presumption under section 113A of the Evidence Act pertains to dowry death, custodial death, abetment of suicide by a married woman, absence of consent in prosecutions for rape. Here correct answer is option C, abetment of suicide by a married woman under section 113A of the Indian Evidence Act. Question number 737. Presumption as to abetment of suicide by a married woman under section 113A of the Evidence Act. The prosecution has to prove a conclusive proof. The court may presume, the court shall presume. Here correct answer is option C, the court may presume. Question number 738. The presumption under section 113A of the Evidence Act not attractive if the marriage took place more than 7 years prior to the suicide of woman, even if the cruelty is established by the prosecution. By the introduction of section 113A of the Indian Evidence Act, the prosecution is not required to prove the facts beyond reasonable doubt against the accused. Which of the following statement is correct? Option A, statement A, option B, statement B, option C, statement A and B, and option D, none of these statements. Here correct statement is only statement A. Question number 739. Presumption as to dowry death are laid down in. Here correct answer is option B, that is section 113B. Presumption as to dowry death has been laid down in section 113B. Question number 740. The presumption under section 113B of the Indian Evidence Act 1872 can be raised only if essential ingredient of section 304B of IPC are proved. Here option A is the right answer. Question number 741. Section 113B, presumption as to dowry death, was added to the Indian Evidence Act in. Correct answer is option A, that is 1986. Question number 742. Which one of the following section of the Indian Evidence Act has been inserted by the Dowry Prohibition Amendment Act 1986? Here correct answer is option C, that is section 113B. Question number 743. Which one of the following is not the prerequisite of presumption as to dowry death under section 113B of the Indian Evidence Act? Here correct answer is option B, that is victim had illicit relationship with other male person is not the prerequisite for presumption of dowry death, whereas victim was subjected to cruelty or harassment by her husband or other relatives is a prerequisite. Such cruelty or harassment was a connection with any demand of dowry is prerequisite, and it was done within the 7 years of marriage is also a prerequisite under the presumptions related to dowry death under section 113B of Indian Evidence Act. Question number 744. An accused charged under section 302 and 304B of IPC is acquitted of the offence under section 302 of IPC. The presumption under section 113B of the Evidence Act is automatically refuted, not refuted, not relevant, irrelevant, and otiose. Here correct answer is option B, not refuted. Question number 745. Which is not a precondition to raise an obligatory presumption under section 113B of the Evidence Act? Here correct answer is option A only. The accused is being tried for the offence under section 4 of the Dowry Prohibition Act. Question number 746. Which of the following is not correctly matched? Option A, presumption as to documents 30 years old, section 90. Burden of proving that person is alive who has not been heard for 7 years, section 108. Dumb witness, section 119. Presumption as to dowry death is section 130B. Question number 747. Section 114 of the Evidence Act provide for certain presumption of fact, irrefutable presumption of law, irrefutable presumption of law, none of the above. Here correct answer is option A, presumption of fact. Section 114 of the Evidence Act provide for the certain presumption of fact. Question number 748. In which of the following cases the court may presume under section 114 that a man in possession of stolen goods after the theft is either the theft has received the goods knowing to them to be stolen, that judicial and official acts have been regularly performed, that evidence which could be and is not produced would, if produced, be unfavorable to the person withholding. Example, the police withholding price of the evidence, all of the above. Here correct answer is option D, that is all of the above. Question number 749. Section 114 of the Indian Evidence Act provides for which of the following? Here correct answer is option C. The court may presume existence of certain facts. Question number 750. The court may presume that an accomplice is unworthy of credit unless he is corroborated in material particulars. This is presumption contained in dash of the Indian Evidence Act. Correct answer is option B, that is section 114B. Question number 751. Section 114 illustration G of the Indian Evidence Act 1872 refers to the presumption as to option A, common course of business, B, arising from withholding evidence, C, regarding bill of exchange, and D, continuity of things. Here correct answer is option B, that is arising from withholding evidence. Question number 752. Under section 114 of the Evidence Act, court may presume the existence of any fact which it thinks likely to have happened regard being had to the common course of. Here correct answer is option D, that is natural events, human conduct, public and private business. All of the above are correct here. Question number 753. Which illustration of section 114 of the Indian Evidence Act is based upon the maxim omnia praeseminer rait et solemnister esse acta? Here correct answer is option C, that is illustration E. Question number 754. The court may presume that when a document creating an obligation is in the hands of the obligator, the obligation has been discharged. B. Judicial and official acts have not been regularly performed. C. A bill of exchange accepted or endorsed was accepted or endorsed for deficient consideration. And D. All these are incorrect. Here correct answer is option A. The court may presume that when a document creating an obligation is in the hands of obligator, the obligation has been discharged. Question number 755. In which of the following cases the court may presume under section 114 of the Evidence Act that a man who is in possession of stolen goods soon after the theft is either the thief or has received the goods knowing them to be stolen? B. That an accomplice is unworthy of credit unless he is corroborated in material particulars. C. That judicial and official acts have been regularly performed. All of these. Here correct answer is option D, that is all of these. Question number 756. Which of the following facts the court shall presume to exist? Option A. When a woman states in her evidence before the court that she did not consent for sex. Option A. Option B. The child will never lie. Option C. A priest will always speak truth. All of these. Here correct answer is option A. When a woman states in her evidence before the court that she did not consent for sex, this will be the court shall presume to exist. Question number 757. A person is seen with the same banknotes immediately after a theft in the bank. The presumption is he has stolen the money, he has received the stolen money with required knowledge, either A or B, none of the above. Here correct answer is option C. Either he has stolen money or he has received the stolen money with required information. Question number 758. Presumption as to absence of consent in certain presumptions of rape cases is raised by. Correct answer is option D, that is section 114A of the Indian Evidence Act. Question number 759. The presumption under section 114A of the Indian Evidence Act is an rebuttable presumption, a presumption of fact, mixed presumption of law and fact, irrebuttable presumption of law. Here correct answer is option A, rebuttable presumption. Presumption under section 114A of the Indian Evidence Act is rebuttable presumption. Question number 760. Which of the following section was not inserted in the Indian Evidence Act 1872 by the Information Technology Act 2002? Here correct answer is option B, section 114A. Other section 81A, section 73A and section 47A was inserted by the amendment in 2000 Information Technology Act 2002. Question number 761. In a prosecution for rape, where sexual intercourse by the accused is proved and a woman states in her evidence before the court that she did not consent, here correct answer is option D. The court shall presume that she did not consent. Question number 762. By which amendment section 114A was inserted in the Indian Evidence Act? Here correct answer is option D, that is none of the above. Question number 763. Section 114A of the Indian Evidence Act is related to presumption as to abetment of suicide by a married woman, presumption as to abetment of suicide by a woman. C. Presumption as to absence of consent in certain prosecution for rape. Here correct answer is option C, presumption as to the absence of consent in certain prosecution for rape. Section 114A of the Indian Evidence Act is related. Question number 764. What is presumption as to absence of consent in cases of rape under section 114A of the Indian Evidence Act? Option A, none of these. Option B, a conclusive proof. Option C, the court may presume. And option D, the court shall presume. Here correct answer is option D, the court shall presume. Question number 765. In a case where doctor commits a rape on a woman of 30 years of age under his treatment and a woman says that she did not consent, the court will need proof, shall presume that she did not consent, may need corroboration, may presume or may not presume her consent. Here correct answer is option B, that shall presume that she did not consent. Question number 766. Estoppel has been defined under section 115. Here option A is the correct answer. Question number 767. In which section of Indian Evidence Act the provision of estoppel are given? Here correct answer is option A only, section 115 to section 117. Question number 768. Section 115 of the Indian Evidence Act is founded upon the doctrine laid down in which of the following case? Here correct answer is option B, that is Pickard versus Sears. Question number 769. What is estoppel? Correct answer is option A, that is prohibition from proving a certain fact. Question number 770. The doctrine of estoppel means B. Restriction to make statement contrary to the earlier statement or admission. This is the doctrine of estoppel. Question number 771. Section 115 of the Indian Evidence Act deals with estoppel. Question number 772. When one has, by his declaration, act or omission, intentionally caused or permitted another person to believe a thing to be true and to act on such belief, neither he nor his representative shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing. The statement of law is well known in the Indian law of evidence as a principle of. Correct answer here is option C, that is estoppel. Question number 773. In which one of the following under Indian Evidence Act is not a kind of estoppel? Option A, estoppel by will, estoppel by deed, estoppel by conduct, estoppel by record. Here correct answer is option A, that is estoppel by will is not a kind of estoppel. Question number 774. In case of Sharat Chandra De versus Gopal Chandra Laha 1891 is related to which of the following section of the Indian Evidence Act? Correct answer is option B, that is section 115 of the Indian Evidence Act. Question number 775. Which one of the following is not a kind of estoppel? Here options are estoppel by deed, estoppel by conduct, estoppel by record, estoppel by decision. Correct answer is option D. Estoppel by decision is not a kind of estoppel. Question number 776. Which section of the Indian Evidence Act is founded upon the doctrine laid down in Pickard versus Sears? Correct answer is option C, that is section 115. Question number 777. Estoppel can be attestation, recital in deed, standing by, all of these. Correct answer is option D, that is all of these. Question number 778. A judgment given by a competent court can create estoppel by record, estoppel by deed, estoppel by recital, estoppel by matter in pies. Here correct answer is option A, that is estoppel by record. Question number 779. A person cannot deny a statement previously made. Estoppel, waiver, denial, none of these. Here correct answer is option A, that is estoppel. Question number 780. A intentionally and falsely led B to believe that a plot of land belonged to him. On that basis, he induced B to buy and pay for it. Afterwards, the plot of land became the property of A. A brought a suit to set aside the sale in favor of B on the ground that at the time of the sale he had no title. In such suit, A may prove want of title at the time of sale. A cannot allowed to prove the want of his title. It depends upon the value of the property. All of them are incorrect. Here correct answer is option B, that is A cannot be allowed to prove want of his title. Question number 781. The principle which preclude a person from denying some statement previously made by him is known as estoppel. Question number 782. Which one of the following is not a case of estoppel? Here correct answer is option A. Palvinder Kaur versus State of Punjab is not a case of estoppel, whereas Pickard versus Sears is related to estoppel. Shri Krishna versus Kurukshetra University is also related to estoppel, and Sharat Chandra J versus Gopal Chandra Laha is also related to estoppel. Question number 783. What is estoppel? Option A, prohibition from proving certain facts is estoppel. Question number 784. Which of the following does not figure in section 115 while dealing with applying the principle of estoppel? Here correct answer is option A, that is conduct. Whereas other options are act, omission and declaration figure in section 115 while applying the principle of estoppel. Question number 785. Which of the following statement is not correct? Here options are: a rule of law cannot be nullified by restoring to doctrine of estoppel. Assurances held out but not incorporated in an agreement would not attract doctrine of estoppel. Plea of promissory estoppel shall be available even if an officer of the government acts outside the scope of authority. And option D, an estoppel arises as soon as the relationship of landlord and tenant is created and tenant is not permitted to deny the title of his landholder. In question number 785, it has been asked which of the following statement is not correct. Here option C is not correct. Question number 786. Which of the following statement is incorrect in the context of estoppel as dealt in section 115 of the Indian Evidence Act 1872? Here option B, that representation must be in writing, is incorrect, whereas there must be a representation by a person to another is correct. The other person have acted upon such representation being taken it as true is correct. The other person should have suffered some prejudice, detriment or disadvantage by acting upon by or by reason of such representation is correct. Question number 787. Which of the following statement is correct? Option A, section 115 of the Indian Evidence Act applies to contracts by infants. Parda-nasheen ladies are exempted from estoppel. A representation made by an agent is effectual for the purpose of estoppel as if it had been made by his principal. An admission by an advocate, even if it is erroneous in law, is binding on his client. Here in this question it has been asked which of the following statement is correct. Option C, that is, a representation made by an agent is effectual for the purpose of estoppel as if it had been made by his principal, is correct. Question number 788. Estoppel is a rule of evidence used as a defense, rule of equity, all of the above. Correct answer is option A, that is rule of evidence. Question number 789. Estoppel need not to be specifically pleaded, should be specifically pleaded, may be specifically pleaded or may not be specifically pleaded. Both B and C are correct. Here correct answer is option B. Estoppel should not be specifically pleaded. Question number 790. Which one of the following is not an exception to the doctrine of estoppel under Indian Evidence Act 1872? Here correct answer is option C. On the question of fact, it is not an exception to the doctrine of estoppel, whereas when the truth is known to both the parties is an exception. On the question of law is an exception, and against the law is also an exception. Question number 791. Mark the correct statement. The doctrine of estoppel is applied only in civil matters. The doctrine of estoppel is applied only in criminal matters. The doctrine of estoppel is applied in civil and criminal matters. All the above statements are wrong. In question number 791, correct answer is option A. The doctrine of estoppel is applied only in civil matters. Question number 792. Mr. X managed to get admission in MBBS course under a false caste certificate. University took 3 long years in verifying and ultimately cancelled admission of Mr. X. Can estoppel work against the university? Here correct answer is option B. No, as the student has committed fraud himself. Question number 793. Under which section of the Evidence Act a tenant of immovable property is stopped from denying a title of the landlord to that property? Correct answer is option B, that is section 116. Question number 794. A tenant of an immovable property can deny title of the landlord to such immovable property after the tenant vacates the property if the landlord is not the actual owner, if landlord has trespassed into a property and his title is defective, in all cases covered by clause 1 to 3. Here correct answer is option A. After the tenant vacates the property, a tenant of an immovable property can deny title of the landlord to such immovable property after the tenant vacates the property. Question number 795. Under section 116 of the Indian Evidence Act, the tenant is stopped from denying the title of the landlord during the continuance of the tenancy. Option A is the right answer. Question number 796. Section 116 of the Evidence Act is applicable to immovable property. Question number 797. Under which section of the Evidence Act a provision as to who could be a witness may found? Correct answer here is option B, that is section 118. Question number 798. Who may not testify? Option A, an accomplice, child, dumb person, lunatic who is unable to understand the questions and to give rational answer. In this question it has been asked who may not testify. Option D here is the right answer. Lunatic who is unable to understand question and to give rational answer cannot testify. Question number 799. Who amongst the following is not a competent witness? Option A, child, an idiot person, a lunatic person, a dumb person. Here correct answer is option B. An idiot person is not a competent witness. Question number 800. Which provision stipulates that lunatic can be a competent witness? Here correct answer is option B, that is section 118 of the Indian Evidence Act stipulates that lunatic can be a competent witness. Question number 801. Who among the following is a competent witness under section 118 of the Indian Evidence Act? Option A, a person who is unable to understand the questions put to him due to disease. Option B, a child unable to understand questions put to him. C, a lunatic able to understand the questions put to him. And D, a person unable to understand the questions put to him due to extremely old age. Here a competent witness is option C, that is a lunatic able to understand the questions put to him. Question number 802. All persons are competent to testify unless the court considers that they are prevented from understanding the questions put to them because of tender years, extremely old age, mental disease, all of these. Here correct answer is option D, all of these. Question number 803. A person suffering from schizophrenia is not competent to testify, can testify if he cannot communicate verbally, can testify if he can understand the questions and answers them rationally, can testify through his father who understands the questions and can give rational answers on his son's behalf. Here correct answer is option C, can testify if he can understand the question and answers them rationally. Question number 804. Which one of the following is not a competent witness to testify under the Indian Evidence Act? Here correct answer is option D, idiot. Idiot is not a competent witness to testify under the Indian Evidence Act, whereas person capable of understanding the questions put to them, quote, unchaste woman, witness unable to speak are competent witness to testify. Question number 805. A witness who is unable to speak is called dumb witness. Question number 806. Who amongst the following are competent witness? Chance witness, victim of rape, related witness, all of these. Correct answer is option D, that is all of these. Question number 807. Who among the following is a competent to adduce evidence under the Indian Evidence Act? Dumb witness, deaf witness. Select the correct answer by using the codes given below. Here correct answer is option C, both 1 and 2. Question number 808. Dumb witness may give his evidence by writing or by sign in open court. Such evidence shall be deemed to be, here correct answer is option B, that is oral evidence. Question number 809. In which one of the following is not correctly matched? Child witness section 118, dumb witness section 120 is not correctly matched, whereas hostile witness section 154 and expert witness section 45 are correctly matched. Therefore, here answer will be B. Question number 810. Which of the following statement is incorrect regarding dumb witness? A dumb witness may give his evidence by writing in open court. A dumb witness may give his evidence by signs in open court. Evidence given by a dumb witness in writing before the court shall be deemed to be documentary evidence. A dumb witness may give evidence in any manner which can make it intangible. Here correct answer is option C. This is incorrect. Evidence given by a dumb witness in writing before the court shall be deemed to be a documentary evidence is incorrect. It will deem to be an oral evidence. Question number 811. Which section of the Evidence Act removes the bar doctrine that husband and wife were one person in law? Here correct answer is option C, section 120. Question number 812. What is the evidentiary value of evidence given by husband against wife and vice versa under the Indian Evidence Act? Here correct answer is option D. Evidence can be adduced by both in civil and criminal proceedings. Question number 813. A document containing a communication from a husband to his wife in the hands of a third person is. Options are not admissible in evidence until consented to by the writer of the communication. B, not admissible at all. C, admissible in evidence. D, none of the above. Here correct answer is C, admissible in evidence. Question number 814. Husband and wife are competent witness against each other in civil and criminal cases, only in civil cases, only in criminal cases, only under investigation. Correct answer here is option A, that is in civil and criminal cases. Question number 815. Husband or wife are permitted to disclose any communication between them during marriage. In civil proceedings between the parties, in criminal proceedings between the parties, in matrimonial proceedings between the parties. Here option D is the correct answer, that is all of the above. Question number 816. Which of the following is true and correct? Option A. In all civil proceedings, the parties to the suit and the husband or wife for any party to the suit shall be a competent witness. Option B. In criminal proceedings against any person, the husband or wife of such person respectively shall be a competent witness. C, both A and B. Here option C is the correct answer. Question number 817. As per section 120 of the Evidence Act, which of the following has been stipulated that wife of a party is not a competent witness in the civil proceedings, husband of a party is not a competent witness in civil proceedings, wife of an accused is not a competent witness in criminal proceedings, none of the above. Here correct answer is option D, that is none of the above. Question number 818. A spouse will be permitted to disclose the communication made during the marriage. Here correct answer is Option D, that is with the consent of the person who made it, in suits between the spouses, in prosecution between the spouses. Here all the answers are correct. Question number 819. A and B were married. During marriage, A committed forgery and communicated it to B, his wife. After some time, divorce took place between A and B married C. In a charge against this, forgery prosecution wants to produce A as a witness against C. Can they do? Option A, they can do as B is now married to C. Option B, they can do as forgery is an offense against public policy. They cannot do as B is bound not to be witness against A under privileged communications. D, they cannot do so as B has now nothing in common with A and is a third party. Here in question number 819, correct answer is option C. That is, they cannot do as B is bound not to be witness against A is A under privileged communication. Question number 820. In criminal proceedings against any person, the husband or wife of such person shall be competent witness, incompetent witness, competent witness only if they are major with the consent of other, competent witness only if they are sane and with the consent of the others. Here correct answer is option A, that is competent witness. Question number 821. Assertion. B writes to his wife C a letter which contains defamatory matters about D. C cannot be compelled to disclose this communication. Reason. Any communication made during subsistence of marriage by a husband to his wife or vice versa is protected as privileged communication. Here correct answer is option A, that is both A and R correct, and R is the correct explanation of A. Question number 822. Which section of the Indian Evidence Act protects communication during marriage? Here correct answer is option B, that is section 122. Question number 823. Under section 122 of the Evidence Act, privilege is available to professionals, magistrate, wife and husband, judges. Here correct answer is option C, that is wife and husband. Question number 824. A communication made to the spouse during marriage under section 122 of the Evidence Act remains privileged communication after the dissolution of marriage by divorce or death, does not remain privileged after the dissolution of marriage by divorce or death, does not remain privileged after the dissolution of marriage by divorce but remains privileged even after death, remains privileged after the dissolution of marriage by divorce but not so on after death. Here correct answer is option A. A communication made to the spouse during the marriage under section 122 of the Evidence Act remains privileged communication after the dissolution of marriage by divorce or death. Question number 825. Under which section of Evidence Act a judge cannot be compelled to answer any question as to his own conduct in court as such judge? Here correct answer is option C, that is under section 121 of Indian Evidence Act. Question number 826. Section 121 of the Indian Evidence Act provides for privileges in respect of which of the following? Correct answer is option B, that is judges and magistrate. Question number 827. Privilege under section 121 of the Evidence Act is not available to an arbitrator, may or may not be available to an arbitrator, available to an arbitrator, none of the above. Here correct answer is option A, not available to an arbitrator. Question number 828. During the course of a trial of a rape case, a person present in the court causes a knife to another person before the court. The judge before whom the incident took place may not be called an evidence, may be called an evidence under the special order of High Court, may be examined as a witness. Here option C is the right answer. Question number 829. A magistrate can be compelled to answer question on his own conduct as a magistrate in court. Here correct answer is option D, by an order of court to which he is subordinate. Question number 830. The privilege to withhold the documents information under the administrative law is enacted in which of the following sections of the Evidence Act? Correct answer is option C, that is section 123 of the Evidence Act. Question number 831. Which one of the following section of the Indian Evidence Act deals with the evidence as to affairs of state? Correct answer is option A, that is section 123 of the Evidence Act. Question number 832. Which section of the Indian Evidence Act is based on the maxim solus populi est suprema lex? Correct answer is option A, that is section 123 of the Evidence Act. Question number 833. Documents in respect of which privilege has been provided under section 123 of the Indian Evidence Act as a published official record is an unpublished official record, both A and B, none of the above. Here correct answer is option B, that is an unpublished official record. Question number 834. Which of the following provision of the Indian Evidence Act deals with privileged communication about unpublished official records relating to the affairs of state? Here correct answer is option B, that is section 123. Question number 835. Under which section of the Indian Evidence Act a public servant shall not be compelled to disclose the communication made to him in official confidence? Correct answer is option B, that is section 124 of Indian Evidence Act. Question number 836. Can a police officer be compelled to disclose the source of information relating to commission of an offence? Here correct answer is option C, that is no. Police officer cannot be compelled to disclose source of information relating to commission of offence. Question number 837. For protection under section 124 of the Evidence Act, communication is to be made to a public officer in official confidence, to a public officer as an ordinary cause of his duties, to a police officer as a routine manner, either A, B or C. Here correct answer is option A, that is to a public officer in official confidence. Question number 838. No revenue officer shall be compelled to say whence he got any information as to the commission of any offence against the public revenue. This provision is contained in. Here correct answer is option A, section 125 of the Evidence Act. Question number 839. Which one of the following sections of the Indian Evidence Act applies to the pleaders relating to professional communication? Correct answer here is option C, section 126 and 127. Question number 840. Communication by a client to an advocate is not permitted to be disclosed under section dash of the Indian Evidence Act. Here's correct answer is option A, that is under section 126 of the Indian Evidence Act. Question number 841. Which of the following statement is correct? Here, the protection of professional communication as provided under Indian Evidence Act in section 126 to 129 is available only for engaging an advocate to plead his case, for disclosing communication to advocate or his colleagues before communication of the offence of illegal acts, after commission of the crime or illegal acts. Here correct answer option D, after commission of the crime or illegal acts. Question number 842. Which one of the following sections of the Indian Evidence Act applies to the pleaders relating to professional communication? Here correct answer is option D, that is section 126 and 127. Question number 843. Professional communication between advocate and his client is not admissible in evidence, is a privileged communication only until the contract continues, is admissible in evidence with the consent of the client, is not admissible until it is legal. Here correct answer is option C, is admissible in evidence with the consent of the client. Question number 844. A client says to B, an advocate, I have committed forgery and I wish you to defend me. His communication is protected from disclosure under section 126 of the Evidence Act. Question number 845. Deepak, accused of committing offence supplying arms, informs his lawyer Shweta that he has committed the offence and wishes her to defend him in the circumstances. Here correct answer is option C. The communication is privileged one and protected from disclosure. Question number 846. A client says to his advocate B, I have committed murder of C. I wish you to defend me. Whether advocate B may disclose the aforesaid communication in the court? Here correct answer is option C, that is no. Question number 847. Which one of the following fact is protected from disclosure in a court of law? Here correct answer is option A. A client to B, an attorney, I have committed the forgery and I wish you to defend me, is protected from disclosure in court of law. Question number 848. A client says to B, an attorney, that he wishes to obtain possession of property by use of a forged deed on which he requests the attorney to sue. The communication is option A, protected from disclosure in view of attorney-client privilege under all circumstances. B, not protected from disclosure as attorney-client privilege does not extend to communication furtherance of a criminal purpose. Here correct answer is option B only. It is not protected from disclosure as attorney-client privilege. Question number 849. The professional communication between an advocate and his client can be disclosed before the court with the consent of the client, without the consent of the client if made in furtherance of an illegal purpose, without the consent of the client if advocate comes to know that any crime or fraud has been committed since the commitment of his employment, all of the above. Here correct answer is option D, that is all of the above. Question number 850. Legal advisor, option A, can disclose a professional communication after the death of his client, can disclose a professional communication after the relationship with the client has ended, can disclose in professional communication is made in furtherance of any illegal purpose, can disclose a professional communication of all instances. Here correct answer is option C, that is can disclose professional communication if made in furtherance of any illegal purpose. Question number 851. For the following, which is an exception to the section 23 of the Evidence Act? Here correct answer is option A, section 126 of the Evidence Act. Question number 852. A client says to B, an advocate, I wish to obtain possession of property by use of a forged deed on which I request you to sue. Here correct answer is option B. This communication is not protected from disclosure. Question number 853. Section 129 of the Evidence Act 1872 states that no one shall be compelled to disclose the court any confidential communication which has taken place between option A, teacher and student, company and its client, legal professional advisor and his client, landlord and tenant. Here correct answer is option C, legal professional communication advisor and his client. Question number 854. Which of the following is not correctly matched? Option A, communication during marriage, section 122 is correctly matched. Evidence as to affairs of state, section 123 correct match. Confidential communication with the legal advisor, section 128 is incorrect. Evidence of an accomplice, section 133 is correct. Here option C is not correctly matched, therefore it is the correct answer. Question number 855. Which of the following is not correctly matched? Matrimonial communication, section 122 correct. Official communication, section 124 correct. Professional communication, section 126 correct. Confidential communication with the legal advisor, section 127 is incorrect. Question number 856. Which of the following pairs is not correctly matched under Indian Evidence Act? Here options are section 45 opinion of expert correct, section 67A proof as to electronic signature correct, section 74 public documents correct, section 124 professional communication is not correctly matched. D will be the correct answer. Question number 857. An accomplice is a competent witness against the accused person. Here option B is the right answer. Question number 858. Section 133 of the Indian Evidence Act is related to a number of witnesses, accomplice, oral evidence, relevancy of fact. Here correct answer in question number 858 is option B, that is accomplice. Question number 859. An accomplice is a competent witness under section 118, under section 119, under section 132, under section 133. Here correct answer is option D, that is under section 133 of the Indian Evidence Act. Accomplice is a competent witness under section 133 of the Indian Evidence Act. Question number 860. Dagdu versus State of Maharashtra is related with option A, that is accomplice is the correct answer. Question number 861. An accomplice is a person who participates in the commission of crime with the charge accused. Here option A is the right answer. Question number 862. Which one of the following is provided under section 133 of the Indian Evidence Act? Here options are acceptance of an evidence, rejection of an evidence, evidence of deaf and dumb, evidence of an accomplice. Here correct answer is option D, evidence of an accomplice. Question number 863. Select the right option based on the following assertion. Reason. Assertion. The evidence of an accomplice requires to be accepted with great degree of caution and scrutiny. He hopes for pardon or has secured it and so favors prosecution. Here option A. Both A and R are individually true and R is the correct explanation of A. B. Both A and R are individually true but R is not the correct explanation of A. In question number 863, correct answer is option B. Both A and R are individually true but R is not the correct explanation of A. Question number 864. Which of the following statement is correct with respect to an accomplice? Here option B is the correct answer. An accomplice shall be a competent witness against an accused person. Question number 865. Accomplice shall be a competent witness against an accused person. An accomplice is unworthy of credit unless he is corroborated with material particulars. Here option B is the correct answer. Both A and R are true but R is not the correct explanation of A. Question number 866. Which of the following statements are not true? Option first. An accomplice is a competent witness against an accused person. Conviction on the testimony of an accomplice is legal. Conviction on the testimony of an accomplice is legal only if it is corroborated. Here correct answer is option C, 3 only. Because in this question it has been asked which of the following is not correct. Option 3 is not correct. That is conviction on the testimony of an accomplice is legal only is if it is corroborated. This is not correct. Other two options are correct. That is an accomplice is a competent witness against an accused person and conviction on the testimony of an accomplice are correct. Question number 867. Which of the following is the correct statement according to law? Here options are an accomplice shall be a competent witness against an accused person. Leading question may be asked in cross-examination of a witness. The court may permit a party who calls a witness to put any question to him which might be put in cross-examination by the adverse party. All of the above. Here correct answer is option D, that is all of the above. Question number 868. Who amongst the following is an accomplice? Correct answer is option A. A prostitute is an accomplice. Question number 869. Who amongst the following is not an accomplice? Option A. A bribe giver, a detective, a prostitute, a person receiving stolen property. Here correct answer is option B. A detective is not an accomplice. Question number 870. Mark the correct statement. An accomplice is unworthy of credit unless he is corroborated in material particulars. An accomplice shall be competent witness against an accused, and conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice. Option C, both A and B, and option D, none of the above is correct. In question number 870, correct answer is option C, both A and B. Question number 871. Who among the following is not an accomplice? Option A, trap witness, a raped girl, an eyewitness to a murder, all of the above. Here correct answer is option D. These all are not an accomplice. Question number 872. Which of the following statement is incorrect about accomplice? Option A. Court may tender pardon to an accomplice under section 306 of CRPC. Court may tender pardon only in those offences which are punishable up to 7 years of imprisonment. It is necessary for the court to record its reason in every case of pardon. The object of pardoning is to obtain evidence from the accused. Here in this question it has been asked which of the following is incorrect. Option B is incorrect, therefore it will be the right answer. Question number 873. Testimony of an accomplice before it is accepted and acted upon. Option A must be corroborated from the testimony of the another accomplice, must be corroborated from an independent source, need not to be corroborated at all, need not to be corroborated but corroboration is required as a rule of guidance. Here correct answer in question number 873 is D, that is need not to be corroborated but corroboration is required as a rule of guidance. Question number 874. An approver's evidence must be reliable, must be corroborated, must be reliable and preferably corroborated is not admissible. Here correct answer is option B, 1 and 3. An approver's evidence must be reliable and preferably corroborated. Question number 875. Proviso to section 132 of the Indian Evidence Act is a facet of rule against self-incrimination. Policy of section 132 of the Indian Evidence Act is to procure evidence for doing justice. Here correct answer is option A, that is both A and R are true and R is the correct explanation of A. Question number 876. When a party refuses to produce a document which he has notice to produce, can he use the document as evidence afterwards? Here correct answer is option D, that is both B and C. He can use it with the consent of the other party. He may use it by order of the court. Question number 877. If question asked to a witness to any matter relevant to a matter in issue and the answer given by the witness to such question will criminate him, then the witness shall be compelled to answer such question. Here option A is the right answer. Question number 878. One of the most important principles of the law of evidence is that evidence is to be weighed and not to be counted. This has been incorporated under which section of the Indian Evidence Act? Section 134 of the Indian Evidence Act. Question number 879. Under Indian Evidence Act, what number of witnesses will be required for the proof of any fact? Correct answer is option A, that is no particular number. Question number 880. Which one among the following is common in the provision of section 123, 126 and 127 of the Indian Evidence Act? Option C, that is they are relevant and inadmissible. Question number 881. Which one of the following is not privileged communication? Matrimonial communication, paternal communication, professional communication, official communication. Here correct answer is option B. Paternal communications are not privileged communication, whereas matrimonial, professional and official communications are privileged communication. Question number 882. Under the Indian Evidence Act, which among the following does not come under the category of the privileged communication? Here correct answer is option B. Communication made by a witness who is unable to communicate verbally. Question number 883. Which section of the Evidence Act provides that judge will decide as to the admissibility of evidence? Correct answer here is option C, that is section 136. Question number 884. Admissibility of evidence is to be decided by the parties to a trial, the judge, the public prosecutor, the advocates of the parties. Here correct answer is option B, the judge. Admissibility of evidence is to be decided by the judge. Question number 885. In which section of the Indian Evidence Act examination in chief, cross-examination and re-examination have been benefited? Here correct answer is option D, that is section 137. Question number 886. Under which section of the Indian Evidence Act provisions relating to examination in chief is provided? Correct answer here is option B, that is section 137. Question number 887. Examination in chief means? Option B, the examination of a witness by the party who calls him. Question number 888. Cross-examination under section 137 of the Evidence Act means which one of the following? Here correct answer is option B, that is examination of a witness by the adverse party. Question number 889. Cross-examination of a witness. Option A, must relate to the relevant fact and has to be confined to what the witness testified in examination chief. Must relate to the relevant facts but need not to be confined to what the witness testified in examination in chief. Option C, may relate to the relevant facts but must relate to what witness testified in examination chief. D, may not relate to relevant fact and may not be confined to what witness testified in examination in chief. Here correct answer is option B. Cross-examination of a witness must relate to the facts but need not be confined to what the witness testified in examination in chief. Question number 890. Cross-examination of one's own witness is permissible. Permissible only after obtaining the permission of the court, not permissible with the consent of the opposite party. Here correct answer is option B. Permissible only after obtaining the permission of the court. Question number 891. Which of the following question is not lawful in cross-examination? Options are a question to test the veracity of the witness, a question to discover that position in life of witness is, a question the answer of which amounts to hearsay, a question to injure the character of the witness. Here in this question it has been asked which of the following question is not lawful in cross-examination. The correct answer is option C. A question the answer of which amounts to hearsay is not lawful in cross-examination. Question number 892. The object of cross-examination is to examine the credibility of a witness. Here option C is the right answer. Question number 893. Party calling a person as a witness can cross-examine him as of right with the permission of the court with the consent of witnesses, not in any circumstances. Correct answer is option B, that is with the permission of the court. Question number 894. In which of the following judgments delivered by the Supreme Court in 2015 it was held that it is imperative that if examination in chief is over, the cross-examination should be completed the same day? Correct answer here is option A, that is Vinod Kumar versus State of Punjab. Question number 895. What are the questions which are lawful in cross-examination? To test his veracity, to discover who he is, to take his credit by injuring the character, all of the above. Here correct answer is option D, that is all of the above. Question number 896. What is re-examination of a witness? Option A, recalling the witness, repeated examination of the witness, cross-examination of one's own witness, none of the above. Here correct answer is option D, that is none of the above. Question number 897. The examination after cross-examination of a witness by the party who has called him is called? Correct answer option A, main examination, additional cross-examination, re-examination, re-cross-examination. Correct answer here is option C, that is re-examination. The examination after cross-examination of a witness by the party who has called him is called re-examination. Question number 898. During re-examination of a witness, a new matter can be introduced as a matter of right generally. A new matter can be introduced only with the permission of the court. No new matter can be introduced at all, either A or C. Here correct answer is option B. A new matter can be introduced only with the permission of the court. Question number 899. After re-examination of witness, the adverse party has right to further cross-examine the witness only when new fact is introduced in the re-examination. Question number 900. To an answer to a court, the adverse party has a right to cross-examine only with the permission of the court. Here B is the right answer. Question number 901. When shall the witness be re-examined? Option A, at the desire of the adverse party, at the desire of the party calling him, at the desire of the magistrate, at the desire of the police officer. Here correct answer is option B, that is at the desire of the party calling him. Question number 902. Re-examination of a witness can be for the purpose of filling what is left over in examination in chief. Option B, can be for the purpose of explaining the matters referred to in cross-examination, can be for the purpose of explaining the matters referred to in the examination in chief, and option D, all of the above. Here correct answer is option B, that is can be for the purpose of explaining the matters referred to in cross-examination. Question number 903. A party who calls a witness can put any question to him which might be put in cross-examination by the adverse party. Option B, can put any question to him which be put in cross-examination by the opposite party only with the permission of the court. cannot put any question to him which might be put in cross-examination by the opposite party even with the permission of the court, can in no case put a question to his own witness which might be put in cross-examination of the adverse party. Here in question number 903, correct answer is option B. A party who calls a witness can put any questions to him which might be put in cross-examination by the opposite party only with the permission of the court. Question number 904, which of the following is true? Here options are: there cannot be further cross-examination after re-examination, there cannot be further cross-examination after re-examination as per section 137, there can be further cross-examination after re-examination as per section 138, there can be further cross-examination after re-examination as per section 139. Here correct answer is option C. There can be further cross-examination after re-examination as per section 138. Question number 905. According to section 138 of the Indian Evidence Act, what shall be the order of examination? No any prescribed order: examination in chief, cross-examination, re-examination, cross-examination, re-examination, examination in chief, re-examination, cross-examination. Here correct answer is option B, that is examination in chief, cross-examination and re-examination. Option B here is the right answer. Question number 906. A person summoned to produce a document, when produces the document, then he becomes a witness, he cross-examined by both the parties, he is cross-examined with the permission of the court, he does not become a witness and cannot be cross-examined unless and until he is called as a witness. Here correct answer is option D. A person summoned to produce a document, when produces the document, he does not become witness and cannot be cross-examined unless and until he is called as a witness. Question number 907. Which of the following is true and correct? Option A. A person summoned to produce document does not become a witness by mere the fact that he produces is. A person cannot be cross-examined unless and until he is called as a witness. Both A and B, none of the above. Here correct answer is option C, that is both A and B. Question number 908. What is not true? Options are: witness may be cross-examined as to the previous statement in writing, leading questions may be asked in cross-examination, persons called to produce document can be cross-examined. This is not true, so option C is the right answer. Question number 909. Which of the following sections of the Indian Evidence Act provisions regarding cross-examination of a witness to character? Correct answer is option A, that is section 140. Question number 910. What is the correct order of examination of witness? Here options are: cross-examination, examination in chief, re-examination. Option B, examination in chief, re-examination, cross-examination. C, examination in chief, cross-examination, re-examination. Here the correct order of the examination of a witness is asked, so option C here is the right answer. Examination in chief, cross-examination and re-examination is the correct order of examination of a witness. Question number 911. Which statement is incorrect? Option A, in cross-examination a witness may be asked questions which tend to discover what is his position in life. Option B, in cross-examination a witness may be asked questions which tend to test his veracity. Witness to character shall not be re-examined. In cross-examination a witness may be asked questions which tend to discover who he is. Correct answer here is option C. Witness to character shall not be re-examined is incorrect. Question number 912. Which one of the following is the correct statement relating to cross-examination? Witness to character may be cross-examined. Leading questions cannot be asked in cross-examination. A person summoned to produce a document can be re-examined. A person summoned to produce a document can be cross-examined. Option D, a witness may not be cross-examined as to previous statement made by him in writing. In question number 912, correct answer is option A, that is witness to character may be cross-examined. Question number 914. What do you understand by the term leading question? Option A, question suggesting the answer which person putting it wishes to expects to receive. A question asked to contradict the witness's previous writing. A question asked with reasonable ground. A question asked with a view to check the veracity of a witness. Here correct answer is option A. Leading question is related to question suggesting the answer which person putting it wishes or expects to receive. Question number 915. Any question suggesting the answer which the person putting it wishes or expect to receive is called. Here correct answer is option D, that is leading question. Leading question can be asked during examination in chief, cross-examination, re-examination, all of the above. Correct answer here is option B, that is cross-examination. Leading questions can be asked during cross-examination. Question number 917. Which of the following statement is correct? Leading questions may be freely asked in examination in chief of a witness. Leading question may be freely asked in cross-examination. Leading question may be freely asked in re-examination. Leading questions may not be put to a witness of tender ears. Here correct answer is option B. Leading questions may be freely asked in cross-examination. Question number 918. Leading question may be asked in examination in chief. Here correct answer is option A and B, that is with permission of the court as to matters which are introductory if in the opinion of the court matter involved has been already sufficiently proved. Here option D is the correct answer. Question number 919. During examination in chief or re-examination, leading questions cannot be asked under any circumstances. Leading questions on certain matters can be asked without the permission of the court as a matter of right. Leading questions on a certain matter can be asked only with the permission of the court, and option D only A and not B or C. In question number 919, correct answer is option C. Leading question on certain matter can be asked only with the permission of the court. Question number 920. Who can prosecution be allowed to ask leading question to its own witness? In examination chief, in re-examination, when the witness is declared hostile in all circumstances. Correct answer here is option C. When the witness is declared hostile. When can prosecution be allowed to ask leading question to its own witness? When the witness is declared hostile. Question number 921. Under which of the following conditions leading question may be asked during examination in chief with the permission of the court? Option A, in the matters which are disputed or not introductory, when matters in question is sufficiently proved under both the above conditions, under none of the above conditions. Here correct answer is option B, when the matter in question is sufficiently proved. Question number 922. Which one of the following is not correctly matched? Opinion of experts, section 45 of the Evidence Act is correctly matched. Secondary evidence, section 62 of the Evidence Act is not correctly matched. Leading question, section 141 of the Evidence Act is correctly matched, and number of witnesses, section 134 of Evidence Act is correctly matched. So here incorrect question is asked, so option B is the correct answer. Question number 923. Documents which are meant for cross-examination of a witness of the other party or meant for refreshing of memory of a witness may be produced at any time when they are required. Option C is the right answer. Question number 924. Under section 145 of the Indian Evidence Act, a witness may be contradicted as to his previous statement in writing without drawing his attention to the previous writing, after drawing his attention to the previous writing, without drawing or after drawing his attention to the previous writing, none of the above. Here correct answer is option B, after drawing his attention to the previous writing. Under section 145 of the Indian Evidence Act, a witness may be contradicted as to his previous statement in writing after drawing his attention to the previous writing. Question number 925. Under section 145 of the Evidence Act, a witness may be cross-examined as to previous statement in writing. Here correct answer is option A, that is without proving the same and without showing the same to the witness. Question number 926. Which one of the following sections of the Indian Evidence Act provides questions lawful in cross-examination to be asked? Here correct answer is option A, that is section 146. Question number 927. Under section 146 of the Evidence Act, a witness could be asked questions during the cross-examination. Here correct answer is to test his veracity is correct, to discover who he is and what his position in life is correct, to shake his credit by injuring his character, and all of these. Here correct answer is option D, that is all of these. Under section 146 of the Evidence Act, a witness could be asked questions during cross-examination. Option D here is the right answer. Question number 928. In prosecution for an offence under section 376 of IPC, where the question of consent is an issue, it shall not be permissible to adduce evidence or to put questions in the cross-examination of the victim as to the general immoral character or previous sexual experience of such victim with any person for proving such consent or the quality of consent is provided in which section of the Indian Evidence Act. Here correct answer is option B, that is section 146. Question number 929. Which of the following section of the Indian Evidence Act has been amended by the Criminal Law Amendment Act 2018? Correct answer is option A, that is section 146. Question number 930. The previous sexual experiences of a prosecutrix in a case of rape where the questions of consent is an issue. Option B is it is irrelevant. Question number 931. Which one of the following provisions of the Indian Evidence Act 1872 has been amended by the Criminal Law Amendment Act 2013? Correct answer is option B, that is section 146 of the Indian Evidence Act. Question number 932. Under proviso of section 146 clause 3 of the Evidence Act, in a prosecution for rape, in cross-examination, the prosecutrix, option B, cannot be put questions as to her general immoral character. Here C is the correct answer. Question number 933. For deciding whether or not a witness shall be compelled to answer questions, the court shall have regard to the considerations which include as to whether such questions are: Option A, proper if the truth of imputation conveyed thereby would seriously affect the opinion of the court as to the credibility of the witness on the subject matter of his deposition. Option B, improper if the truth of imputation conveyed thereby would affect in a slight degree of the opinion of the court as to the credibility of the witness on the subject of his disposition. Both A and B. Here correct answer is option C, that is both A and B. Question number 934. The judge's power to put question or order production of documents does not include authorization to. Option A, compel witness to answer any question which such witness is entitled to refuse to answer if the question were asked by the adverse party, to ask a question which would be proper for any other person to ask, to elicit clarity on a point, none of these. Here correct answer is option A, that is to compel a witness to answer any question which such witness is entitled to refuse to answer if the questions were asked by the adverse party. Question number 935. Under Indian Evidence Act 1872, questions relating to a matter not relevant to the suit or proceedings may be asked for. Here correct answer is option C, that is section 148 of the Indian Evidence Act. Question number 936. A barrister is instructed by an attorney or a vakil that an important witness is a dacoit. There is a reasonable ground for asking the witness whether he is a dacoit. This illustration is based on which of the following sections of the Indian Evidence Act? Here correct answer is option A, that is section 149 of the Indian Evidence Act. Question number 937. In which of the following circumstances are there no reasonable grounds for putting questions to the witness? Option A, a barrister told by a solicitor that an important witness is dacoit. The barrister asks the questions, are you a dacoit? Option B, an advocate is informed by a person in the court that an important witness is a dacoit. The informant, on being questioned by the advocate, gives satisfactory reasons for his statement. The advocate asks this question, are you a dacoit? The witness by whom nothing whatever is known is asked for random whether he is a dacoit. Witness of whom nothing whatever is known, on being questioned as to the mode of life and means of living, gives unsatisfactory answer. The witness is asked, are you a dacoit? In question number 937, correct answer is option C. A witness whom nothing whatever is known is asked at random whether he is a dacoit. Question number 938. Indecent and scandalous questions may be forbidden by the court under section 151 of the Indian Evidence Act. Question number 939. Which of the following questions shall not be asked in examining a witness? Only that which is intended to insult, only that which is intended to annoy, only that which appears to the court needlessly offensive. Here option D is the correct answer, that is all of these. Question number 940. Questions intended to insult or annoy may be asked to a witness during. Here correct answer is option D, that is none of these. Question number 941. Under Indian Evidence Act 1872, the court may permit such question which regards indecent or scandalous if they relate to facts in issue. Option A here is the right answer. Question number 942. A witness is asked whether he was not dismissed from a past for dishonesty. He denies it. Evidence is offered to show that he was dismissed for dishonesty. Here correct answer is option C. The evidence is not admissible. Question number 943. The provision relating to hostile witness is provided in section 154 of the Evidence Act. Option A is the right answer. Question number 944. Which section of the Indian Evidence Act was amended by the Criminal Law Amendment Act 2005? Correct answer here is option D, that is section 154. Question number 945. Hostile witness is dealt in Indian Evidence Act under. Here correct answer is option A, that is section 154. Question number 946. Under Indian Evidence Act 1872, the statement of hostile witness is irrelevant, can be acted upon, cannot be acted upon, has no evidentiary value. Here correct answer is option B, can be acted upon. Question number 947. Under Indian Evidence Act 1872, evidence of hostile witness cannot be taken into consideration for any purpose. It cannot be relied on by the prosecution. It can be relied only by the defense. It can be relied on by the prosecution as well as the defense. Here correct answer is option D. It can be relied on by the prosecution as well as the defense. Question number 948. A party can ask question to his own witness under which section of the Indian Evidence Act 1872? Here correct answer is option B, that is section 154 of Indian Evidence Act. Question number 949. During examination in chief of a case under section 325 of IPC, the victim denies the prosecuting case. Under what provision of Indian Evidence Act the victim may be asked leading questions by the public prosecutor? Here correct answer is option C, that is section 154 of Indian Evidence Act. Question number 950. With respect to section 154 of the Indian Evidence Act 1872, choose a true statement about the propositions. Propositions are: section 154 of the Evidence Act confirms a discretion on the court to permit a witness to be cross-examined by a party calling him. Second, the court will not normally allow a party to cross-examine his own witness and declare the same hostile unless the court is satisfied that the statement of the witness exhibits an element of hostility. Third, mere declaratory that a witness is hostile, his all statements shall be excluded from being considered. Assertions. Here assertions are first and second are correct, third is incorrect, second and third are correct, first is incorrect. C, first and third are correct and second is incorrect, all are correct. In question number 950, correct answer is option A, that is first and second are correct and third is incorrect. Third one, that is mere declaration that a witness is hostile, his all statements shall be excluded from being considered, is incorrect. Whereas section 154 of the Evidence Act confers a discretion on the court permit a witness to be cross-examined by party calling him, is correct. The court will not normally allow party to cross-examine his own witness and declare the same hostile unless the court is satisfied that the statement of the witness exhibits an element of hostility. This is also correct. So statement first and second are correct and third is incorrect. Option A here is the right answer. Question number 951. Testimony of hostile witness is to be rejected outrightly, partially rejected, partially accepted, considered with caution and be corroborated. Here correct answer is option D, considered with caution and be corroborated. Question number 952. Hostile witness means an unfavorable witness, a witness who is desirous of telling the truth, a witness who is not desirous of telling the truth, an overpowered witness. Here correct answer is option A, an unfavorable witness. Question number 953. By which of the following ways Indian Evidence Act 1872 the credit of a witness may be impeached by adverse party? Options are by the evidence of persons who testify that they from their knowledge of the witness believe him to be unworthy of credit. Option B, by proof that the witness has been bribed or has been accepted the offer of bribe. C, by proof of the former statement is inconsistent with any part of his evidence which is liable to be contradicted, and evidence D, all of the above. Here correct answer is option D, that is all of the above statements are correct. Question number 954. Which of the following provisions of the Indian Evidence Act was omitted by the Amendment Act of 2002? Correct answer is option C, that is section 155 clause 4 of the Indian Evidence Act. Question number 955. Which option is available to a commissioner when a party seeks permission to cross-examine his own witness? Option A, he can permit the party to do so. He cannot permit the party to do so. He may ask the party to first obtain permission from court under section 154 of the Evidence Act. Option D, he can permit the party to do so with the consent of the opposite party. Here correct answer is option C. He may ask the party to first obtain permission from the court under section 154 of the Indian Evidence Act. Question number 956. Former statement of a witness may be proved to corroborate later testimony as to the same fact as provided under section dash of the Indian Evidence Act. Correct answer is option A, that is section 157 of the Indian Evidence Act. Question number 957. A statement recorded by investigation officer under section 161 CRPC can be used for contradiction, for corroboration, to refresh the memory of a witness. None of these. Here correct answer is option A, that is for contradiction. Question number 958. Statement of an injured person is recorded as dying declaration. However, he survives. His statement is admissible under which section of the Evidence Act? Correct answer is option D, that is section 157 of the Indian Evidence Act. Question number 959. Which one of the following statement is correct? A dying declaration made under section 32 of the Indian Evidence Act 1872 is subject to the control of section 164 of the Code of Criminal Procedure, section 161 and 162 of the Code of Criminal Procedure, section 52 and 54 of the Indian Evidence Act, section 158 of the Indian Evidence Act. Here correct answer is option D, that is section 158 of the Indian Evidence Act. Question number 960. Under which section the facts proved under section 32 and 33 can be contradicted as per the Evidence Act? Here correct answer is option C, that is section 158 of the Evidence Act. Question number 961. Under which provision a witness can refresh his memory? Here correct answer is option B. Under section 159 of the Indian Evidence Act, witness can refresh his memory. Question number 962. Under section 159 of the Evidence Act provides for. Here correct answer is option C, that is witness can refresh his memory. Question number 963. Which of the following sections of the Indian Evidence Act has been amended by the Criminal Law Amendment Act 2018? Select the correct answer with the help of the code given below. Section 53A, section 119, section 146. Here correct answer is option C, that is only 1 and 3 are correct, that is section 53A and section 146. Question number 964. The examination of a witness by the party who calls him. Here correct answer is examination in chief. Witness who lets down the party who calls him. Here correct answer is option B, that is hostile witness. Examination of a witness by the adverse party. Here correct answer is cross examination. Examination of a witness by the adverse party, that is cross examination. Question suggesting the answer which the person putting it wishes or expects to receive. Here correct answer is leading question. Question suggesting the answer which the person putting it wishes or expects to receive is leading question. So by going through these options, correct match here will be option B. Question number 965. Indecent and scandalous question. Here correct match is section 151. Impeaching the credit of witness. Correct match is section 155. Question intent to insult or annoy. Here correct match is section 152. And the last question by party to his own witness is section 154. Indecent and scandalous question, section 151. Impeaching credit of witness, correct answer is section 155. Questions intended to insult or annoy, section 152. Question by party to his own witness, section 154. Question number 966. Match the following and tick the correct code. List first and list second. Section 60, oral evidence is the correct answer. Section 141, leading question. Section 154, hostile witness. And section 159, refreshing memory. Here by going through these match, the correct option is option A. Question number 967, match list first and list second. Refresh the memories, correct answer is section 159. Dying declaration, correct answer is section 32 clause 1. Leading question, correct match is section 141. Hostile witness, here correct match is section 154. By going through these matches, the correct answer here will be option A. Question number 968. Which one of the following is not correctly matched? Options are section 113B, presumption as to dowry death, section 137, examination in chief, section 151, indecent and scandalous question, section 154, impeaching credit of witness. Here correct answer is option D. Section 154, impeaching credit of witness is not correctly matched. Question number 969. The following is not the example of best evidence rule. Section 60, section 64, section 91, section 164. Correct answer is option D. Section 164 is not the example of best evidence rule. Question number 970. A judge in India is not empowered to put questions on his own to the witness or to the parties, is empowered to put questions on his own to a witness or to the parties according to his sweet will, is empowered to put questions on his own to the witness or to the parties in order to discover or to obtain proper proof of relevant fact, is not empowered to put questions on his own to a witness. Here in question number 970, correct answer is option C. A judge in India is empowered to put questions on his own to the witnesses or to the parties in order to discover or to obtain proper proof of relevant facts. Question number 971. Court question under section 165 of Evidence Act can be put to, correct answer is any witnesses, any parties. C is the correct answer. Question number 972. Under which section of the Indian Evidence Act a judge is empowered to ask any question relevant or irrelevant to a witness or a party to a suit? Here correct answer is option B, that is section 165. Question number 973. Power of a court to suo motu explain any person or at any stage is under. Here correct answer is option C, that is section 165 of the Evidence Act. Question number 974. Which of the following chapters of the Indian Evidence Act deals with witnesses? Here correct answer is option D, that is chapter 9. Question number 975. Which section of the Evidence Act makes that the provision that there shall be no new trial on the ground of improper admission or rejection of evidence? Here correct answer is option C, that is section 167. Question number 976. Mode of proof of a custom is contained in section 32 clause 4 of the Evidence Act, section 32 clause 7 of the Evidence Act, section 48 of the Evidence Act, all of the above. Here correct answer is option D, that is all of the above. Section 32 clause 4, section 32 clause 7 and section 48 of the Evidence Act, mode of proof of a custom is contained. Question number 977. Section 27 control. Section 24 of evidence, section 25 of the evidence and section 26 of the Evidence Act. Here option D is the correct answer. Question number 978. Facts discovered in consequence of a joint information. Option A are not admissible and cannot be used against any of the accused person. Option B are admissible, can be used against any one of the accused person, are admissible and can be used against all the accused person. Both B and C are correct. Here correct answer is option A, are not admissible and cannot be used against any of the accused person. Question number 979. Declaration in the course of businesses are admissible under section 32 clause 2 of the Evidence Act. Here option B is the right answer. Question number 980. Oral evidence under section 60 of the Evidence Act may be direct only, hearsay, both A and B, either A or B. Correct answer is option A, that is direct only. Section 60 of Evidence Act. Oral evidence under section 60 of Evidence Act is direct only. Question number 981. Maxim omnia prosecutor ret issa acta means. Here correct answer is option A, that all acts are presumed to be rightly done. Question number 982. Principle of omnia prosecutor ret issa acta is contained in. Correct answer is option B, that is section 79 of the Evidence Act. Question number 983. Section 79 of the Evidence Act applies to certified copies issued by the government officer, certified copies issued by the government officer, other documents duly certified to be genuine by the government officer, and option D, all of the above. Here correct answer is option D, that is all of the above. Question number 984. Section 90 of the Evidence Act applies to. Here correct answer is option C, that is both testamentary and non-testamentary document. Section 90 of the Evidence Act applies to both testamentary and non-testamentary documents. Question number 985. Section 88A of the Evidence Act applies for presumption as to electronic message forwarded corresponds with the message as fed in the computer, presumption as to the person by whom message is sent, both A and B, and option D, only B but not A. Here correct answer is option A. Section 88A of the Evidence Act provides for presumption as to the electronic message forwarded corresponds with the message as fed in computer. Question number 986. Section 91 of the Evidence Act prohibits admission of oral evidence to prove the contents of a document where the writing is a fact in issue. Option B is the right answer. Question number 987. Oral evidence of a fact invalidating the document is admissible under proviso 1 of the section 92 of the Evidence Act. Option A here is the right answer. Question number 988. Under proviso 2 of the section 92 of the Evidence Act, oral evidence is admissible where the instrument is silent on the matter sought to be proved and the agreement to be proved is consistent with the terms of the documents. Here option B is the correct answer. Question number 989. Extrinsic evidence to show the meaning or supply the defects in an instrument is prohibited under section 93 in respect of. Here correct answer is option A, that is ambiguous patents. Question number 990. In criminal trials, it is bound to presume the absence of the case of the accused following any general or special exceptions to the proviso to the provision under which the accused is charged. Here option C is the correct answer. Question number 991. In cases a child is born within 280 days of the dissolution of marriage, the mother remaining unmarried, the presumption of legitimacy of child under section 112 of the Evidence Act arises irrespective of whether father is alive or dead on the day the child is born. Question number 992. Estoppel should be specifically pleased. Option A here is the right answer. Question number 993. A person is competent to testify if he understands the questions put to him, if he is able to give rational awareness to those questions, if has both A and B. Here correct answer is option C. Both A and B are the correct answer. Question number 994. Privilege under section 121 of the Evidence Act is available to an arbitrator. Question number 995. Privilege in respect of husband and wife under section 122 of the Evidence Act relates to question which a witness cannot be compelled to answer, question which a witness cannot be permitted to answer, both A and B, only B and not A. In 995 correct answer is option C, that is both A and B. Question number 996. Admissibility of the evidence under section 122 of the Evidence Act has to be adjudged. Option A, in the light of the status on the date when the communication was made. Here option A is the correct answer. Question number 997. Protection under section 122 of the Evidence Act is available to. Correct answer is option B, that is husband and wife as a witness. Question number 998. Protection under section 122 of the Evidence Act is. Correct answer is option B, that is not confined to confidential questions only but extends to communication of whatever nature. Question number 999. Section 124 of the Evidence Act provides for the privilege in respect of official communication. Here option B is the right answer. Question number 1000. After re-examination of a witness, the adverse party has a right to further cross-examination the witness only when a new matter is introduced in the re-examination. Here option C is the right answer. Question number 1001. Under section 145 of the Evidence Act, a witness may be cross-examined as to previous statement in writing. Option A, without proving the same and without showing the same as witnesses. Here option A is the correct answer. 1002. Objection as to admissibility of a document in evidence can be made at first opportunity when the document is rendered in evidence. 1003. A party or person who calls the witnesses can be permitted to cross-examine the witness so called by him as provided under section 154 of the Evidence Act. 1004. The Delhi High Court issued guidelines for the protection of witnesses in. Correct answer is option A, that is 𝐯𝐴𝐿𝐼 case 2003. Question number 1005. Relationship is not a factor to affect the credibility of a witness held by the Supreme Court in. Option A is the right answer, that is S. Darshan Reddy versus State of Andhra Pradesh, AIR 2006, Supreme Court. Question number 1006. In which case Supreme Court held that material evidence and not the number of witnesses has to be taken note to ascertain the truth of the allegations made. Here correct answer is option B, that is Syed Ibrahim versus State of Andhra Pradesh, AIR 2006 is the correct answer. Question number 1007. It is well settled law that the rule of prudence requires that the evidence of an accomplice should ordinarily be corroborated by some other evidence. It was held by the Supreme Court in. Correct answer is option A, that is Francis Stanley versus Intelligent Officer, AIR 2007, Supreme Court. Question number 1008. In which of the following cases Supreme Court held that test identification parade is only an aid to investigation? The practice is not born out of prudence. Correct answer is option A, that is Siddharth Vashisht alias Manu Sharma versus State NCT of Delhi, AIR 2010. Question number 1009. A dying declaration is relevant evidence under section 32 of the Evidence Act, notwithstanding it being hearsay evidence, because if a person is dead and anything said by the person as to the cause of the death is relevant, since the dead person cannot be brought before the court to testify, necessity makes it inevitable to admit the said statement. Question number 1010. The question in cross-examination, option B is the right answer, need not to be confined to the fact testified by the witness on his examination in chief. 1011. Which section of the Indian Evidence Act deals with hostile witness? Here correct answer is option B, that is section 154 of the Indian Evidence Act. Question number 1012. By which of the following ways Indian Evidence Act credit of a witness may be impeached by the adverse party? Here correct answer is option D, that is all of the above. By the evidence of persons who testify that they from their knowledge of the witness believe him to be unworthy of credit, by proof that the witness has been bribed or has accepted the offer of bribe or has received any other corrupt inducement to give his evidence, by proof of the former statement inconsistent with any part of his evidence which is liable to be contradicted. Here all the statements are the correct. Question number 1013. In which of the following cases Supreme Court held that any information or material that is subsequently discovered with the help of voluntarily administered test result can be admitted in accordance with the section 27 of the Indian Evidence Act 1972? Here correct answer is option A, that is Selvi versus State of Karnataka is the right answer.